Court officer, sir. Madam.
Sir, ಹೇಳಿ.
Madam, am I audible?
ಸರ್ ಹೇಳಿ. AG ಸರ್ ಹೇಳಿ. ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
Madam, am I audible?
ಹಾ ಸರ್, ನಿಮ್ದು audible ಇದೆ.
Madam, namdu audible ಇದೆ madam.
Yes sir.
Last. Okay.
Lordships kindly. One forest matter, my lord. My ingress and egress is blocked. From 60 years I have been using the road. 230. Wait, a matter for 230, threat of eviction. Threat of eviction by the administrator after expiry.
One matter at 230, my lord. In the preliminary provisional list, my name appeared. College students, medical college, same.
Education illing barutte.
Since
Justice Anand Sahib. Education alli.
Total 6.
Total 6, I cannot move, my lord.
Oh, disabled. Kodi.
230, my lord, please.
My lord, at 230, election matter. Voting.
My lord, may I make a mention, please? My lord, this is a matter pertaining to the Bangalore bench. Your lordships has disposed of the CRP on 25/10/2025, this month.
CRP.
CRP 19 of 2014. It was a matter.
Copy is not available. Tomorrow it will be made.
My lord, I had the benefit of a stay for the last 11 years. May I request? I filed an application before the Bangalore bench for an IA for a stay for another 6 weeks till my period of
IA?
I have IA for stay of the proceedings till my statutory period of appeal is permissible for another 6 weeks. So I filed the
We'll
IA.
We'll answer the application. No problem. Yes.
May I request on Friday, my lord, because I filed
No,
the
yes,
application.
we'll take it on Friday. No problem.
Grateful.
My lord, may I make a mention, please?
That's the memo.
Yes.
CRP.
Yes, please.
Yes.
My
Grateful.
lord, may I make a mention, please?
Yes.
Your lordship, writ petition 1011 of 21. My colleague will pass on the memo. Your lordship, in this matter, we are challenging the disciplinary proceedings. The petitioner is due for retirement. He's retiring in 3 months, and his promotion is withheld because of this, your lordship. On that account, your lordship, I'll seek that this matter may be heard on Friday.
Oh, let's give it. Yes. Pending matter.
Pending matter.
My lords, petitioner is relieved from the service, my lords. Since
Relieved.
from the, please, my lord, since from 2021, she has not
pending matter.
been paid
Kodi,
with
madam.
the
Give the
salary, my
pending
lords.
matters.
Lords,
Kindly
matter has
day
been
after
disposed
tomorrow,
of.
my lords.
Give it, please. Next
Matter
week.
has been disposed of, ma'am. Matter has been disposed of.
So,
Through oversight, quashing of annexure has not been mentioned.
I will see. Wings
Sixth,
spoken.
my lords.
Lord.
Your lordship, can I mention one matter, your lordship? Your lordship, one date given matter is not listed, your lordship.
Which one? Parola.
Yes, my lords.
Irli baratte bidi.
At 230, my lord, KBTCL matters. Execution petition, yesterday, your lordship.
Yes, call the cases.
Same.
Serial number 150, your lordship, it has become infractious.
Thank
your
you.
lordship.
The learned
With
counsel
liberty,
appearing
your
for the
lordship.
petitioner submits that the petition is rendered infructuous due to efflux of time. The said submission is placed on record. Petition is disposed as having become infructuous.
With liberty, your lordship.
The infructuous admile and liberty, madam. Yes.
Acha.
Serial number 1, KL Patil, VG Bhatt.
This
My
matter.
My lord, serial number 184, V group lordship.
Infructuous ಆಗಿದೆಯಾ?
Yes, sir. And kindly have it 3 weeks time and stay.
Infructuous ಆದ್ಮೇಲೆ 3 weeks time ಬೇಕಾ?
ಇಲ್ಲ ಸರ್, infractious ಆಗಿಲ್ಲ ಸರ್.
ಮತ್ತೆ adjournment ಇಲ್ಲ madam ಬೆಳಗ್ಗೆ. Mention when it is called.
Yes, sir.
Serial number 1. Lordship, sir, please to order for quashing of annexure, yes, as well as 50% of arrears of the back wages. Lordship's YouTube recording is also I have kept in. That has not been reflected in the order operative portion of the order.
Problem ನಿಲ್ಲಿಸ್ಬಿಡ್ಬೇಕಿದ್ನಲ್ಲ. ಹೌದಾ?
ಹೌದು.
Yes. ಏನ್ ಮಾಡಿದ್ದೆ?
This was a case where my lord second show cause notice was defective.
That is the order.
Disciplinary proceedings were quashed.
Hey, last time ಅಲ್ಲಿ ಮಾಡಿದ್ದು.
In the operative.
7 months.
Unauthorized absence 7 months. Defective second show cause notice.
The subject petition was heard and disposed on 21st February 2025. The learned counsel for the petitioner submits that out of inadvertence, the consequential relief that the petitioner was entitled to, which was determined at 50% of the back wages, is omitted in the operative portion of the order. The learned counsel appearing for the respondent would also submit that said consequential relief was indeed granted. Therefore, in the light of the submission being made in unison, the operative portion would now read in this way. The allowed idu number 3 haki.
Annexure yes on quash ಆಗಬೇಕು. Appellate authority.
Petition is allowed. Annexure F and Annexure S stand order of the disciplinary authority and appellate authority stands quashed. The petitioner shall become entitled to 50% of the back
Arrears of the salary.
50% of arrears of the salary. In the light of the order being passed on consensus, the correction be effected to and a fresh certified copy be issued to the petition.
Obliged.
Cell number 2, NK Marutirao, Srinand Pachapure.
Lordship, in this, we're seeking to set aside the annexure at K, Your Lordship, which is passed by Education Tribunal. Education Tribunal, Your Lordship.
Yes.
Which has held that the petitioner was appointed as a attender in the respondent number 1.
Who appears for the respondent? State illa.
Bhaskar L. Patil.
Your Lordship, on the last location also, none of them have appeared on behalf of respondent, Your Lordship.
None of them had come, is it? Gayatri madam.
I'll seek instruction. Sorry. I'll seek instructions.
Your instructions.
Yes, Monday or
Sunnamali yaru
Tuesday.
illa anta relief.
Monday or Tuesday, my lords. My
No, I'll
name may
take
be
it on 18th. By
Yes,
then you secure
please,
instructions, whatever has to be done, you do.
Yes.
The-
My name may be shown in the cause list. Yes.
The learned counsel, Gayatri SR, is directed to accept notice in place of Bhaskar L. Patil. The learned counsel seeks 10 days time to secure instructions and make submissions. List the matter on 18th in the fresh matters list.
Please.
Please, my lords.
8 ವರ್ಷ ಆಗಿದೆ ಅದಕ್ಕೆ.
Yes, my lords.
Much obliged.
Cell number 3, Prashant S. Kardevar.
Today itself I secured the records, my lords. May I request day after tomorrow?
They have taken land malord in the year 1998. Award is not at passed.
Day after tomorrow, my lord. Today itself I secured records, my lords. I will.
ಇದೆಯಲ್ಲ?
ಬಂದಿದೆ sir.
Learned AGA submits that he has received instructions and the records, would make his submissions on Thursday.
Please.
Thursday, list in fresh matters list.
I request on Monday. Thus,
ನೀವಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಬಿಡಿ. Yes.
please.
Number 4, VM Shilvan, Girish V. Bhatt.
Matter, Your Lordship, I appear for the connected petition.
Ah.
Wherein, Your Lordship, in the first petition, they have sought for right to vote and contest.
Correct.
And court has granted, Your Lordship, only right to vote.
Ah.
Subsequently, Your Lordship, by attaching that interim order, they have filed nomination. In fact, nomination is accepted. I have filed an objection, Your Lordship, stating that they have got only voting right. Since, Your Lordship, they have given endorsement, Your Lordship, stating that as per the High Court order, we have accepted the nomination. That endorsement, Your Lordship, I have challenged in my writ petition. Subsequently, I got interim order, Your Lordship, saying that not to act upon their nomination. There are only 2 candidates who has filed the nomination. Their nomination is stayed, Your Lordship. Only remained is me. Last occasion, Your Lordship, they have submitted one letter, Your Lordship, stating that election agilla. Yes, since, Your Lordship, I am the only candidate who remained.
Election ಬೇಕಾಗಿಲ್ಲ.
Bekagil. Since, Your Lordship, I have also filed a letter, Your Lordship, seeking that why election is not taken place.
ಈಗ we'll take one by one. Now the first one, 107365.
Please, Lordship.
ಅದ್ಯಾರ್ದು ಒಂಟಿ ಅವ್ರದಾ?
Please, Lordship.
ಹೇಳಿ ಸರ್.
In this Lordship,
ಇಲ್ಲ ಇದರಲ್ಲಿ interim order ಏನಾಗಿದ್ದು?
interim interim order, my sister was there on that day. She has appeared as a KBT respondent. She has objected not to permit me to the contest the election.
So you
In
have
fact, the court allowed me to conduct, but by oversight, Lordship, in the order, it has not depicted. So very next day we,
Contest ನನ್ನ order ಆ?
ಅಲ್ಲಲ್ಲ, entry order.
Contest ನಾನು ಕೊಡೋದೇ ಇಲ್ಲ.
ಇಲ್ಲ ತಾವು ಕೊಟ್ಟಿಲ್ಲ ಆ ದಿನ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಲಾರ್ಡ್ಶಿಪ್ ಇದು ಇವರು ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರು ಹೇಳಿದ್ರು 13D ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ದೆನ್ ಅವರು ಆಯ್ತು ರಿಟೇಮ್ ಉಳಿಯಲ್ಲ, ನಾನು ಫ್ರೆಶ್ ಎಲೆಕ್ಷನ್ ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳ್ಬಿಟ್ರು. ಅದು ಆಮೇಲೆ ಡೇಟ್ ಹೋಯ್ತು, ಅದು ಆಗಿಲ್ಲ. ನಾವು 13D comply ಆಗಿಲ್ಲ admittedly, and even no election, and even out of 79 members, only 5 members.
No, the question is not that. Now, the interim order was not granted for you to file nomination.
Please.
How did you file nominations? Who filed it? Niva?
ಇಲ್ಲ, ನಾವು
How did you file?
ಲಾರ್ಡ್ಶಿಪ್ ಲಾಸ್ಟ್ ಒಕೇಶನ್, ಲಾಸ್ಟ್ ಡೇ ಅದು ಇದ್ದಿದ್ದು. ಓರ್ಲಿ ಇವನ್ ಗವರ್ಮೆಂಟ್ ಇದಿತ್ತು.
ಯಾವ್ದು ಸೂರತ್ ಸಾಹೇಬ್ರದ?
ಇಲ್ಲ, ಇವರು ಪೂರ್ಣಾಚ ಸಾಹೇಬ್. ಇಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ. ನಾನು
1.5 year last year elections.
ಇಲ್ಲ, ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು, ಬಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಬರ್ಲಿಲ್ಲ. ಆಮೇಲೆ ನಾವು ನಾಲೆಜ್ ತಂದ್ವಿ, ಬರ್ಲಿಲ್ಲ, ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೇವೆ. ಅದು ಇವನ್ ಸಾಯಂಕಾಲವರೆಗೆ ಇದಾಯ್ತು. ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳಿದ್ರು.
See, I go by the record.
True.
Record ಅಲ್ಲಿ there is only voting rights.
True.
If there is voting rights, you could not have contested at all. You could not have filed nomination at all. Now,
even though
ಇಬ್ರು contesting right ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಉಳಿಯೋದವ್ರು ಒಬ್ರೆ.
ಅಲ್ಲ, ಇವೊಂದು ಇಲೆಕ್ಷನ್ ಆಗಿಲ್ಲ ಆ ದಿನ, because of all this mess. And even out of 79 members, only 5 members have been they have been made eligible, lordship.
Yes, government.
They can raise section 70, my lords.
Section 70 raise ಮಾಡಬಹುದು, but nomination, let everything be considered there only. I will observe that.
Now, returning officer only given letter, your lordship, by election is not conducted. Since I was the only candidate who has remained. Since your lordship, in their petition, result was subject to leave of this honorable court. I was not announced as declared.
Let the results be declared. You challenge.
Election ಆಗಿಲ್ಲ, ರಿಸಲ್ಟ್ ಕ್ವಶನ್ ಬರಲ್ಲ.
ಏನ್ ರಿಸಲ್ಟ್ ಇದೆ ಅದ್ ಮಾಡ್ಲಿ, ಎಲ್ಲ ಚಾಲೆಂಜ್.
ಅಲ್ಲ, 13D ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅವ್ರೆ.
All that before the court. Now that elections are over or not?
No.
In respect of all, ಉಳಿದಿದ್ದೆಲ್ಲ ವಾರ್ಡಿಗೆ ಸಂಬಂಧಪಟ್ಟ
ಅವರೇ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲೆಕ್ಷನ್ ಆಗಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದಾರಾ?
ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾಕೆ ಆಗಿಲ್ಲ ಅಂತ ನನ್ನ ಲೆಟರ್.
Letter versus letter.
ಆಮೇಲೆ 79 members, out of 79 members, only 5 members have been. There is a ಎಲ್ಲರದು ರೈಟ್ಸ್ ಕಟ್ಟಿಲ್ಲ.
ಈ ಪ್ರಕಾರ ನಿಮ್ಮ ವಿಷಯವಾಗಿ ಮಾನ್ಯ ವಚನ ಪೀಠದಲ್ಲಿ ತಡೆಯಾಜ್ಞೆ ಇದ್ದು ಕಾರಣ ಮತಕ್ಷೇತ್ರ ಇದುವರೆಗೂ ಚುನಾವಣೆ ಜರುಗಿರುವುದಿಲ್ಲ. ಇದು ಯಾವತ್ತಿದೆ? 28/10/25.
Given one letter where
ಇನ್ನೊಂದು ಲೆಟರ್ ಏನಿದು? 3/11/25. ಸಂಪೂರ್ಣವಾಗಿ ಗಮನಿಸದೆ ಮತದಾನಕ್ಕೆ ಅವಕಾಶ ಕಲ್ಪಿಸಿ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದೀವಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲ ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ. ರಿಸಲ್ಟ್ಸ್ ವಿಲ್ ಬಿ ಡಿಕ್ಲೇರ್ಡ್. You challenge everything there.
Same society, your lordship, different constituency. Your lordship has allowed all the writ petitions. This was the only pending.
Allowed andre, this last year.
Out of 15 constituencies, only this constituency elections were not held.
Anyway, the petitioner is before this court seeking the following prayer. Coordinate bench of this court, owing to the orders granted.
One submission, lordship. My only submission, fair submission, because even my sister, she was there as a caveat response. She has objected, lordship, and even in very next day we brought to the notice.
I will post it before the same honorable.
ಅಲ್ಲ, very even ಅವರು ಗವರ್ಮೆಂಟ್ ಇದ್ದಾರೆ, ಇವ್ರಿಗೂ ಬೇಕಾದ್ರೆ ಕೇಳಬಹುದು ತಾವು. ಅದರ್ವೈಸ್ ನಾನು ಇಷ್ಟೆಲ್ಲ ಇದು ಮಾಡ್ತಿದ್ದಿಲ್ಲ. ಅವ್ರು ಹೇಳಿದ್ರು 13D ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ ಅಂದ್ಮೇಲೆ it has to go, entire election has to be conducted ಅಂದ್ಕೊಳ್ಳಿ. On that ground, lordship, this court expressed that will dispose of this.
Live ಇದೆಯಾ?
No. ಅಲ್ಲ, ಅದಷ್ಟೇ ಮತ್ತೆ. Otherwise, because lordship, my only grievance is that, lordship, out of 79 members, only 5 members they have been allowed, lordship. What about the rights of the other 71 members, lordship? Straight away they have not followed the procedure, lordship.
That's all right. If that is the case, then we will consider. If 13D is not there, because there is an observation that there is procedure contemplated 13D2A is not followed antane ide illi.
ಅವರೇ ಹೇಳಿದ್ದಾರೆ, ಅವರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ.
We have published the list.
It is not in compliance antidiyala.
The one ground independent notice has to be issued, which is not been issued.
Not been issued andre it's contrary to 13D2A.
Now voting rights, lordship. My rights, lordship.
Subsequently, your lordship, same matter was posted.
Killing of democracy, lordship.
Killing.
ಹೌದು, ನಾನು voting rights ಎಲ್ಲ ಏನು ಇಲ್ಲ ಅಂದ್ಮೇಲೆ open ಆಗಿ 71 members they have been deprived, lordship, without due process of law.
No, if independent notice are not issued, I will direct holding of fresh election after a procedure being followed.
ಅಷ್ಟೇ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ಮಾಡ್ಲಿ ಅಂತಂದ್ರೆ
ಹಾ,
ಅವರು
last year
ಇಲ್ಲಿ
ಇದೆಯಲ್ಲ ನಿಮ್ ಗವರ್ಮೆಂಟ್ 5/6/2024 ಸರ್ಕ್ಯುಲರ್ ಇದೆ, ಅದ್ರ ಪ್ರಕಾರ ಮಾಡ್ಲಿ.
For the same judge, your lordship, twice matter was posted.
ಈಗ ಥರ್ಡ್ ಟೈಮ್ ಅಲ್ಲೇ ಕಳಿಸ್ಲಾ? Then, no, the learned judge observes that 13D2A is not complied. You show me the compliance. Or you are admitting non-compliance.
ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ, ನೆಕ್ಸ್ಟ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ರು ರೆಕಾರ್ಡ್ಸ್,
In all the
ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ರು ಅವರು ಅದೇನ.
If it is admitted non-compliance, will not send the matter to be, matter before the registrar.
ಕನ್ನಡ ಪಟ್ಟಿ ಎಲ್ಲದನ್ನು ನಾವು ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ದೀವಿ.
ಕೊಡಿ ಮೇಡಮ್. ಏನ್ ಲಿಸ್ಟ್ ಇದು?
ಅಲ್ಲ ಅರ್ಹ ಪಟ್ಟಿ ಅನರ್ಹ ಪಟ್ಟಿ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಲಿಸ್ಟ್ ಮಾಡಿರೋದು, ನಂತರ ಆಫ್ಟರ್
ಅಲ್ಲ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಎಲ್ಲಿ ಕಳಿಸಿದೀರಾ?
ಇಂಡಿಪೆಂಡೆಂಟ್ ನೋಟಿಸ್
ಮತ್ತೆ then this has to go.
Same society, different constituency, all matters your lordship has allowed it.
No negative equality. ಅಲ್ಲಿ ತಪ್ಪು ಮಾಡಿದೀವಿ ಅಂದ್ರೆ ಇಲ್ಲೂ ತಪ್ಪು ಮಾಡ್ಬೇಕು ಅಂತ.
I will leave it to your lordship.
ಹಾ?
Will leave it to your lordship.
Leave it to your lordship. Yes. There is if it is an admitted fact, then fresh elections will have to be held after complying with 13D2A procedure.
ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಒನ್ ವಾರ್ಡ್.
ಒಂದೇ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ
ಉಳಿದಿದ್ದ ವಾರ್ಡ್ ಎಲ್ಲ ಮುಗಿದು ಹೋಗಿದೆ, ಎಲ್ಲದ ಎಲೆಕ್ಷನ್.
ಇಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗಂಗಿದ್ರೆ ಹೋಗಿ.
lordship has allowed the writ petitions, ಅದರಲ್ಲಿ ರೈಟ್ ವೋಟಿಂಗ್ ರೈಟ್ ಕೊಟ್ಟಿದೆ, that has been disposed.
ಮಂಟಿ ಅವರೇ, ಒಂದು ವಾರ್ಡ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ,
one word is left.
ಓಪನ್ ಇದೆ, ಅದಕ್ಕೆ ಆನ್ ರೆಕಾರ್ಡ್ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ಲಾರ್ಡ್ಶಿಪ್. ಅದರ್ವೈಸ್ ಐ ವಿಲ್ ಡೌನ್.
No, it will upset the apple cart.
Please. ಈಗ
ಇಲ್ಲ, ಇದೊಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ಪೆಂಡಿಂಗ್ ಇಟ್ಟಿದ್ರು, ಬೇಕಾದ್ರೆ
ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ಅಲ್ಲ, ವಾರ್ಡ್ ಮೇಲೆ.
ಅದೇ ಇದ್ರದ್ದೊಂದೇ ಅದು ವಿಲೇಜ್ ಅಷ್ಟೇ, ಬೇಕಾದ್ರೆ ಇದನ್ನೊಂದು ಫ್ರೆಶ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಆಗ್ಬೋದು.
We'll see what solution. Tomorrow I'll take it.
Please.
Just tomorrow in same stage.
Please.
But statutory non-compliance goes.
in respect of other also my lords, but
ಅದ್ರಲ್ಲೂ ಹೇಗೆ ಇತ್ತಾ?
ಅಲ್ಲ ಅದರಲ್ಲೆಲ್ಲ ವೋಟಿಂಗ್ ರೈಟ್ ಕೊಟ್ಟು ರಿಸಲ್ಟ್ ಅನ್ನು ಅನೌನ್ಸ್ ಮಾಡಿ ಅಂದ್ರೆ this court granted the liberty. We have announced the result. ಇದು ಒಂದು ಪಿಟಿಷನ್ ಬಾಕಿ ಉಳಿದಿರೋದು ಅಷ್ಟೇ.
All right. Yes.
Only lordship on the basis of the 4 members, they want to hold this election, we want to win this election, lordship. Oh, what about the?
ಸಾದಿಕ್ ಏನೋ ಹೇಳಿದ್ರಿ.
ಇಲ್ಲ.
Yes.
Please.
Petitioner. Lord, tender was for, Lord, allotment of shops was called for.
55 commercial complex, lordship.
There being page 16. Lord, there is a circular that.
You're already in occupation of the.
Yes, ma'am, from 15.
So first ನಿಮಗೆ ಕೊಡ್ಬೇಕು.
ಹೌದು.
Right of first waive off.
ಟೆಂಡರ್ಗೆ ಅವ್ರು ಅಪ್ಲೈ ಮಾಡ್ಬೇಕಲ್ಲ ಸ್ವಾಮಿ?
ಟೆಂಡರ್ಗೆ ಅಪ್ಲೈ ಮಾಡೋದು ಫಸ್ಟ್ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು.
ಅಲ್ಲ 15 years ಇಂದ ಇದಾರೆ ಸ್ವಾಮಿ ಅವರು. ಕೈಂಡ್ಲಿ ಸಿಕ್ ಅನ್ನೆಕ್ಷರ್ ಇ ಲಾರ್ಡ್ಶಿಪ್.
ಸರ್ಕ್ಯುಲರ್ ಕೊಡಿ.
ಇದೆ annexure B, ink page 16 ನಲ್ಲಿ my lord difficulty, my lord kindly turn ink page 18. Ink page 18 last paragraph.
This is the circular, yes.
This circular states, my lord, 18% to SC ST, ink page 18 last para. 18% to SC ST and one shop to, my lord, handicap.
ನೀವು ಯಾರು?
We are, my lord, general category.
ಆಯ್ತು ಸರಿ.
Now they have, my lord, more than 18%, my lord, they have given it to, my lord, scheduled caste and scheduled tribe as per notification. And, my lord, kindly turn to, my lord, impugned order annexure E, annexure F. Ink page 61.
The commercial complex vested to the Taluka Panchayat lordship.
Correct, commercial complex.
My lord, ink page 58. My lord, there are 55 shops. My lord, to accommodate 5 persons, my 5 shops are left out.
ಈಗ ನೀವು
I am seeking, my lord, right for.
That's all right. Tender, you participated in the tender and came in?
Please, my lord.
15 years back ಹೆಂಗ್ ಬಂದಿದ್ದು ಇಲ್ಲಿಗೆ?
Tender ಮೇಲೆ ಬಂದಿದೆ.
ಇಲ್ಲ ರೆಂಟ್ ಬೇಸ್ ಮೇಲೆ ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ. Since from 15 years is continued.
Who are you?
I am for the Taluka Panchayat lordship. I called for a tender lordship.
Circular ಪ್ರಕಾರ you have to give them the first right whether they want to continue.
ರಿಸರ್ವೇಶನ್ ಫಾಲೋ ಆಗಿದೆ ಸ್ವಾಮಿ. ರಿಸರ್ವೇಶನ್ ಫಾಲೋ ಮಾಡಿದ್ದೇವೆ.
ರಿಸರ್ವೇಶನ್ ಫಾಲೋ ಎಕ್ಸೆಸ್ ಆಗಿ ಮಾಡಿದ್ದೀರಾ?
ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಸ್ಟೇ ಇದೆಲ್ಲ?
ಸ್ಟೇ.
Since from January is interim order is not extended lordship.
No problem. Will not extended.
Yes lordship.
Extend ಆಗಿದೆ, my lord, I had requested it. I will file application.
It was extended twice.
It's my order.
Yes.
Please, Lordship.
ಸೂರತ್ ಸಾಹೇಬ್ರ ಮುಂದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ.
ಹೌದು.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಬೇರೆ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ದೀನಿ.
ನೆಕ್ಸ್ಟ್ ಅವ್ರದ್ದು ರಿಪ್ರೆಸೆಂಟೇಷನ್ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಸ್ವಾಮಿ.
ಏನು?
ನಮ್ದು ಕಂಟಿನ್ಯೂ ಮಾಡ್ರಿ, ಪ್ರೈಸ್ ಹೈಕ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
My lord.
ಪ್ರೈಸ್ ಹೈಕ್ ಮಾಡಿ. ವಾಟ್ ಎವರ್ ರೆಂಟಲ್ ಯು ಆರ್ ಗೆಟಿಂಗ್ ಫ್ರಮ್ ಅದರ್ಸ್ ನೌ, ಯು ಟೇಕ್ ಇಟ್ ಫ್ರಮ್ ದೆಮ್, ದೇ ವಿಲ್ ಗಿವ್.
Yes, yes.
ಅಲ್ಲ, ಅದು ಟೆಂಡರ್ ಕಾಲ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಅಪ್ಲೈ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
We'll see, we'll let you know. There is
Section 216 of the Panchayat Raj Act, Lordship.
ಎಲ್ಲಿದೆ? What, Sadiq?
Urgent.
Lordship, kindly see page number, ಇದು section 216 of the Panchayat Raj Act, Lordship. This is the vested of the Taluka Panchayat property, Lordship. 100% funding of the our authority, Lordship.
Absolutely, no problem. ಈಗ ನೀವೆಲ್ಲ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ಬೇರೆ ಜೊತೆಗೆ?
My lord.
ಇಲ್ಲ ಹಂಗೇನಿಲ್ಲ, ನಾವು ಟೆಂಡರ್ ಕಾಲ್ ಮಾಡಿದ್ದೇವೆ.
My lord, kindly seeing page 63. My lord, this respondent Taluk Panchayat seeks for clarification for extension of lease period to me.
Page.
My lord, page 63. ವಿಷಯ: ಕುಷ್ಟಗಿ ತಾಲೂಕಿನ ಪಂಚಾಯತಿಗೆ ಸೇರಿದ 55 ವೈದ್ಯ ಮಳಿಗೆ ಕರಾರು ಒಪ್ಪಂದ ಮುಗಿದ ಪ್ರಯುಕ್ತ ಬಾಡಿಗೆ ಅವಧಿಯನ್ನು ನವೀಕರಣ
Legislatures request
after tender notification.
After tender.
Yes.
The petitioner dispose ಮಾಡಲಾ?
Please, Lordship.
ಕರೆಕ್ಟ್, ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ ಹಾಕಕ್ಕಾಗದವ್ರು. ದಿ ಪೆಟಿಷನರ್ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಕೊಡ್ತೀನಿ. Sorry, my lord.
ನಾನು ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದೇನೆ ಸ್ವಾಮಿ, ತಮ್ಮದೇ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಇದು.
His
Paragraph 28,
is
Lordship.
covered to say
I have myself held so, sir, in many
Yes, yes.
cases.
Paragraph 28, Lordship.
1 minute.
Memo filed on 1410, Lordship.
ಧಾರವಾಡ ಬೆಂಚ್ ದ
ಅದೇ ತಾವೇ ಕೊಪ್ಪಳದ್ ಮಾಡಿದ್ರಿ ಸ್ವಾಮಿ. ಮ್ಯಾನ್
ಪವರ್
ಬಟ್ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಅಂಡ್ ಸ್ಕೋಪ್ ಇಸ್ ಕನ್ಸರ್ನ್.
ಅದು ತೊಂದರೆ.
ಕೊಟ್ಟಿರೋ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಅಂಡ್ ಸ್ಕೋಪ್.
The petitioner is before this court seeking the following prayer. The petitioners are heard so and so. The petitioners are the ones who were allotted shops in the precincts coming within the precincts of the second respondent. Which respondent? Fifth respondent, Taluk Panchayat, Kushtagi, Koppal. The petitioners begin their business after entering into those shops pursuant to the contract and between the town municipal council and these petitioners for those petty shops coming with the precincts as indicated here and above.
Taluka Panchayat, Lordship.
Taluk Panchayat. The issue in the list is with regard to the calling of the tender and allotting the shops to all those eligible tenderers. It is at that juncture the petitioner is at the doors of this court in the subject petition on an apprehension that the petitioner's business would be stopped and they would be driven out of their premises. This court protected the interests of the petitioners in terms of its order dated 9/1/2025. Therefore, the petitioners continue to be in business of in the said premises. The learned counsel Sadiq Godwala, appearing for the petitioner, submits that after the issuance of the tender notification, the Taluk Panchayat itself has communicated to the Chief Executive Officer of Jilla Panchayat as to with regard to the feasibility or liberty being sought to continue these petitioners in those shops that were allotted with an enhanced rent. In that light, the learned counsel Sadiq submits that it is in tune with the circular that is issued by the state, and therefore that the fifth respondent cannot now act contrary to the circular. The learned counsel seeks continuance of these petitioners strictly in consonance with the circular that is issued by the state. The learned counsel,
Vijay Kumar Balgeri,
sorry, so and so representing the fifth respondent would vehemently refute the submission, seeking to place reliance upon a judgment rendered by this court in page 11, this court in so and so, on contending that the scope of judicial review in such cases is extremely limited and this court should not entertain the petitions at the plea of the petitioners who have now completed their tenure in terms of the earlier tender notification through which they came in. The learned AGA would also toe the lines of the learned counsel appearing for the fifth respondent in submitting that the shops of shops belonging to, shops that are public property should be necessarily allotted to by way of a tender, The aforenarrated facts are not in dispute. The petitioners enter into these shops by way of participation in a tender 10 years ago, na? 10 years ago, i.e. on 10 or 15?
15 years.
Then 10 go 15 ವ್ಯತ್ಯಾಸ ಇಲ್ವಾ?
10 to 15 years.
10 to
different.
3 years ಮಾಡಿ ಅವ್ರು ರೆಂಟ್ ಬೇಸ್ ಮೇಲೆ ಇದ್ರು ಸ್ವಾಮಿ ಅಷ್ಟೇ.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. ಎಸ್.
ಆಮೇಲೆ
The learned counsel for the petitioner has placed heavy reliance upon a circular issued by the state. ಎಲ್ಲಿದೆ ಸರ್ಕ್ಯುಲರ್ ಸಾದಿಕ್?
Page number B, my lord, in page 16. 17. Page 18. Last paragraph.
The circular, the conditions or the nuances of the circular is as follows. Page 17 to 19 quote ಮಾಡಿ. Therefore, the issue in the list revolves around the interpretation of the circular. On the strength of the said circular, the fifth respondent itself is said to have communicated to the Jilla Panchayat seeking the extension of these petitioners on payment of higher rent that they would get.
Clarification, seeking for clarification.
Seeking clarification.
After they made the legislature's request, lordship.
The fifth respondent Panchayat itself has communicated to the Jilla Panchayat, albeit on the request of the shop, on the petitioners and the like, that the shops of the petitioners could be continued for a further period with the enhanced rent, strictly in terms of the circular that was issued by the state. The communication reads as follows, page 63.
Petitioner tenure was already completed, lordship.
Yes, ಎಷ್ಟು ಸರ್ತಿ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತೀರಾ?
Sorry, lordship.
ಅಪೀಲ್ ಹಾಕಿ. Yes. ಏನು ಹೇಳಿ ಮೇಡಮ್? The communication reads as follows. If the communication so made by the fifth respondent to the Jilla Panchayat is juxtaposed with the circular that is issued by the state, the communication, though on the request of these petitioners, appears to be in tune with those circulars. In identical circumstances, the coordinate benches of this court have considered the issue with regard to the allotment of these shops to these persons and their right to continue in the shops pursuant even before the tender could be notified to allot the shops to other persons. The coordinate bench is held as follows. In the light of the said judgment of the coordinate bench, which considers this issue and permits the continuation of the shop or to those persons in tune with the circular quoted supra, the petitioners shall be continued in those shops strictly in consonance with the circular quoted supra. Till again ಕರ್ಬಿಡಿದೆ. ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ ನೀವು?
ನಾವು my lord
55 lordship.
ಇಲ್ಲ 55 shops. ನಾವು ಇರೋದು 20 my lord, we are 40 minutes. 5 shops only. 40.
Therefore, the petitioners in the shops that are allotted to shall not be disturbed. Insofar as the judgment rendered by this court, which reliance upon which the petitioner respondent has placed, is distinguishable without much ado. The said judgment was concerning supply of manpower through a tender or otherwise. In those circumstances, this court had held that would not, judicial review in such cases would not be permissible as a matter of course. The said judgment being inapplicable, I deem it appropriate to pass the following order. The allowed cost, the petitioner shall be permitted to continue in terms of the circular and the judgment rendered by the coordinate bench. ಮೂರಿದೆ ಸಾದಿಕ್, ಈಗ ಕೊಟ್ರೆ ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ, ಇಲ್ಲದೆ ನಾಳೆ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟಾಕ್ ರಿವರ್ಸ್ ಮಾಡ್ಬಿಟ್ಟು.
ಇಲ್ಲ ಈಗಲೇ ಇವತ್ತೇ ಕೊಡಿ.
May I make one submission with great respect, lordship? Page number 17. After tenure is complete, as per KTB Act, liberty to give the fresh call for tender, lordship.
No problem. ಆಯ್ತು, ಆಗ್ತೀನಿ ಅದನ್ನು.
Liberty to call and fresh tender, lordship.
After the tenure is complete.
Tenure already completed, last year is completed.
ಅದನ್ನ one sentence ಅಲ್ಲಿ you will annul the entire judgment. Very good way of telling it.
It's circular itself is shows that.
Circular ಇರ್ಲಿ, ಈಗ ನಾನು ಬರ್ದಿದ್ದೀನಿ, ಕೊನೆಗೆ I'll write, after the tenure is over, tender can be called. Tenure is already over. Yes, sir.
ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ ಕಾಲ್ ಮಾಡಿದ್ದೀವಿ ಸರ್ ಫಸ್ಟ್ ಟೈಮ್.
ಫಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದೆ.
Please, Lordship.
ಬಹಳ ಸಂತೋಷ. Yes. ಇವ್ರದಾ? ನನ್ ಮುಂದೆನೆ ಬರ್ಬೇಕಾ? ಸಕ್ಸೆಸಿವ್
482.
ಕೊಡಿ. ಕ್ಲಾಸಿಫಿಕೇಶನ್ ತಪ್ಪ ಅಷ್ಟೇ ತಾನೆ?
ಹೌದು ಪ್ಲೀಸ್. ಕ್ರಿಮಿನಲ್ ಬರೋದು ರಿಟ್ ಅಂತ.
ರಿಟ್ ಬಂದಿದೆ.
420.
ಪ್ಲೀಸ್.
ಸ್ಟೇ ಇದೆಯಾ?
ಸ್ಟೇ ಇದೆ.
ರೆಸ್ಪಾಂಡ್ ನೀವಾ?
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್
ಸೀನಿಯರ್ had appeared yesterday.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್
Senior appeared.
ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಟ್ಟರು ನಿನ್ನೆ ಫುಲ್ ಚಾರ್ಜ್ ಶೀಟ್.
ಹೆವಿ ಮ್ಯಾಟರ್. ಫೈನ್ ಫೈನ್. ನಾಳೆ ತಗೊಳ್ಳೋಣ?
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
Fresh matter.
ಪ್ಲೀಸ್. ಗ್ರೇಟ್.
Registry to classify the matter appropriately.
ಪ್ಲೀಸ್. ಗ್ರೇಟ್.
Please.
ನಿನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ KLR ಆಗೋಯ್ತಾ ಅದು?
7, Chetan Munoli.
My lord, I appear for the petitioner's counsel.
Yes,
There
sir.
are two applications, my lord, for amendment and one application for impleadment. As far as the application for amendment is concerned, my lord, what has happened is the panchayat has, my lord, made a demand. Earlier we were paying the 22 lakhs as taxes. Suddenly, my lord, the resolution passed by them was to pay, my lord, 1 crore. That was annulled by the CEO and he, my lord, made a demand for 16 crores. Now, my lord, the land of ours is granted by the KADB. There are circulars, my lord, which have been passed by the government stating that, my lord, it's only the KADB which can collect the taxes, my lord, not the panchayat. In fact, this honorable court has already passed an order saying that, my lord, if KADB land allotment is made, then, my lord, panchayat, my lord, can't make a demand. Demand is quashed. In fact, my lord, we have produced it along with the application, my lord, for IA5.
Along with
IA5,
Regarding-
page 42.
Regarding amendment is concerned, my lord, it can be allowed, my lord. But they also question the validity of the section 199 of the Gram Panchayat Act.
Then we will consider it.
Please,
Objections
the amendment is concerned, it can.
ಇಲ್ಲ, objections ಬೇಕಾಗುತ್ತೆ.
Amendment,
ಹಾಕಿದ್ದೀವಿ.
ಅಲ್ಲ, main matter ಹಾಕಿಲ್ಲ. State has not filed, my lord. Only the respondent number 2 has been filed.
No, state has to file if 119 is.
Even for amended petition, will comprehensive statement of objection will file.
All right, we'll allow the amendment. Is there an interim order?
There is an
Yes,
interim
my lord,
order
there
for
is.
the demand notice.
It is still today.
The state has filed
Third, the
amendment.
learned senior counsel Shri Uday Holla appearing for the petitioner. The learned additional advocate general submits that the state has no objection.
Regarding this.
State has no objection for the allowing of the amendment application so filed. In the light of the said submission and being satisfied with the reasons so indicated in the affidavit accompanying the applications, the application is allowed. The petitioner shall now amend the petition and file an amended petition within a fortnight.
My lord, there is also an application for impleadment of the president of the panchayat, my lord, because CEO and the panchayat, because
that
CEO
also
has
be allowed?
annulled. Yes, ma'am.
President of the panchayat, why?
President. Chief executive.
Chief
No, no, not
executive.
panchayat.
Chief executive.
Chief executive. I stand corrected.
Yes, sir.
Sorry.
For the ಅದು ಇದು ಮುಗಿಸಿದ್ಮೇಲೆ fortnight so and so, the state is at liberty to file objections to the amended petition as well, notwithstanding the fact that the Hakila
Already filed.
notwithstanding the fact that they have already filed their objections to the petition earlier filed. The so and so. Next, IA 2 of 2025. The petitioner has preferred an application seeking impleadment of the chief executive officer of which panchayat?
Taluka Panchayat and Jilla Chief Executive Officer of Jilla Panchayat Hospet, Vijayanagar.
Jilla Panchayat Hospet for the reasons indicated in the affidavit accompanying the application and being satisfied with the same. The so and so allowed. The petitioner shall amend the cost title and file an amended cost title along with the amended petition. Again, within a fortnight, the learned Bhushan so and so accepts notice for the CEO, Jilla Panchayat.
CEO and Executive Officer, Taluka Panchayat.
CEO and so, list the matter on, yes, when do we take it? Objections, 4 weeks?
Whenever-
4 weeks.
The,
Second week of this.
the learned additional advocate general seeks 3 weeks' time to file a statement of objections, a comprehensive statement of objections. List the matter on 4th, 5th, 5th December. 4th December. Saka?
Please.
List the matter on 4th December. Objections, if any, by then interim order subsisting would continue till the next date of hearing.
Not sir. IA number 3 of 25 and 5 of 25 may be allowed. Not, sir.
IA 3 ಯಾವುದು? Amendment.
ಅದು amendment.
IA 3 and 5 both amendment.
Please, oblige.
My lord, implement as IA 4, my lord, not IA 2.
ಅದು ನೋಡ್ಕೊಂಡು I'll see.
Grateful,
ನೋಡ್ಕೊಳ್ಳಿ.
grateful to you.
IA 4 IA 3 ಯಾವ್ದು ಇಂಪ್ಲೀಡಿಂಗ್ ಯಾವ್ದು ಇದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಎಸ್
Please, ma'am.
Civil by A, Ganesh Rai Bagi.
My lord, already existing committee without informing, without giving any notice to the existing committee, and knowing that the existing committee has summoned the general meeting, already issued the notice, paper publication.
Yes, sir. Who appears to be
Realizing
respondent?
this.
State.
Please. Please, my lords. My lords, so first initially the annexure K, my lords, 34. It is stayed, approved by the registrar with regard to the committee, my lords.
Under section 13.
Under section.
Please. And thereafter, my lords, annexure L that has been revoked. Since it is because there is a complaint by some other persons, my lords.
Power to revoke.
That's why the Honorable Court has stayed the.
Correct. Where is the power to revoke? Once ಯಾರು
Yes,
complaint
once
ಕೊಟ್ಟೆ ಕೊಡ್ತಾರೆ.
functions officio.
13 ಅಲ್ಲಿ ಒಂದ್ಸರಿ accept ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ how do you revoke it?
Yes, my lords. Functions officio on that ground, this Honorable Court has stayed, my lords. Now
ಹೇಳಿಲ್ಲ ಮತ್ತೆ ಏನು?
Yes.
ನೀವು ಹೇಳಲೇ ಇಲ್ಲ ಏನು?
ಹೇಳಿದ್ದೀನಿ ಸರ್.
ಹೇಳಿದ್ರಾ?
Now the suit is also one of the suit by the secretary is also pending before the civil court.
Let everything be decided that
Yes,
this will quash.
Yes, please.
The petitioner is before this court seeking the following prayer. The petitioner, ಯಾವತ್ತಾಗಿದೆ election?
Annexure M, sir. Annexure M, my lord.
Date.
8, sir.
Date, sir.
Date. Annexure M. Uh, 29/9/2025.
29/9/2025.
I number, page number 8, Your Honor. I have filed to
16/1/25.
29/9/25, my lord.
ಯಾವ್ದು 29/9/25, sir?
I'll
dismiss the petition now. This is what you're telling.
External I have filed to.
External IA?
I have filed to.
External IA?
Additional I have filed to. Challenging the annexure M.
16/1/2025 ಏನಾಗಿದ್ದು ಸರ್?
ಅದು annexure L ಪಾಸ್ ಮಾಡಿದೆ ಸರ್.
ಏನ್ ಮಾಡಿದ್ರು ಸರ್?
16/1/25 annexure L, that is.
ನೀವು ಯಾರಿಗೆ?
Lord, on our complaint, the subsequent order has been passed. Lord,
Where is the jurisdiction? Where is the jurisdiction to recall, sir?
I will ask, my lord, I will
Where is
make.
jurisdiction to recall once it is accepted under section 13?
No, my lord, I will, if your lordships have it next week, my lord, meanwhile, I will.
Why
come on
next
that
week?
call. Lord,
You are not a
not
party here.
brought, no, they have not made us as a party.
Annexure L,
They
35.
have not made us as a party to the writ petition. Lord, I came to know just only. Have it next week, my lord, I will.
ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ?
ಇಲ್ಲ ಸರ್, ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡುವಂತ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಅವ್ರಿಗೆ ಯಾವುದಕ್ಕೆ ಇಫೆಕ್ಟ್ ಮಾಡಿಲ್ಲ ನಾವು.
I will.
Rights
I will-
we have not affected the
He is
rights.
the complainant.
No, sir. ಅವ್ರಿಗೆ ನಾವು ಯಾವ
They are
rights
the
effect
complainants.
ಮಾಡಿಲ್ಲ.
On the basis of our complaint.
Already their case is pending. Suit is pending.
No.
Suit is pending.
Very good.
And
petitioner shall implead, assistant sir correct ಆಗಿ ಬರುತ್ತೆ. The petitioner shall implead the complainant before the registrar as a party respondent to these proceedings. The amendment shall be done for the petitioner, the impleadment shall be done forthwith. The learned counsel Sunil Desai accepts notice for the impleading applicant. Petitioner to serve complete set of papers upon the aforesaid counsel. List the matter on 18th in fresh matters list. The interim order subsisting will continue till the
Humble
next date of
submission, sir.
hearing.
Kindly pass the interim order. Stay the annexure M, my lord.
ಮಾಡಿದ್ದೀನಲ್ಲ
Annexure M.
interim order is already there, sir, don't worry. Yes.
That is the earlier interim order, my lord. Extensive.
The interim order subsisting will continue to the next date of hearing. Yes, next.
Still number 9, Shashank is second.
ನೀವೆಲ್ಲ ಡೇಟ್ ಬರ್ಕೊಂಬನ್ನಿ ಯಾವತ್ತು ಏನೇನಾಯ್ತು ಅಂತ. If you stand like this, then it will be difficult to pass orders. ಅದು ಕೇಳಿಸ್ಕೊಳ್ಳಲ್ಲ. Yes.
This is a matter relating to GST on solatium. This issue is already decided by coordinate bench of this court. Memo is already filed along with the decision. There are two decisions.
Issuance of Shokas notice and premature case, my lords. Notice is issued for that.
Complete murder.
10th July 25.
Yes, ma'am. One is a detailed decision and another is following the.
Where is the other one?
It's the
2025 29 syntax.
Last page of the Abusive Convention Center. Last two pages of the
last
two pages of the compilation.
Last two pages just Suraj avaru gottayitu.
Yes, ma'am.
Which is the other one that he has followed?
The first one, ma'am. Asha
Krishna,
versus
Krishna Kumar.
Yes, ma'am.
What is your?
This is Shokas notice is issued.
Yes. Anything else? The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the show cause notice is now issued to the petitioner on this score, or seeking the petitioner to show cause as to why GST should not be levied upon the solatium amount. The learned counsel submits that the issue in the list stands completely answered by the judgment rendered by the coordinate bench in so and so first flag in 2025 173 tax 1863. The said judgment is followed by another coordinate bench in writ petition 19351 of 2025, wherein the coordinate bench is held as follows. In the light of the issue standing completely answered by two of the aforequoted judgments of the coordinate benches, the submission of the learned AGA that it is only a show cause notice is unacceptable.
One submission. Subsequently, they passed the order also, which is also impugned.
Show cause notice is unacceptable. However, the learned counsel for the petitioner submits that an order in original is passed at a subsequent point in time, which is also impugned in the subject petition. Therefore, the petition deserves to succeed with the prayer that is sought, and the annexures as sought in the prayer to be quashed for the aforesaid reasons.
Annexure A and annexure L.
Whatever you have sought is quashed. Next.
Obliged.
Number 10.
Family pension and terminal benefits of the petitioner was withheld on the ground that criminal revision petition is pending before this honorable
Criminal
court.
revision petition.
Yes, sir. That is came to be dismissed on 28 July 2025.
In 138 case.
Illa 306 abatement to suicide. The present petition is the wife of
Petition,
the
criminal revision petition.
revision petition. Criminal petitioner discharge admele she filed a criminal revision,
discharge.
mother-in-law of the present petitioner. That is also came to be dismissed.
Could you order?
The copy. Mine my learned friend has produced one copy that they have preferred SLP anta.
She has prepared a SLP before the Supreme Court. It was pending.
But it was not yet come before the court, your Lordship.
Diary number ಇದೆ. Diary number ಇದೆ. SLP not listed before Supreme Courts. ಕಳಿಸಿದ್ದೀನಿ. Diary number ಕಳಿಸಿ.
Who is the complainant?
Complainant is the mother-in-law of the petitioner. The mother of the deceased, Your Lordship.
Deceased ಯಾರು ಮಗನ?
Magan. ಇವಳು ಅವನ ಹೆಂಡತಿ ಇವಳು.
ಅದು correct.
He committed a suicide.
ಇಲ್ಲಿವರೆಗೂ you are accused in 306.
Accused in 306. Earlier, before the trial court have discharged.
Anything else, sir?
ಏನಿಲ್ಲ, that is on record, my lords. Consider it, but SLP is pending. Only thing is, she is the mother.
So, pension ಯಾರಿಗೆ ಬರುತ್ತೆ? Family pension.
Mother and wife.
ಯಾರು ಹೇಳಿದ್ ಮದರ್ಗೆ ಬರುತ್ತೆ ಅಂತ? What sort of law is this you are telling?
That is what.
How will family pension go to the mother, sir?
That pension is concerned to my lords.
Then what concerned are you telling?
Let them pass.
Sir, ಏನ್ ಬರುತ್ತೆ? How did you withhold the pension till now?
The ground of my immediately after the
What
dismissal of the revision, my lords, he has prepared on 11/8/25, my lords. That she filed applications.
The husband commits suicide, ಏನ್ ಮಾಡಕ? Abatement. ಮತ್ತೆ? The petitioner is before this court calling in question an endorsement dated 19/12/2024 by which the family pension of the petitioner is denied and the petitioner seeks a consequential mandamus for release of family pension and other terminal benefits of the deceased husband. ಏನು 21 years ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ. Yes,
immediately after marriage.
20 ಮದುವೆ.
The heard so and so. Facts in brief, germane, are as follows. The petitioner is said to have married one Iraya Pujar, who was, what was he working as?
Jawan.
Jawan in?
Respondent number.
Working as a Jawan in the second respondent, coming under the first respondent. The husband of the petitioner commits suicide on 28/11/2023 by the act of pouring kerosene on himself and pouring kerosene and setting himself ablaze. The acts of the crime falls on the wife for abetment to suicide by a complaint registered by the mother. The mother, which becomes a crime in crime number 137 of 2023. The police conduct investigation and file a charge sheet before the concerned court arraigning the petitioner as accused and accusing the petitioner as for an offence of abetment to suicide. After the filing of the charge sheet, the concerned court, the petitioner files an application seeking her discharge from the array of accused. The concerned court allows the discharge application, sets the petitioner free from allegations. The said order of discharging the petitioner is called in question again by the mother in criminal revision petition 100-433 of 2024. The criminal revision petition also is said to be dismissed by the coordinate bench of this court. The coordinate bench of this court, now the mother is said to have approached the Apex Court in a special leave petition. Therefore, the petitioner who is entitled to terminal benefits terminal benefits on the death of the husband is family pension, or other terminal benefits on the death of the husband is not paid a penny on the score that the mother has been agitating by filing a complaint against the wife, against the present petitioner for the offence of abetment to suicide. The learned counsel appearing for the petitioner, Jagdish Patil, would submit that the two courts, one, the concerned court of session has discharged the petitioner holding that there was no element of abetment to suicide present in the case at hand, which is affirmed by the coordinate bench in criminal revision petition following the judgments of the Apex Court in the case of Prakash and Kanchan Sharma, and would submit that there is no warrant for the respondent to rely on the complaint of the mother or the representation of the mother to deny family pension to the petitioner, family pension or terminal benefits to the petitioner. The learned
DSGI.
The learned DSGI Venkatesh Karvi would submit that the only reason is that the mother has represented to the department that pension should not be released in favor of the wife, as she is guilty of abetment to suicide, killing the abetment to suicide of the husband, the son of the complainant. And would submit that they have gone by only the representation, and if an order passed by this court, then whatever, gone by the representation. I have given my anxious consideration to submissions. Discharge order ಇದೆ.
Yes, sir.
Discharge order ಇದೆ.
Discharge order, your lordship.
The aforenarrated
28
fact,
to
the aforenarrated
27,
fact
23 to
of
37.
the son of the complainant and the petitioner getting married is a matter of record. The petitioner, the husband of the petitioner is said to have committed suicide on 28/11/2023 on manifold reasons. The acts of the commission of suicide of the mother of the husband falls on the wife by registration of a crime in crime number 137 of 2023 for offence punishable under section 306 and 34 of the IPC. The police conduct investigation and file a charge sheet. On filing a charge sheet, the petitioner seeks herself to be discharged from the area of accused. The concerned court, which page Ali? Jagdish sir.
Yes, sir.
Page,
37
page.
page.
37.
Operative portion is 37, your lordship.
37.
Yes, sir.
The concerned court discharges the petitioner on the following reasons. Para 39 till the end, page 34 to 37. This is called in question by the mother before the mother is not a party here?
No, your lordship. Before this court, your lordship. The writ petition, I am not.
Revision del party. This is called in question by the mother before the before this court in criminal revision petition, so and so. The coordinate bench, in terms of its order dated 28th July 2025, allows the dismisses the criminal revision petition by affirming the order of discharge passed by the Court of Session quoted supra. The mother has now approached the apex court against the said orders. In the light of the two orders in favor of the present petitioner and the settled principle of law that family pension would be available to the wife and the children of the deceased, hearing the mother all over again in this petition is of no avail. Therefore, the petitioner becomes entitled to the terminal benefits of the deceased husband that gets accrued to the deceased husband in accordance with law, which cannot be denied at this, by any stretch of imagination. In that light, the following order allowed mandamus issues to the quashed mandamus issues to the respondent to consider the case of Nivedira.
My name may be deleted. Earlier
he has filed it. Union of India.
Right. The so-and-so. Allowed quashed a mandamus issues to the respondent to settle the terminal benefits of the deceased husband in accordance with law, at any rate within 8 weeks from the date of receipt of the copy of the order, ordered accordingly. Please, next.
Nemo.
First, separate order sheet Madi. The registry to delete the name of Shivraj Balluli as appearing for the respondent. Pleasure.
Lordship, second respondent, Lordship, issued a notification, Lordship,
Lordship,
for
kindly
appointment
day
of
after tomorrow.
Anganwadi teacher, Lordship.
Kindly
Anganwadi.
day af- Please, your lordship.
By reserving,
appointment ಯಾವಾಗ ಆಗಿದೆ?
ಅಲ್ಲ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರಿ ಸ್ವಾಮಿ. ಬೈ ರಿಸರ್ವ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇನ್ನೂ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. By reserving the post for SC community, Lordship. In the Bommasagar Karyam camp, Lordship, there is no SC families, Lordship. For that reason, Lordship, petitioner made a representation, Lordship, for changing the reservation, Lordship. Instead of SC community, it is reserved for backward community, Lordship. That representation not considered by the respondent authority, Lordship.
Lordship,
ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? Because Anganwadi notification is square, the
Please, your
population of SCs.
ಹೌದು. On the last occasion, as per my instructions, your lordship directed me to verify how many families are there.
That is
So
the order.
please, your lordship.
ಏನು ಇಲ್ವಾ?
I have not yet received, your lordship.
Learned HCGP seeks 10 more days time to comply with the order dated another, on 19/9/2025, which had directed the population of SCs to be placed on record by the learned HCGP in the area in which the Anganwadi Kendra is situate. The learned list the matter on 18th in fresh matters list.
Please.
Yes.
Number 12, Srinivas Desai. V. Raman.
Sir, writ of mandamus directing the respondent number 4 to.
Mandamus kilidoyta principal alva.
Please promote.
In connected matter, my lords, we have questioned the endorsement issued by the authority.
Bari mandamus saka.
Please.
In charge principal.
Please.
Yes. The only ground urged is that, my lords, no reasons are assigned in the endorsement for not approving the.
Consider representation. This we will direct consideration of representation, not a problem.
Short synopsis, Your Lordship.
Consider representation as synopsis.
No, this endorsement is challenged in the connected.
All right, we'll dispose this.
Please.
The petitioner is before this court seeking the following prayer. Though the learned heard the learned counsel sounds. Though the counsel for the petitioner would seek to project several grounds urged in the petition, would finally restrict the prayer for consideration of a representation dated 5/9/2024 submitted to the respondent, submitted to the official respondents.
Four.
Respondent. In the light of the said submission, I deem it appropriate to dispose the subject petition with a direction to the respondent to consider the representation of the petitioner and pass necessary orders in accordance with law. Yes. Now come to the connected matter. Adu neevena?
I appear for the petitioner in that matter, my lords.
Yes, madam.
Let's communication dated 29/4/2022 is challenged before this honorable court. My appointment was sent for approval, my lords, and the authority second respondent has issued the communication. The
Yeah.
only.
Approve ಮಾಡಿ.
Approve ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ. ಮತ್ತೆ ಅಷ್ಟೇ ಇನ್ನೇನಿಷ್ಟು.
Date of events, I have appointed in 2004. He is appointed.
Gayatri madam has fairly said what is this.
ನಮ್ದು ರೆಗ್ಯುಲರ್ ಪ್ರಮೋಷನ್ ಅವ್ರದ್ದು ಇನ್ಚಾರ್ಜ್.
ಆಯ್ತು ಸರಿ, ಏನ್ ಕೇಸ್ ಇಲ್ಲ ಬಿಡಿ. The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner, idyadu 102
104205.
104205 ಅಂತ ಇದೆ, ಅದು ಯಾವುದು?
Yes, that is the certiorari.
ನಿಮ್ ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲ ಹಳೇದಿರ್ತಿದೆ ಇಲ್ಲಿ. Dates are same, is it?
Same, both.
The petitioner is before this court seeking the following prayer. They heard so and so. Tracing the history of the rights of the parties in the present case is unnecessary. Therefore, it would suffice if the narration would begin from 21/10/2004, when the petitioner in writ petition 102-616 of 2025 comes to be appointed as history lecturer against a backlog vacancy in the fourth respondent institution. The state is said to have issued certain guidelines for promotion to the post of principal of a pre-university college. The guidelines are dated 20th January 2012. The fifth respondent, the petitioner in the companion petition, is appointed as a Kannada teacher in the high school run by the fourth respondent, owing to retirement of one T.S. Bijapur, who retired on attaining the age of superannuation on 29/2/2020. The fourth respondent is said to have later promoted the fifth respondent to the post of lecturer in Kannada and is posted to the Kannada in the said institution. The promotion of the fifth respondent to the post of lecturer in Kannada is said to have been approved by the department. On 4/12/2022, when G.S. Bijapur, the senior most lecturer who was working as a principal, retires on attaining the age of superannuation. On the retirement of the said incumbent, it transpires that the petitioner was placed as in charge principal and the said placement was sent for approval to the hands of the state. The state has denied approval on the score that the petitioner was only an in-charge principal and could not be directed to be granted directed to be granted the post of principal on officiating basis. The learned counsel appearing for the petitioner Gayatri SR, though
My senior name may be shown.
Mallikarjun Swamy.
Yes.
The learned counsel appearing for the petitioner Mallikarjun Swamy Hiramad, though would seek to project several grounds. The facts are undisputed, as the petitioner was always an in-charge principal, in contradistinction to what the ನೀವು ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದರಲ್ಲಿ ಇಲ್ವಾ? In contradistinction to what the petitioner was in the companion petition. In the light of the approval being rejected by the state, which is in tune with law, as the petitioner had not gained the eligibility of being appointed as a regular principal, an in-charge principal cannot claim that the approval of the non-approval of his appointment as a regular principal is contrary to law. In that light, the petition does not deserve any indulgence at the hands of an in-charge principal who becomes an in-charge principal only on 4/12/2020. ಯಾವತ್ತಾಗಿದ್ದು? 8/2/2022. Finding no merit in the petition stands.
Number 13, Salma.
Not parole. Recommended for premature release, Your Lordship. 302.
Where are you, madam?
Office, Your Lordship.
ಕಾಣ್ತಾನೆ ಇಲ್ಲ? ಎಸ್. ಇಲ್ಲರೆ ನೀವು ಕಾರು ಪಾರ್ಕು ಎಲ್ಲದಿಂದ ಬರ್ತೀರಾ?
Your Lordship, High Court ಅಲ್ಲಿ ಇದ್ದಿದ್ದು, Your Lordship, all the police.
Yes. The petitioner is before the
302.
The petitioner, who are you, mother?
Wife, Your Lordship.
The wife of the convict is before this court seeking release of the convict on grant of parole. Heard so and so. The son of the petitioner, husband of the petitioner gets embroiled in a crime and gets convicted of the offense under section 302 of the IPC in SC 378 of 2011. The petitioner is said to be in prison for the last 15 years.
10 years, 7 months, Your Lordship. 10 years, 7 months.
How are you recommended?
Your Lordship, I have moved the memo, Your Lordship. Memo with documents. They have recommended, Your Lordship. 12 years ಆಗಿದೆ. Parole ಅಲ್ಲಿ ಆಚೆ ಹೋಗಿದ್ದೀರ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 11 years.
The petitioner has now been in prison for close to 12 years. It is the case of the petitioner that the husband's name has been recommended and to be placed before the committee for consideration of premature release owing to his conduct. The said fact is not disputed. In the light of the coordinate benches or this court granting parole to all those persons whose cases have been recommended and pending before the committee, I deem it appropriate to grant the petitioner, husband of the petitioner release on parole for a period of 60 days, reserving liberty to seek its extension owing to the conduct of the petitioner while outside the prison on such parole, with the following. Yes, next.
Number 14, K. Raghavendra Rao, PV Gunjan.
Nennedu. Yes, madam.
Yes. Plus, petitioner must join the services in Hotspot Millards City Cooperative Bank in the year 1973. He retired Millards on 30/6/2008 after rendering the services for more than 35 years. Plus, his last drawn salary was 16,582. Your Lordship, kindly Millards peruse annexure F as per annexure F. Then, as per annexure G, Millards, he opted for, his original pension was 2,689 was fixed. He opted for commutation. In view of that, because it was fixed at 1,614.
15 years ಆದ್ಮೇಲೆ ವಾಪಸ್ ಮಾಡಿಲ್ವಾ ಅದನ್ನ?
15 years admele, then I sought for restoration in 23. That restoration has not been done. Instead of that, when I sought for details of the amount they have deducted, they say Annexure M is issued by respondent number 2 saying that they have not maintained.
The only grievance.
And they have reduced it to 948.
The grievance of the petitioner is that her pension has not, his pension has not been restored to the original.
Commuted value of
Commuted
pension
value has
15 years
not-
ಆದ್ಮೇಲೆ
and then,
original value you have to
In fact,
restore it.
it's the case of the respondent that it has been done. However, in the
No,
meanwhile,
one
as.
minute.
Yes.
Commuted value of pension ತಗೋಬೇಕಾದ್ರೆ it was fixed as 2,689.
That was
All
early,
right.
yes, my lord.
You can't restore it to 900 rupees.
In the meanwhile, my lord, there was a direction of the Honorable Supreme Court wherein it said that higher pension shall be paid only where the contribution was based on the actual salary drawn by the.
Actual what?
Actual salary drawn by the employee.
Actual
Because
salary ಎಷ್ಟಿತ್ತು?
The contributions are taken on the basis of the salaries drawn by the
When
employee.
was the judgment of the
Earlier,
apex court?
earlier, my
When
lord.
was the judgment of the apex court?
That was in 2022 November, my lord.
You retire ಆಗಿದ್ದು ಯಾವಾಗ?
In 2008, my lord.
8.
In fact, the
So
Honorable
apex court
Supreme
said
Court
you
has said-
exhume all
Honorable
that has
Supreme-
been concluded?
No, Honorable Supreme Court has said that where an employee has retired before 2014 without exercising option for paying, contributing
Is
on.
that judgment?
That is Sunil Kumar, and I have not produced that. The Sunil is a well-known judgment in SLP number 8.
No, where is the judgment? If you're relying on something, you should produce it or get it.
Just, there was one important, this one in that, saying that only persons who have exercised their option along with the employer will be entitled to such higher pension. my lord.
Where is the judgment?
In that, in this case, there is no such
Then-
option exercised.
Then you should be entitled.
So she is not entitled to, he is not entitled to, for the reason that he had retired much before 2014, in 2008, without exercising option. And
Judgment
moreover, he
is-
has also
ನೀವು
not,
ತಂದಿಲ್ವಾ
he has
judgment?
he has also not
ಅವ್ರೆ-
contributed.
ಒಂದ್ ನಿಮಿಷ. You also don't have the judgment?
But it's quite a.
Quite ಅಲ್ಲ ಇಲ್ಲ. Where is the judgment?
Because I don't have this. I'll have.
In fact,
citation ಹೇಳಿ sir. ಯಾವ್ದು? Where?
Shortly, because it's a very lengthy judgment, I thought it may not be necessary. Only one paragraph very specifically mentions that what are the conditions which have to be fulfilled for opting.
What sort of submissions? You rely on a judgment, you don't get it, saying it's
Then,
very lengthy.
Sorry, I mean, because that was, I never thought that would be the issue here now. And moreover, it has been restored as
Over
per,
ಇಲ್ಲ,
as
nothing
per,
is over.
as per response,
Yes.
as per Annexure R4, which I have produced. He has been.
I will direct restoration completely if you don't give the judgment.
I
Along
will
with
furnish,
interest,
I'll-
costs and
I'll
everything.
furnish it, madam.
Yes.
I'll furnish it.
Tomorrow.
No, not tomorrow.
Take a judgment.
No, I'm not here for next 1 week.
You are not the?
I am not here, madam. So after 17th, madam.
You are not here.
I mean, personally inconvenience, I may not be here on, from 17th, madam.
List the matter on 18th in
I'll certainly furnish the.
fresh matters list. ಅವತ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ I will allow
I
everything.
will certainly comment, and I'll also furnish.
With
and
costs
also,
and,
I'll also.
Costs and interest, take it to the
I will,
Supreme Court.
I will try to convince the law to show that it has been restored, subject to the condition imposed by the
Restoration
Honorable
cannot be
Supreme Court.
worse off, sir. Yes.
Yeah, because of the direction.
2,500
of the Supreme-
commuted
because of the
value
direction-
fix
that
ಮಾಡ್ಬಿಟ್ಟು
has come down
restoration
because it
900
has
ರೂಪಾಯಿ
been-
ಮಾಡಕ್ಕಾಗದು. What
that
sort
has
of
come- that has
judgment
come-
can never be what you have interpreted? Yes.
No, it's only because of the directions.
No,
by the
no,
Honorable
sir.
Supreme Court,
It
which
can
say
never
that
be what you
how
have
it has to be
interpreted.
worked out. It is not that
Nothing
I have
will-
done it on
We
my
will take
own.
care of the judgment. Get it first.
And in between, my lord.
ಅದರಲ್ಲಿ ಯಾವ
in fact,
party name ಹೇಳಿ?
In fact, in 2014.
Party name
without
ಹೇಳಿ
any-
sir.
Without.
Judgment party name ಏನು?
Yes, madam.
Volume.
In whose case did the apex court write so?
In, so the general, I mean, for higher pension, how pension has been.
In whose case? Title ಇಲ್ವಾ ಅದಕ್ಕೆ?
And Sunil Kumar's case, man. Sunil Kumar B. Sunil Kumar B, that's a citation, my lord. Employment Provident Fund versus Sunil Kumar B, my lord.
Enforcement?
Employment Provident Fund.
EPF
Organization.
versus
EPF
Sunil Kumar
versus
B.
Sunil Kumar B. SLP, man. It's in an SLP.
ಎಲ್ಲ SLP.
I will, it was reviewed and then the court has held so. I will furnish, my lord. And moreover, in 2014, the respondent had increased the pension of the petitioner without any application being made, without any representation, for the reason that they found that he was entitled to. Then that was taken as a
You have
granted.
been very
When
magnanimous.
when it was increased by the respondent on its own accord, it was taken as a gratis and it was enjoyed. Now, that is what I mean. No application was made, no reference was given. When the organization found that he was entitled to a more pension, that was also granted.
We will answer what
back
is.
pension was also.
We will answer what is greatest, get the judgment first.
I will get it.
Yes,
20,
next.
17, 18 years, madam.
Petitioner
Silver?
challenging the notice issued by the first respondent police.
Externment.
First respondent police, the police station.
Notice?
Notice, and they have issued the notice directing the petitioner to furnish the information regarding the supply of sugar cane to the second respondent sugar factory. The second respondent sugar is the complaint, has filed complaint against its employee, stating that its employee have misappropriated the sugar cane quantity.
Crime register madidara?
Crime register against the employees, not against these petitioners, farmers. But after the lapse of 2 years, farmers, these are all farmers, they have supplied the sugar cane to the sugar factory.
In investigational information, Kodi.
I will furnish when it.
So what's the problem? Why have you filed this petition now?
My case is since the entire information to the sugar factory only, but the entire details and waybill receipts.
ನಿಮಗೆ ದುಡ್ಡು ಬಂದಿಲ್ವಾ ಅಲ್ಲಿಂದ? ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿಯಿಂದ ದುಡ್ಡು ಬಂದಿಲ್ವಾ?
In the year 2021-22 they
ಬಂದಿದ್ಯಾ?
ಬಂದಿದೆ.
ಅದು ಕೊಡಿ ಅಷ್ಟೇ.
Will furnish within 15 days. But in the meantime, the first respondent may be directed to not to take coercive step against the petitioner.
ನಿಮ್ಮ ಮೇಲೆ ಯಾರು coercive step?
That cannot be met. It's already dead. 482 petition was filed. But this honorable court has said investigation, it's a matter to be investigated. But they have issued witness notice. They have to go and tell either they have the
petitioner is before this court seeking the following prayer. The petitioners claim to be farmers. Against the sugar factory or its employees alleging certain misappropriation of funds as funds, a crime in crime number 183 of 2022 has been registered for offences punishable under section 408, 420, 465, 468. Read with 34 of the IPC. The learned counsel for the respondent, Srinath Pachapuri, submits that the coordinate bench has quashed a stayed.
No. Dismissed, lords. The proceedings and directed to investigate the
coordinate
matter.
bench has rejected the petition filed by accused
persons.
By the accused. The petitioners herein are not the accused, they are farmers who are being called by the police for the purpose of investigation. The investigation is on. It is needless to, investigation is on. It is trite that the witness or whoever is called for the purpose of investigation cannot file a petition. Stalling such investigation being conducted, that too in the teeth of the criminal petition filed by those accused being dismissed. In the light of the said circumstance, while observing that the petitioner farmers should not be unnecessarily harassed, I deem it appropriate to dispose the petition with a direction to the investigating direction to the petitioners to cooperate with the investigation. Please.
Great. Cannot take in but coercive steps. Or they are threatening to seize the vehicles of the farmers. Tractors seize threatening ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಇದೆಲ್ಲ ಮಾಡಿದ್ರೆ 482 ಹಾಕಿ ನೀವು ಅಂತ. ಎಲ್ಲ ಬನ್ನಿ ವಾಪಸ್. ಹೇಳಿಲ್ವಾ? Not to in the garb of investigation.
Please.
Number 16, Anandarpalli. B. Shivraj Hiramant.
Please, Lord.
Where were you yesterday, sir?
Some
You have to go before the tribunal.
No.
No, illa. I want to pass an order. Deputationist.
No, Lordship.
Parent cadre ಯಾವುದು?
She is appointed as FDA, Lordship.
Where?
ಹೂವಿನಡಗಲಿ, Lordship.
ಹೂವಿನಡಗಲಿಯಲ್ಲಿ ಅಲ್ಲ, ಯಾವ ಆಫೀಸಲ್ಲಿ ಸರ್?
ತಾಲೂಕ್ ಪಂಚಾಯತ್, Lordship. ಹೂವಿನಡಗಲಿ ತಾಲೂಕ್ ಪಂಚಾಯತ್.
ತಾಲೂಕ್ ಪಂಚಾಯತ್
Midday scheme under the she is working. Midday scheme, Lordship. She is under working.
Yes, Shivraj Hiramant.
Blood is a Group C employee,
So?
government employee.
So?
Blood.
You said is a deputationist from the government.
Milord.
School ಇಂದ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಇಲ್ಲಿ.
Milord, kindly see. The lien has been under.
You are from the education department ಅಂತ ಹೇಳಿದ್ರಿ.
Yes, Milord. Lien has been sent to.
Lien ಬಿಡಿ sir. Now, where was he substantially appointed at the outset?
Milord.
Panchayat or what?
Milord, it is appointed by the government.
in the office of a Taluka Panchayat, he is a government employee.
Don't tell me all this. He's an employee of the Taluk Panchayat. All right? Yes. This court on 3/11/2025 had passed the following order on the submission made by Shivraj Hiramat. The petition is not to be, the petitioner is not to be relegated to the Karnataka Administrative Tribunal, as the petitioner is appointed, albeit by the state, to in the Taluk Panchayat. Therefore, he is an employee of the Taluk Panchayat, and against employees of Taluk Panchayat, the petition, writ petition would be entertainable. Anything else? What's the matter?
My lord, it has been exercised under Rule 10 of KCCR rules.
Rule 10 of suspension.
Suspension order.
KCCR alla sir, KCSCCA.
KCSC.
Yes, sir. What's on the merit?
Blood, I have not been served the copy of a writ petition.
Interim order diya.
Notes.
The petitioner to serve set of papers upon the learned counsel Shivraj Hiramat forthwith. List the matter on 17th in fresh matters list.
Please.
Yes, next.
17, Afshan Abdul Aziz, Sanjay's category.
Lord, I filed
My
the.
lords, case, my lords. The petitioner have come before this honorable court to set aside the terminated
Set aside
Application
the cost
notice
that
for
terminate the
tender.
ಯಾವ್ದು ಮಾಡ್ಬೇಕು ಹೇಳಿ. Set aside ಮಾಡ್ಬೇಕಾ, cost ಮಾಡ್ಬೇಕಾ, terminate ಮಾಡ್ಬೇಕಾ?
Quashing of termination.
Caution of
notice,
termination.
tender
Why were
of-
you terminated?
My lords, I'll go for brief, my lords.
You'll-
Brief, I'll go. my
ಆಯ್ತು,
lords.
brief ಆಗಿ.
Yeah, petitioner is doing tender work through GEM portal bidder since more than 40 years from time to time, my lords. And since 2018, registered GST in and
You
working.
have retired now.
No, he's
This
working,
matter
my
ended.
lords.
This tender
Under
matter,
the
in fact,
respondent
was
Interim
allotted.
matter, yes.
It was
For good
allotted.
transport service, collect the mails parcel and to the Belgaum city and contract basis and leaving his livelihood with this work only, my lords. The respondent number 1 issued a notification inviting the tender through GEM portal bidder on 17/10/2024 for good transport service, collect the mails parcel from the postal department and distribute in among the Belgaum, my lords. Petitioner applied for the said tender and participated and qualified, my lords. Due to the bona fide impression, petitioner did not intimate the active GST in, my lords. On 16/1/2025, he got to know that his GST is not activated. So he has intimated the same to the respondent number 1 by letter dated 16/1/2025, my lords, at Annexure C. And subsequently, after obtaining the GST, he has intimated the same Annexure C1 at page 27 on 23/1 within 7 days, my lords. The respondent, after going through the entire documents on records, he has selected and elected the selected and he has made the qualified on 31/1/2025, my lords. And as per that, he got the contract and he is rendering his service from 2024, February 2nd, February 2024 till today. He is working and he is rendering his service and he is taking the bills and the respondent number 1 is giving payment also.
Yes. Now come to Annexure L, page 45.
Yes.
This is the reason for termination.
Yes, a notice was issued to him. Notice was
That's all
issued.
right. This is the reason
Yes.
for termination.
Yes, he did not have
Since you have
the.
uploaded, deactivated, cancelled
Yes,
GST number.
Yes.
Now GST number is active or cancelled?
Yes, as on that day, when he participated and entered into contract, my lord, he was not having active GST number.
When did it get activated?
Active, my lord, subsequently, he got it on
23rd.
He got it on, GST number is on, he says 7/4, after the contract, my lord, in fact, he got it. Your lordship, he have produced that annexure itself only, where it says, but now only the question is that, my lord, whether he participating without active GST number, whether a breach of contract, on that basis itself is the issues itself. Lordship, the annexure which he has produced, page annexure C1, my lord, it is on the date it is not disclosed properly, but it says,
23/1/2025, he has submitted the activated GST.
Lords may
ballot.
get at page
After that
27,
only
my lord.
they have,
27, my lord. After entering into
What was the date of the tender?
date of tender, it's, my lord, is 5/11/2024. Evaluation was carried out.
5/11/2024.
my lord. And his tender bid was accepted, your lordships.
Where is the tender condition?
Yes, 11/11/20, it is there. my lord.
Tender condition.
Yes, kindly see the sanction order, annexure R5, page 16, my lord. The sanction order. It is 1 day prior to his intimation itself, my lord. In my statement of objection is there. Page 16, my lord, annexure R5. In that, your lordships may kindly see the condition, termination of contract, page 22, my lord. Clause 11, in that second one, my lord. In fact, I have extracted itself, my lord, in my objection.
Early
but I-
second one, ಹೇಳಿ sir, ಆಮೇಲೆ.
Yes, ma'am. Breach of contractual obligation. Any incident considered as a breach of contract with results an immediate termination of service, if the buyer shall have the right to.
ಆಯ್ತು, ಈಗ GST ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ?
It was the GST has to be
that
deduction,
is-
everything, my lord. Because now in view of the GST number.
All right,
being
all right,
out.
yes.
Yes. And now, my lord, even there is an arbitration clause in the agreement. That is also there in the, after executive agreement. That is page
ನನಗೆ ಎರಡೇ date
59.
ಕೇಳಿದ್ದು. Evaluation of tender ಆಗಿದ್ದು ಯಾವತ್ತು? ಇವ್ರ GST revive ಆಗಿದ್ದು ಯಾವತ್ತು?
My lord, he got revived after the 16/1.
Date ಇಲ್ವಾ?
16/1, my lord, after sanction order, my lord. He intimated.
after signing the agreement, my lord, but.
After signing the agreement.
But after that, they have approval, they have,
He says it is same
31
GST.
after submitting the activated GST, my lords, on 31/1/2025, they have selected me and they have hand over the charge and
Where are those documents?
at page 28, my lords. Annexure D, my lords.
This is 31/2025.
Yes, my lords.
GST was revived by then?
Yeah, 23rd I have given, 23rd January I have given, and 31st they have passed the order, my lords. With reference to the subject cited above, it is.
Please don't read, madam. I will read. Yes. Yes, sir.
My lord, as on the, when he participated in the bid.
Where did you give it?
My lord, it was not the
Where did you
acquisition.
give it, sir?
No, it was, he gave we did not verified in the GST portal.
Why did you not verify?
Yes, my lord, but it doesn't mean that we have acquiescence of this.
No, after this, sir.
After
23rd revival, where is the representation given?
23rd January.
Which annexure?
Annexure C1, my lords, page 27, my lords.
ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ?
That he
You
said.
need to update your GSTN for getting the order above 40 lakhs. ನೋಡ್ತಾ ಇದ್ದೀರಾ?
That in these, my lords, the office location and the through mail they have taken that, my lord, and deactivated I have given, and they have.
Deactivated ಎಲ್ಲಿದೆ madam ಇಲ್ಲಿ?
Deactivated.
You need to update your GST for getting the order above 40 lakhs.
Yes, my lord.
All right, what date is this?
Lordships, we have produced that one. Annexure, page 64, annexure R8, man. R8, man, page 64. The petitioners, my lord. Cancelled on applicable GST with effect from 1/5/24. He got activated.
Effective from 1/5, cancelled on application of GST tax.
Yes, he says he was not having turnover, so he got himself cancelled. Our only intention, as on the date of participating at bid was and sanction order, he was not having the
Foresight, my
activated
lords.
GST number.
But activate ಮಾಡಿದಾರಲ್ಲ even before,
Subsequently
even
got it.
before the work order is issued, it is activated.
Yes, ma'am, that
Correct?
of course.
Anything else?
And 1/4 fact, my lord, the terms and conditions which your lordships may kindly see next page 63, which we, page 62, my lord, in that one. Page 62, he gave an undertaking that if any false information, that is on 411 prior to, after bid was accepted, my lord.
Why did you give, sir?
No, that the.
Why did you give the contract?
In fact, we did not verify. Subsequently, GST portal was verified. Then it disclosed that he participated without active GST number.
Why you did not verify it earlier? But the whole problem is, if it were to be a big, at the beginning, it's a different thing. You already awarded the contract to him.
Yes.
He has begun to execute the contract.
Yes.
Then GST is revived, that representation is given to you. Then looking after that, only 31/1/2025, you pass and issue work order to him.
Yes, in fact, subsequently annexure 9, it was verified through legal things, my lord. Page 65.
As on the date of submission of the bid and scrutiny of the documents, admittedly, definitely, he did not have.
Yes, ma'am.
All right.
Yes.
He participates. So he had withdrawn from GST because of his turnover. It's not that he had defaulted and they had cancelled. Now it is revived later.
Yes.
You look into that revival and then pass this order.
That would.
ಸುಮ್ನೆ ಹೆಂಗ್ terminate ಮಾಡ್ತೀವಿ?
No, it was still he is having 2 years the contract. He completed half 6 months itself.
9
So
months
it
has
should not be the.
ನೀವು ಸುಮ್ನೆ ಇರಿ madam. Yes.
It should not be the reasons for other ones to take that things, my lord. Now GST being.
Other ones ಬೇರೆ, we will hold
Yes.
that yes, it was not correct of the petitioner to participate without it, but he has
Yes,
got
your
it
lordship.
revived, and after revival only everything is done.
Yes, the department should have verified, but with a bona fide belief that it is having a activated GST.
Anyway, today it is there.
Yes, it is there, Mel. In fact, I would say one more that arbitration clause is there. But agreement provides for it.
Anyway, the petitioner is before this court seeking the following prayer. The petitioner is said to be in petitioner is said to be in the business of distribution of post parcels through the GEM, which arrive through the GEM portal. A notification comes to be issued by the first respondent on 17/10/2024 for goods and transport service. The petitioner, finding himself eligible in terms of the said notification, applies and is emerges as the successful bidder, and their contract is awarded to the petitioner. Long after the petitioner begins to execute the contract, i.e. for about 9 months, the respondent is said to have realized that the petitioner at the time of participating in the tender and the scrutiny of the documents did not have a valid GST, as the GST that was in his possession had been withdrawn on the volition of the petitioner owing to the turnover. Thus comes the order of terminating the contract against the petitioner. The petitioner is driven to this court on the said order of termination of the contract. The learned counsel appearing for the petitioner would contend that the termination of contract could not have happened notwithstanding the could not have happened in the light of the fact that the GST, as on the date of work order being issued, was revived, and the revival of the GST was brought to the notice of the respondent department. The learned counsel would take this court through the documents appended to the petition. The learned counsel Sanjay Katkari, appearing for the respondent, would vehemently refute the submission in contending that as on the date of issuance of the scrutiny of the documents and issuance of the scrutiny of the documents and participation in the tender, the petitioner admittedly did not have the GST. In that light, no fault can be found with termination of the contract as termination of the contract. The learned counsel would further submit that there is an arbitration clause for dispute resolution between the tenderer and the tender inviting authority, and therefore this court should not interfere on all the aforesaid facts. I have given-
Termination,
huh?
and termination clause in the sanction.
And he would further submit that there is a termination clause in the contract itself. If the tenderer would have misled the tender inviting authority and secured a tender. I have given my source. Therefore, narrated facts are not in dispute. The tender is invited. Well, the tender?
Next.
Page
17/10/2024.
70?
10/2024.
Annexure 8,
Annexure A, my lord.
page 17.
Page 70.
The tender is invited for the following purpose. Page 17. The petitioner participates in the tender.
411.
The GST of the petitioner was admittedly not available on the said date. The tender scrutiny happens, and it was indicated to the petitioner that if the petitioner would want to have a order beyond 40 lakhs, the GST would be a must. Therefore, the petitioner gets the GST reactivated on 16/1/2025. The reactivation of the GST is brought to the notice of the respondent. After bringing it to the notice of the respondent, the work order is issued in favor of the petitioner on 31/1/2025. The work order so issued reads as follows, page 28. Therefore, the respondent tender inviting authority was completely aware of the fact that the work order, aware of the fact that the GST had been revived and the work order was thus issued. Notwithstanding the same, after about 9 months of execution of the work comes the impugned order. Impugned order reads as follows, page 45. The impugned order puts the clock back on this and terminates the contract on the score that the GST uploaded by the petitioner on the date of submission of the bid was a deactivated or a cancelled GST. The said reactivation, as observed herein above, has been submitted to the respondent, after which being completely aware of the fact that the GST has been revived, or a number GST has been revived, GST of the petitioner has been revived, award the contract. After having scrutinized all the documents and awarded the contract, it was not open to the respondent to put the clock back to the date on which the petitioner had submitted his bid and cancel the terminate the contract altogether after about 9 months of its execution. The submission of the learned counsel for the respondent that the petitioner has misled the tender inviting authority at the outset would have merited acceptance if the respondent themselves after noticing the revival of the GST would not have awarded the contract. The contract is awarded with eyes wide open by the respondents after scrutinizing the entire documents. Therefore, now it is too late in the day for the respondents to contend that at the time when the bid was submitted, the GST was not available. GST being in place, long before the issuance of the work order, cannot now place the petitioner worse off for termination of the contract. In that light, the petition the other submission of the learned counsel is that there is an arbitration clause, and therefore the petitioner should be relegated to resolve the dispute before the arbitrator. The said submission also is unacceptable. The petitioner, the contracting party, the respondent, the contracting party is a state under Article 12 of the Constitution of India. A contracting party, if is shown to be behaving in the manner that it has, which on the face of it would become arbitrary, it cannot be said that the petitioner should be relegated before the arbitrator to raise an arbitration for a dispute of termination of contract within 9 months of its execution, that too on the score of non-availability of the GST at the time when the document was submitted. It was always open to the petitioner, to the respondent, to have scrutinized the documents and rejected the tender. After having accepted it, And before the work order being issued, GST being in place, the termination would become arbitrary. In that light, the petition deserves to succeed, allowed, quashed.
Another one submission.
Matten, madam.
No, my lords, that date is 23/1/2025, that GST activity. It has come 16, my lords.
23.
Please.
ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ? ಸರಿ.
80, PC Chaklapi, C Jagdish.
I appear for the respondent.
Petitioner has been appointed as a primary school teacher, my lord. My lord, and also the petitioner
Then
submitted the,
appeal ಹೋಗ್ಬೇಕು on wrong form.
my lord, may I take the attention, my lord? Circular, my lord. My lord, page number, my lord. Page number
May I
15.
submit? He is migrated from Maharashtra. Veer Singh is against him. Even if the contention is no notice was issued, even if the notice is issued, my lord, in the light of Veer Singh's case, he cannot maintain the
Page number 59, my lord.
Migrant.
No, my lord. No.
migrant. ಒಂದೇ ನಿಮಿಷ
As per the observation of the committee, my lord, he is migrated.
Annexure G ತಗೊಳ್ತಾವ್ ದಯಮಾಡಿ.
Gulbarga district, my lord. Only grandfather has.
Annexure G ಅವರೇ ಒಪ್ಕೊಳ್ತಾರೆ. ಮಹಾರಾಷ್ಟ್ರದವರು ನಾವು.
Cousin brothers have taken the government service, my lord, under SC/ST category, my lord. Cousin
Page
brothers.
56 ತಾವು ನೋಡಿ ಸ್ವಾಮಿ.
Page number 59, my lord. There is page number 59, may I kindly look at it.
18th in preliminary hearing.
My lord, there is.
ಅಲ್ಲ 56 ಅಲ್ಲಿ
it's list finalized ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Therefore, my lord, ಇದು primary school teacher list, my lord.
ಎಲ್ಲಿದೆ?
Page number. Therefore, I filed the application, my lord.
What application?
Interim stay application.
Interim.
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಯಾರು ಫೈನಲೈಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
The final selection list, my lord, page number, my lord, 52, my lord. She's serial number 4, my lord. My lord, I'll submitting the, my lord, there is a circular, my lord, to give the opportunity, my lord, even though they have not issued any notice, my lord. Next is circular, my lord.
ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
My lord, they have held that, my lord, I migrated from the Maharashtra, my lord. Page number, for moment, page number 59, may kindly be looked at. Serial number 3, my lord.
Impugned order.
Page number 12, my lord.
Circular.
Circular, my lord.
ಅದ್ರಲ್ಲಿ ಯಾವ
DCBC ಆರ್ಡರ್ ಮಾಡಿ.
3, my lord. Page number 59, my lord.
ಅರ್ಜಿದಾರರು ತಮ್ಮ ಹೇಳಿಕೆಯನ್ನು ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸುವ ಅವಶ್ಯಕತೆ ಕಡ್ಡಾಯವಾಗಿ ಅವಕಾಶ ನೀಡತಕ್ಕದ್ದು. ಈಗ ನಿಮ್ ನೋಡಿ ಏನು ನೋಡಿ?
No, nothing, my lord. Nothing.
Where is the order impugned?
Page number 12, my lord. Impugned order, my lord.
DCBC.
Please, my lord.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ ತೀರ್ಪಿನ ಪ್ರಕಾರ ಇವರು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪರಿಷತ್ ಮೈಗ್ರೆಂಟ್ ಅಂತ ಹೇಳೋದು.
Migrant ಅಂತ ಮಾಡಿದ್ದಾರೆ. And grievance is settled, I will submit all the document before the committee, my lord.
The petitioner.
ಅಲ್ಲ ಒಂದೇ ನಿಮಿಷ ತಾವು.
ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ನಾನು ಮಾಡೋದೇ ಇಲ್ಲ. Yes, nothing I will hear. ನೋಟಿಸ್ ಕೊಟ್ಟು ಮಾಡಿ. Basic.
Please, my lord.
The
ಅಲ್ಲ
petitioner.
admitted fact ಇದೆ.
ಅಲ್ಲ even then admitted fact ಅಂತ ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದಾರಾ? ನಿಮ್ ಪ್ರಕಾರ
ಅಲ್ಲ
ಅಡ್ಮಿಟ್
ಅವರೇ ಎನೆಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ.
ಒಂದು ನೋಟಿಸ್ ಕೊಡಿ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು ಸ್ವಾಮಿ.
Petitioner is before this court seeking the following prayer. The petitioner heard sounds. The petitioner is a participant in the notification issued by the state government to fill up the posts of graduate primary teachers for class 6 to class 8. The petitioner emerges as a successful candidate and name is found in the provisional select list. The issue relates to the aftermath of the provisional select list. The district caste verification committee, without issuance of any notice to the petitioner, which is an admitted fact, cancels the caste certificate on the score that the petitioner is a migrant and has migrated from state of Maharashtra, and the benefit of being a scheduled caste would not be available to the petitioner in the state of Karnataka. The petitioner, on the strength of the cancellation, the appointment of the petitioner is now put to jeopardy. The learned counsel for the petitioner submits that if a notice had been issued by the district caste verification committee, the documents would be placed before it, and to justify the claim that the petitioner was not a migrant, and was entitled to the benefit of being a scheduled caste in the state of Karnataka. The learned counsel for the petitioner would also place reliance upon a circular issued by the state, which clearly indicates that without issuance of notice, no order should be passed against the persons by the district caste verification committee. It would not need a circular even. It is too rudimentary to observe that any person any order which entails civil consequences must proceed with issuance of notice and in compliance with the principles of natural justice. In that light, the petition deserves to succeed with the matter being remitted back to the hands of the district caste verification committee to issue a notice to the petitioner, secure the documents, and then pass necessary orders in accordance with law. For the aforesaid reasons, the following order: petition is allowed, so and so stands quashed. The matter is remitted back to the district caste verification committee, who would now issue notice to the petitioner and take the issue to its logical conclusion after considering the reply of the petitioner submitted furnished to the said notice, ordered accordingly.
Final list cannot be
Ordered accordingly. Yes.
Number 19, Abhinandan V.
ಅದು ಕ್ವಾಶೆ ಆಗಿದೆ ಮತ್ತೆ ಏನ್ ತೊಂದರೆ ಏನ್ ಸರ್?
The other day, my lords, your lordships had heard the matter, my lords. The petitioner's seniority was not considered since the disciplinary proceedings was
ಅದು
pending.
ಆರ್ಡರ್ ಮಾಡಿದಿನಲ್ಲ ಏನೋ.
Article of charges was not issued
You said no,
after
after
4
the
years.
promotion charges, article of charges were issued in 2021.
ಯಾವಾಗ?
2021 ನೋಡಿ. Nodi, he has made an application
2021.
for
Promotion is 2017.
2018.
18.
Nodi, he has made an application for nodi, representation to consider his case for promotion. Nodi, we will consider nodi within a time bound. Nodi, actually.
We will consider and he will come back to this court again.
ಅದೇ ಹಂಗೆ
Nodi, suppose if he is eligible, nodi,
What is eligible, sir?
because we have to see nodi, from what
DPC
date
was,
he is.
DPC was held.
Nodi, DPC is
kept in seal.
His case was considered.
Nodi, it was kept in nodi, sealed. Nodi,
Exactly. Sealed cover.
Because of inquiry.
ಇಟ್ಟಿದ್ದೇ ತಪ್ಪು. ಅಲ್ವಾ?
joint inquiry, nodi, 15 employees were involved in the
What to do,
case.
ಎಲ್ಲಿ ಡೇಟ್ಸ್ ಎಲ್ಲಿದಾವೆಲ್ಲ? ಏನು? ಸಿನಾಪ್ಸಿಸ್ ಅಂದ್ರೆ ಡೇಟ್ಸ್ ಅಂಡ್ ಇವೆಂಟ್ಸ್ ಏನಾದ್ರು
ಇಲ್ಲ.
ಏನಾರು ಒಂದು ಕೋಆಪರೇಟ್ ಮಾಡಿದ್ರೆ ಡಿಸ್ಪೋಸ್ ಜಾಸ್ತಿ ಮಾಡ್ಬೋದು. ನೀವು ಏನು ಮಾಡದೆ ಹೋದ್ರೆ ಹಂಗೆ.
I'll give it.
2 hours in I'm stuck with 20 matters because no assistance.
I'm ready with the
No
matters, my lords, but
synopsis, nothing.
I'll give it, my lords. I'll give it.
What you'll give it. ಹಿಂಗಾದ್ರೆ ವೆರಿ ಡಿಫಿಕಲ್ಟ್. ಇಫ್ ಡೋಂಟ್ ಕೋಆಪರೇಟ್ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಎಲ್ಲ ನಾನೇ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಆಗಲ್ಲ.
Let's
You should get the law. You should law ಬಿಡಿ ನಾನು ನೋಡ್ತೀನಿ. ಡೇಟ್ಸ್ ಅಂಡ್ ಇವೆಂಟ್ಸ್ ಅರ ಕೊಡ್ಬೇಕು.
ಇಲ್ಲ ಪ್ರಾಪರ್ ಫಾರ್ಮ್ಯಾಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಬಟ್ ಐ ಆಮ್ ರೆಡಿ, my lords.
ಅದಕ್ಕೇನು ಫಾರ್ಮ್ಯಾಟ್ ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ, I'll give it within 5 minutes, my lords.
Not correct. Been seeing since morning, zero assistance. ಯಾರು ಅಸಿಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಲಿ? ಎಲ್ಲ ಓದ್ಕೊಂಬಂದ್ ಮಾಡ್ತಾರೆ ಅವ್ರು ಏನ್ ಸುಮ್ಮನೆ ಆಗ್ಬಿಟ್ರೆ.
ಇಲ್ಲ, I am ready, my lords.
Yes, allowed cost. Not consider. I am not going to say consider. I am going to lay down the law and direct you to act in a particular manner.
Yes, nodi, yes. Nodi, the prayer is not direction to consider representation.
No problem. You will consider it in a particular way. This is not correct. Your judgment ತಂದಿಲ್ಲ ಈಗಲೇ ಮುಗಿಸ್ತಾ ಇಲ್ಲ.
Number 20,
ಸೀಲ್ಡ್ ಕವರ್ ಇಟ್ಟಿದ್ದು ಹೌದಾ? ಡೇಟ್ಸ್ ಕೊಡಿ, ಯಾವತ್ತು ಸೀಲ್ಡ್ ಕವರ್ ಇಟ್ಟರು, ಯಾವತ್ತಾಗಿದೆ ಎಲ್ಲ.
Please.
Yes.
Plus.
number 20, Archana Magdum, Pawan B. Togati.
In this case, no, is
Case
the
number 20, my lord. I beg to appear for my lord this one.
Please.
14 years.
14 years. Respondent KIDB.
Yes, sir.
Just for understanding the notification dates, my lord, I would like to pass on the. There are 2 writ petitions pending before this honorable court, my lord, that is WP 105222 and 105242. Wherein, my lord, the preliminary notification has been issued in 2 different dates. The first is on 28/5/2010, my lord, in the first case, and in the second case, my lord, on 7/11/2009, my lord. There was no notice issued to the parties, my lord, under section 28(2), which mandates that
Straight away 28(4) ಮಾಡಿದಾರ.
28(4), my lord. ಅವ್ರು ಏನಂತಾರೆ, in the year 2021, the land has been acquired for the purpose of BMEC company, my lord, for which there was a notification and the petitioner filed her objection.
To that
Only to that notification, and in under 28(4), my lord, her name was not forthcoming. And subsequently, my lord, they take all those objection to this particular notification, saying that she has already filed her objection, she has already been heard, and
This notification, there is no
No.
28(2),
No.
28(3).
No, my lord. Directly 28(4) was issued on 29/2/2024
After
and
14 years.
17/2/2024, my lord.
That's all the case?
Please, ma'am.
Yes, sir. Affidavit
Lord's
ಹಾಕಿದ್ರೆ
name.
explaining delay.
We have filed objections, my lord, in both the cases. Can I request, my lords, to kindly take, my lord, WP 105222?
I am there, sir. Ade.
Please, your lords. My lords, may come to page number, my lords, 14 of this objection statement. My lords, find the typed copy of this objection statement at page number 16 of this document, at page number 16, my lords.
28(3) ಯಾವ್ದು ರೆಫರ್ ಮಾಡ್ತಿರಲ್ಲ, ಯಾವ್ದಿದು?
28 ಅಲ್ಲ, ಇದು ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡು, they say that, my lord, the land is attached in by the ED and a Lokayukta investigation is going on and don't acquire this land is their stand. Kindly see, my lord, the page number 14, page number 14 of my objection statement in WP 105222, my lords.
Affidavit
R1 annexation.
objections ಯಾವ್ದು?
Objections are filed, my lord.
Page 14.
14 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಸ್ವಾಮಿ. ಇದು this objection is filed, my lord, I think on
page 14.
Yes.
ಹೇಳಿ.
Lord, typed copy is at page number 16. R1, my lord, is in petitioner's own handwriting, but typed copy you also may kindly see. ನಾನು ಶ್ರೀಮತಿ ಜ್ಯೋತಿ ಪ ಚೌಹಾಣ್, ಸಾಕಿನ್ ಹುಬ್ಬಳ್ಳಿ ದೀನಬಂಧು ಕಾಲನಿ 2ನೇ ಕ್ರಾಸ್, ಕಾರವಾರ ರೋಡ್, ಸಾಯಿ ಜ್ಯೋತಿ ಪ್ರಕಾಶ್ ಬಿಲ್ಡಿಂಗ್, ವಯ 61 ತಿಳಿಸುವುದೇನೆಂದರೆ, ತಮ್ಮ ಆಫೀಸ್ ನಿಂದ ಸರ್ವೆ ನಂಬರ್ 58/1, 58/2, 59/1, 59/2 ಮತ್ತು 81/4 ಈ ನಂಬರಿನ ಜಮೀನುಗಳನ್ನು ಕೈಗಾರಿಕಾ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುತ್ತೇವೆ ಅಂತ ನೋಟಿಸು ಬಂದಿದ್ದು ತಾರೀಕು 11/1/2022 ನಾವು ಅದನ್ನು ಸ್ವೀಕರಿಸಿದ್ದೇವೆ. ಈ ಜಮೀನು ಈಗಾಗಲೇ ಡೈರೆಕ್ಟರೇಟ್ ಆಫ್ ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಬೆಂಗಳೂರು ಝೋನ್ ನಲ್ಲಿ ಕೇಸ್ ನಂಬರ್ so and so ECIR 18 BZ so and so dated 26/10/2009 ರಲ್ಲಿ ಅಗೇನ್ಸ್ಟ್ FB ಚೌಹಾಣ್ ಅಂಡ್ ಜ್ಯೋತಿ ಎಫ್ ಚೌಹಾಣ್ ಇವರ ಹೆಸರಿನಲ್ಲಿ ಕೇಸು ನಡೆದಿರುತ್ತದೆ ಮತ್ತು ಲೋಕಾಯುಕ್ತ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಆಫ್ ಪೊಲೀಸ್ ಮತ್ತು ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸ್ ಠಾಣೆ ಧಾರವಾಡ ಠಾಣೆಯಲ್ಲಿ ಕ್ರೈಮ್ ನಂಬರ್ 5/2009 ಡೇಟೆಡ್ 7/7/2009 under section 13(1)(e) and 13(2) of the PC Act 1988 against FB Chauhan Hubli, case charge sheet number so and so dated 18/5/2013, filed by the Lokayukta Police Dharwad, filed FIR in crime number so and so dated 7/7/2009. ಈ ಕೇಸ್ Honorable Third Additional Chief District and Sessions Court ಧಾರವಾಡ ಇಲ್ಲಿ ನಡೆದಿರುತ್ತದೆ. ಹಾಗಾಗಿ ಸದರಿ ಆಸ್ತಿಗಳು ಕೋರ್ಟಿನ ಅಧೀನದಲ್ಲಿ ಇರುತ್ತವೆ ಎಂದು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಆಸ್ತಿಗಳನ್ನು ಜಮೀನು ಮಾಲೀಕರು ಮಾರಲಿಕ್ಕೆ ಹಾಗೂ ಯಾವುದೇ ಸರ್ಕಾರಿ ಇಲಾಖೆಗೆ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲು ಬರುವುದಿಲ್ಲ. ಹಾಗೇನಾದರೂ ಮಾಡಿದರೆ ಇದು ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗುತ್ತದೆ. ಆದ್ದರಿಂದ ತಾವುಗಳು ಈ ವಿಷಯದ ಬಗ್ಗೆ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಆಫ್ ಪೊಲೀಸ್ ಧಾರವಾಡ, ಲೋಕಾಯುಕ್ತ ಧಾರವಾಡ ಡಿವಿಷನ್ ಮತ್ತು ಡೈರೆಕ್ಟರೇಟ್ ಆಫ್ ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಬೆಂಗಳೂರು ಝೋನ್ ಆಫೀಸ್ ನಲ್ಲಿ ಈ ವಿಷಯದ ಬಗ್ಗೆ ಮಾಹಿತಿ ಪಡೆಯಬಹುದು. So it is incorrect to say that notice was not issued. Kindly come to the next document, which is a legal notice that was got issued earlier to that.
Shabrat sir.
Yes.
Why this beating around the bush? Wanted notification ಗೆ 28/2/28/3 ಆಗಿದೆ ಅಂತ ತೋರಿಸಿ. ಅವರು ಲೋಕಾಯುಕ್ತ ಇದು ಹೇಳಿದ್ರು ಅದ್ ಹೇಳಿದ್ರು. Where is your notice issued under 28 proceedings under 28-2, 28-3 to proceed to 28-4? That is all. You don't have to explain all this ಅದಾಗಿದೆ ಇದಾಗಿದೆ ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ?
ಅಲ್ಲ ಕೊಟ್ಟಾಗಿದೆ ಅಂತ ಅವರೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್
ಸರ್ ಅವ್ರು ಹೇಳದ್ ಬಿಡಿ. Where is your 28-2 notice ಕೊಡಿ ಇಲ್ಲಿ. Where is the annexure?
28-2 notice, since it was admitted by her, I wanted to just point
Not
out.
admitted, sir. You give me the 28-2 notice, 28-3 proceedings, then 28-4, not collateral proceedings in pursuant to this notification.
Kindly see, my lord,
As
WP.
simple as that. 28-1 ಆದ್ಮೇಲೆ 2-3-4 ಆಗಿದೆಯಾ ಇಲ್ವಾ? 2 and 3 ಆಗಿದೆಯಾ ಇಲ್ವಾ ಅಷ್ಟೇ. Pursuant to that notification.
Connected case
ಆಗಿದೆ, all that don't tell me.
Connected case ನಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ನಲ್ಲಿ ನೋಟಿಸ್ ಹಾಕಿದೀವಿ. ಇದರಲ್ಲಿ ನಮಗೆ ಇದು ಸಿಕ್ಕಿದ್ರಿಂದ.
No, which is this preliminary notification here? 28-1 ಯಾವ್ದಿದು?
ಎರಡು ಬೇರೆ ಬೇರೆ ಡೇಟ್ ನಲ್ಲಿ ಇದೆ.
ನಿಮಿಷ. 28-5-2010 is the 28-1 notification, correct?
Yes, my lords.
ಅದಕ್ಕೆ 28-2, 28-3 ಆಗಿರೋದು ತೋರಿಸಿ. Don't give me collateral proceedings.
My lords, I will produce it, my lord. But in the connected case, notice was issued and it is also produced, my lord.
Connected case, is it 28-1 notification dated 28-5-2010?
No, that was, my lord, an earlier notification. Notification is dated 17/11/2009.
Now 1 minute. Now 28-4 ಯಾವ notification ಮಾಡಿದೀರಾ?
ಅಲ್ಲ ಅದರಲ್ಲಿ, my lord, there are 4 notifications in all.
28-4 now that is impugned is pursuant to which 28-1 notification?
My lord, in WP number, my lord, 105222, the final notification is dated 29/2/2024.
Right, sir, I am asking a straight question.
Yes, my lord.
28-4 on 29/2/2024 is issued on which 28-1?
That was, my lord, 28-1 is dated 28/5/2010.
28/5/2010.
Yes.
Where is the interregnum 28-2 and 3 pursuant to that notification?
My lord, interregnum we have explained. In fact, my lord, there was a direction of this
explanation. I don't want your explanation. I want the records to see whether 28-2, 28-3 is followed pursuant to 28-1. Otherwise, you can't definitely issue 28-4 straight away.
No, we have complied with everything, my lord. Since there was,
there is nothing.
We'll place, my
nothing to show. You're saying you complied with everything.
We'll place, my lord. We will place on it.
You should have placed it. 3 objections ಹಾಕಿದ್ದೀರಾ, ಯಾಕೆ place ಮಾಡಿಲ್ಲ ಅದನ್ನ?
ಅಂದ್ರೆ ಅವರು ಇನ್ಫ್ಯಾಕ್ಟ್ ಅಲ್ಲಿ ಚೇಂಜ್ ಆಫ್ ಆಫೀಸರ್ಸ್ ಆಗಿತ್ತು, ಅದಕ್ಕಾಗಿ ಹುಡುಕ್ತಾ ಇದ್ರು. ಈಗ ನಾನು ಇನ್ನೊಂದು ಬಾರಿ ಇದನ್ನ ಮಾಡಿಸ್ತೀನಿ ಸರ್.
ಹುಡುಕ್ತಾ ಇದ್ರೆ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಹುಡುಕಕ್ಕೆ?
ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್.
ಕೊಟ್ಟಿದ್ರೆ that would have been the first annexure in your objections. And you filed an affidavit explaining the delay. ಅದರಲ್ಲಿ ಇದೆಯಾ annexure 28-2 and 28-3?
ಅಲ್ಲ ನೋಟಿಸ್ ಕೊಟ್ಟು ಏನಾಗಿದೆ ಅಂದ್ರೆ, ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ permit me to make this submission.
At least in the affidavit of the officers, it would have been annexures 28-2 and 28-3 if you had complied with it.
And also
Are they?
R2 and R2A of the affidavit, ಅದರಲ್ಲಿ
ಏನಿದೆ?
ಇಶ್ಯೂ ಮಾಡಿದೀವಿ ಅಂತ.
ಎಲ್ಲಿದೆ? ಇಶ್ಯೂ ಮಾಡಿದೀವಿ ಅಂತ ಥಿನ್ ಏರ್ ಅಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್.
We will, my lord, place it before.
28-2 and 28-3 are statutory procedures without which 28-4 cannot emerge. If you have not complied, it goes. Yavar notice ಕೊಟ್ಟಿದ್ದಾರೆ madam?
That is true, my lord. But in the connected case, we have produced, in the connected case, my lord, we have produced the copy of.
Case is a different
matter,
notification.
they have played a
Yes,
fraud.
that was a different notification.
This is a different notification.
Different notification, adrallu notification, but I would like to show how fraud has been played by the KIDB. They said that they have consented, wherein the signatures have been done by the parties, but it is not the signature which is going to tally with my party.
How do you demonstrate that?
It is in the objection which has been filed in 105242 of 2025.
105242
of 2025, filed by the KID.
Consent antana?
R1, yes, my lord.
Ellide?
Annexure R1, page number 12. ಒಪ್ಪಿಗೆ ಪತ್ರ. On 24/10/2025, they filed a statement of objection.
2410 R1, yes.
Please, my lord.
This signature, I
Wappige
know.
Patra. This signature is not of the petitioner, my lord.
How do you?
Chavan Jyoti. She signs as JF Chavan.
Where do you get
In my affidavit and
affidavit?
please, in the writ petition.
Is the only petitioner?
In this case, she is the only petitioner, my lord.
JF Chavan.
And even I have to confirm that I have got the
Vakalat Kodi?
say deed also, registered say deed.
Kodil.
2001 ಒಂದು register say deed confirmation ಈಗ ಅವ್ರದ್ದು signature ಏನಿದೆ ಅಂತ ಮಾಡ್ಲಿಕ್ಕೆ. And even in the affidavit as well as in the vakalat also, ma'am. We sign it as, she signs as JF Chavan. And here, my lord, in the Wappige Patra, this
ಇದೆಲ್ಲ ಎಲ್ಲಿದೆ?
last.
ಮೇಲೆ, yes, yes.
ಇಲ್ಲಿ Wappige Patra ಆಯ್ತು. ಆಮೇಲೆ next, my lord, in the page number 14 also at 36, serial number 36 also.
36.
Same signature. Chavan Jyoti. And this is how the KIDB does, my lord, in all those cases, that they just take signatures in the blank papers also, and they say that it is an agreement. This is how the fraud will be played in the land acquisition matters by the KIDB. And moreover, they will not pass award for so many years also. And have produced the judgment which
Yes,
is pertaining to 28/1/24. The prescribed time limitation
procedure,
is only 2 years, my lord.
ಇದು 14 years ಆಗಿದೆ.
ಇದು 14 years.
We'll place the notices and other things before your lordship.
ಏನ್ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ, now
Anyway, you produce the records.
Yes, ma'am.
We'll have to observe something about the KIDB.
Yes, ma'am. We'll produce the records.
Heard reserved.
Please.
My lords, I have submissions to make, my lord. The lordship may kindly.
ಏನು submissions, sir?
Submission, my lord, your lordship may kindly take objection statement in 222. Sorry, my lord, 105242.
ಯಾವ್ದು ಕೊಡಿ ಮೇಡಮ್.
My
Objection.
lords may kindly see page number 40. Notice is issued under section 28(2).
40.
Yes, my lords. 40.
Of the party, my lord.
40.
Yes, my lords. 40. And it is acknowledged by her.
ಎಲ್ಲಿದೆ? 40 ಅಲ್ಲ.
Objection statement in WP 105242, my lords.
R3.
Yes, my lords.
R3 is 40. Chavan
Yes,
Jyoti.
Jyoti Chavan.
In this case, only one survey number is involved.
The signature is not.
Where is the signature here?
They are saying that it is 2/10.
At the bottom of, my lord, this notice, signature is there.
Who is this at the bottom? 2/2010.
Section 28 subclause 2 clearly states that on publication of note, may I read it, Milo?
Yes, yes.
On publication of the notification under subsection 1, the state government shall serve notice upon the owner or where the owner is not the occupier, on the occupier of the land and on all such person known or believed to be interested therein to show cause within 30 days from the date of service of notice why the land should not be acquired. It has to be served on the owner, my lord.
That is there. This you say is notice, sir?
Yes, my lords. This is one notice, and there is no, my lord, there is no rejoinder filed to any of the, my lord, objections or the affidavits that have been filed by KIDB, saying that, my lord, it is not received. On the contrary, my lord, as pointed out by me in the other writ petition, the petitioner not only, my lord, acknowledges
other writ petition is other notification.
Other notification. In addition to that, my lords, there is also a legal notice issued by her through her lawyer. In that also she admits that, my lord, notice is issued to her. Kindly, can I request, my lord, it is page number 18 is the legal notice that was issued. In that also she admits that notice has been issued.
Page?
Page number 18 in WP, my lords, 105222 objection statement.
This I saw.
Para 3, your lordship. That notification
I'll read, my lord. Your lordship may kindly take para number 3. That your authorities have issued a reminder letter dated 31/12/2021, vide so and so, Dinanka 31/12/21, stating that the said land has acquired under BMEC corridor plan. My client received your intimation.
Clause 5 there. 4 and 5.
Yes, my lord. My client received your intimation letter dated 31/12/2021 on 11/1/2022, and after perusal of the letter, it came to my client's knowledge that the above mentioned property is acquired for the purpose of BMEC corridor plan. My client has not been served or received any notice said to have been issued under section 28(2) of the KID Act dated 8/3/2021. Refers to some other matter. Therefore, my client has no any knowledge about the proceedings. It is also instructed by my client that the inquiry said to have been conducted under section 28(3) of KID Act from 4/8/2021 to 18/8/2021 is without her notice, and the said inquiry is also not within her knowledge. And this was on 27/1. This was on 27/1/2022, and prior to my lord,
One
this
minute, sir. One
annexure
minute.
R1.
One moment. Which notification is this, sir? Which 28(1) is this?
The notice
This
for
is
which
with
party has replied
this is
notice.
not 28/1 dated 28/5/2010.
Pursuant to that, is it?
The notification is different for this letter, my lord.
31/12/2021 is the notice issued to them.
Yes,
Correct?
my lord. What has happened is, my lord, that is why I wanted to explain to your lordship, my lord.
31/12 ಅದು ಯಾವ notification, sir?
That was in respect of preliminary notification dated 28/5/2010, my lord. The notice referred is in respect of 59/1. Legal notice refers to 59/1, which is notified under the preliminary notification dated 28/5/2010.
ಅದು ಸುಳ್ಳು.
My lord, I will explain, my lord. I will explain.
That is false. Notice is issued on 31/12% of a different notification.
No, there are only two notifications with which, my lord, the petitioner is concerned.
Second petition, second notification, notice issue ಮಾಡಿ first one cover up ಮಾಡಕ್ try ಮಾಡ್ತಾ ಇದ್ದೀರಾ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಹಂಗಿಲ್ಲ. ಇದರಲ್ಲಿ my lords may kindly see what has happened is there were notices issued pursuant to these two preliminary notifications in 2009 and 10, etc. Later, what happened is, due to stiff opposition from the landowners, my lord, the acquisition proceedings could not be proceeded. In 2015, the additional chief secretary, my lord, visited this area and instructed that this land should be acquired finally, because this is going to be useful for this Bangalore-Mumbai corridor. That is how, my lord, she issued instructions. Then, my lord, it was started again, and in order to afford one more opportunity to the landowners, fresh notices were issued, and this is how, my lord, this 31/12/2021 notice is referred there. And, my lord, in addition to these two notifications dated 2009 and 2010, my lord, the government issued another two preliminary notifications in 2021 and 2022 to acquire about 2,600 acres of land for this, my lord, Bangalore-Mumbai, my lord, the express corridor. That is how, my lord, this was integrated into one layout, and the lands have been acquired. And, my lord, in order to afford one more opportunity, as I submitted, my lord, one more notice was issued to the petitioners, and that is what has been, my lord, acknowledged. And this annexure R2 is, my lord, 27/1/2024, whereas, my lord, the letter at annexure R1 is dated, my lord, 18/4/2022, after the legal notice was issued. And in that letter only she admits that, my lord, notices have been issued, and, my lord, this letter specifically says that notices in respect of all 5 numbers, my lord, survey number 58/1, 58/2, 59/1, 59/2, and 84/1. All these, my lord, survey numbers, my lord, notices have been issued, is what she says. And we want to explain only delay, my lord, that has occurred in this case, and that is why the Honorable Court had directed us to file, my lord, affidavits. That has been done by us. You'll also may kindly see, my lord, in respect of this entire 2,600 acres, these are the only two writ petitions that have been filed. And my lord, compensation has also been, my lord, disbursed to, my lord, all the landowners except these petitioners in Singanhalli village. And the work is, my lord, taken up and almost 10% of the work is completed. And my lords may kindly appreciate, my lord, the petitioner has not disclosed true facts in the writ petition. My lord, this land, according to her only, is, my lord, attached in a ED proceedings. And my lord, Lokayata proceedings is also pending. And my lord, if at this stage, if the acquisition is quashed, my lord, it will, my lord, harm the entire acquisition, my lord, taken up for a larger project. And one another, my lord, important thing I want to point out to your lordship is, my lord, 28(3) order passed by the land acquisition officer, which is produced along with, my lord, our affidavit. In the affidavit, my lord, with the affidavit, my lords, the 28(3) order passed, my lord, by the land acquisition officer is produced. And in that, the land acquisition officer, page number 5 of annexure R4, my lord, page number 15 of the affidavit filed by the additional chief secretary C&I, in which, my lord, the land acquisition officer has ordered for exclusion of 2 acres 24 guntas out of, my lord, survey number 58 and 36 guntas out of survey number, my lord, 59/1, on the ground that there are certain constructions that have come up. This also may kindly be noticed, my lord, and this is in the middle, these lands are in the middle of, my lord, the acquired area, and work is going on there. We have produced, my lord, records to show that also.
One more submission, my lord. In the affidavit, they have stated that they admit that out of the above said 4 notification issued for acquisition, the lands of the petitioners were notified only in 2 notification. They admit only in 2 notification my land has been acquired. And moreover, my lord, this particular land is situated towards Belgaum road. That is the Rajasthan Dhaba towards both the side, my lord. Towards right side, my lord. That is the land which has been acquired. There exists a petrol bunk also, my lord. And there is a specific circular wherein issued by the Department of Commerce and Industry, my lord, that the land which has been already there is existence of petrol bunk, or if the agriculture land is a fertile, then it should not be acquired. Their own circular is there, my lord, and taking into consideration of that, my lord, as per Annexure D, I have produced the
There's an
judgment.
interim order here.
Interim order ಇದೆ. ಅಂದ್ರೆ ಒಂದರಲ್ಲಿ not to dispose ಅಂತಿದೆ, ಇನ್ನೊಂದರಲ್ಲಿ stay of the notifications.
Yes. Heard.
In fact, my lord, the circulars have no application because they are issued.
Heard the learned counsel Srimati Archana Magdum appearing for the petitioner, and the learned senior counsel Basavaraj Shabrat representing the board, and the learned AGA. Heard reserved interim orders of the kind subsisting as on date shall continue till the disposal of the petition.
I pray that the entire notification is to be questioned. 28(1) and 28.
Prayer adu interim order. Yes.
Alla, nan prayer anta.
Yes.
Prayer is restricted to only petitioners, lords. They are
Only
first
petitioners. Only petitioners.
Of course,
petitioners. Lords, there is a reference to the receiving of notice in her petition also, that they have received the notice.
No.
In
that
her
is
writ petition itself, there is a reference, lords.
I have stated
At para
that
9, lords, she has stated that notice is received by us. That notice was brought to the
only
notice.
on notice pursuant to which notification?
Lords, 28/5/2010.
Another matter, not in this.
Thereafter, lords,
stand
28 proceedings are
There are
there.
2 notifications.
Please.
There are 2 notifications.
Please.
If you have issued notice or proceedings on 28(2) and 28(3) pursuant to another notification, you can't paraphrase that to this. They are individual rights.
Some lords, in this petition only, she has contended that notices were
Lands
issued.
are different.
One notice.
No, lands
Not
are
of
different
this.
in both the cases.
Please.
2 different acquisition notifications.
Please.
28(1), 2 different.
Please.
So you have to.
In the connected matter, lords, she has the 28(2)
You have to
notices.
follow the procedure.
Please.
As simple as that.
Two have not received.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 9 ನಲ್ಲಿ not in
We'll see, yes.
510522 she admits that notice has been issued and received by her, and she has submitted reply in her statement in paragraph number 9 of
by
this.
senior counsel, lords.
You place everything.
Para 9, lords, are petition, writ petition.
ಮತ್ತೆ spent 1 hour on this. Yes. List on Lester. You produce all the records.
Please. Since lords have passed order saying it is reserved.
It is reserved.
If another date was given, lords.
No, another date. Yes. Not after having spent so much time. Whatever you want, if there is, I have doubt, I'll post it for further hearing.
We have in fact filed our, my lord, citations also, my lord. Your
I
lordship may
will
kindly have a
consider,
look at it.
you will be
Yes,
rest assured, everything will bear consideration, yes.
please, your lordship.
Heard reserve, yes.
Number 21, Santosh P. Rao, Suresh Bhatt.
My lord, pending inquiry, the petitioner has been suspended and thereafter he has been reinstated on 11/6/2019, my lord. He has now on 30/4/2023, he has retired from the service. Till late, they are not ready to give the pensionary benefits, my lord.
Charge sheet
Your
issue
Lordship, on the
ಮಾಡಿದ್ದೀರಾ?
last occasion, directed to verify why pension is not at
Charge sheet issue ಮಾಡಿದ್ದೀರಾ?
charge sheet issue ಮಾಡಿದೆ, Your Lordship.
ಯಾವಾಗಾಗಿದೆ?
It is submitted to the respond number 1, Your Lordship.
Provisional pension ಅವರು ಕೊಡ್ಲೇಬೇಕಲ್ಲ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರಾ?
Provisional pension
Minimum
has been
pension they
fixed.
are given.
In his copy itself, there he has stated, Your Lordship, at page number.
But charge sheet pending ಇದ್ರೆ ಕಷ್ಟ ಅಲ್ಲ?
ಇಲ್ಲ ಏನು ಎನ್ಕ್ವೈರಿನೇ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಅದು will direct inquiry to be concluded within a time frame.
Please,
That's a different thing. The petitioner is before this court seeking the following prayer. They heard so and so. The petitioner is an employee of the fourth respondent, second respondent, Directorate of Municipal Administration. The petitioner during this service is said to have been placed under suspension by an order dated 7/3/2019. The petitioner during the subsistence of suspension retires on attaining the age of superannuation. In the light of the retirement of the petitioner, the suspension, the order of revoke madidra? The order of suspension would come to an end. But charge sheet is issued to the petitioner during his service. The inquiry proceedings are said to be pending. In the light of the said circumstance, no terminal benefits of the petitioner is settled. It is therefore the petitioner is before this court. The learned counsel appearing for the petitioner would submit that if a direction is issued for conclusion of the inquiry, it would suffice for the present. Since the petitioner is a retired employee and his terminal benefits are at stake, I deem it appropriate to dispose the petition with a direction to the state to conclude the inquiry within an outer limit of 3 months from the date of receipt of the copy of the order. In the event the inquiry is not completed within 3 months, the petitioner will become entitled to all terminal benefits that would flow from his retirement, notwithstanding the pendency of the inquiry. Ordered accordingly.
Please.
Next. Why is learned ASG waiting?
Item number 70, Lord.
70.
70.
230.
230, my lord. Yes,
230
I'm
I'll
grateful.
take it.
I'm grateful.
And Nitin sir, you were waiting. Yavdu that was
It's a tender, my lords. In fact, 4 matters are listed today. Your lordship is so busy in the roster.
28, my lord.
28 ಒಂದಿದೆ, tender matter.
ಆಯ್ತು ನೋಡ್ತೀನಿ.
Yeah.
28 I'm opposing, my lords.
ಆಯ್ತು ಈಗ ತಗೊಂಡಿಲ್ಲ ಕೇಳಿದೆ ಅಷ್ಟೇ.
ಅದೇ.
AG sir, you come at 2:30, I'll take it at 2:30.
I'm grateful.
Who's the opposite side ಅವ್ರಿಗೆ ಹೇಳಿರಿ 2:30 ತಗೊಂತೀವಿ.
I'll ask my
Yes.
colleague to inform.
Yes, yes.
Number 22, Shreyash Neelokan.
Lord, the petitioner is calling question the order
compromise
before the Lok Adalat. 13 acres, 14 guntas of the land.
Sir.
Nothing has been paid to the petitioner.
13/4/2012 is the compromise.
Please, my lord.
13/4/2012.
Yes, my lord. My lord,
Yes, Chandra.
she was not made, the proceedings gone up to RSA, my lord. In the another petition, my lord.
You have signed?
Please, my lord.
Have you signed?
Please, my lord.
You're a teacher.
Please, my lord.
You're a teacher.
Yes.
You have signed on the document.
Yes.
Now you are
My lord,
saying fraud.
Lord, what has happened is RSA, your lordships may kindly see, RSA 2017. Then she came to know, my lord, RSA 2017 ಅಲ್ಲಿ in the another suit. Please.
Notice. Pendency of this petition or issuance of notice will not alter the rights created under the compromise, impugned compromise decree. Next.
23, PG Chagmargun. Geeta K.
Thought from the direction that respond to consider the application submitted by the petitioner.
What is the application?
Seeking to not the furnish certain documents, your lordships.
What documents you want, sir?
Not the pertaining to the not the recruitment, not the process.
Who are you, sir?
I'm the member of the not the society, your
No,
lordships.
sir.
I'm representing
In fact,
cooperative
Madam,
society and they cannot, and it is not maintainable.
in fact, in the recruitment process, they have not caused heavy loss to the bank, your lordships. Irregular some.
Recruitment process ಕೇಳ್ಬೇಕು ಅಂದ್ರೆ you should be a participant.
Participant and nowhere is
My
concerned.
son was also participated in the recruitment process, your lordship.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದು, ಚಾಲೆಂಜ್ ಮಾಡಿ ರೆಕಾರ್ಡ್ಸ್
I sought for the documents, which are not pertaining to the recruitment process, your lordships, which are necessary to for further steps in the matter, your lordship.
ಫಸ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ.
For that purpose, the documents are required.
ಒಂದು ನಿಮಿಷ, ಯಾವ್ದಾರ ಫೋರಮ್ ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಲ್ಲಿ ತರಿಸ್ಕೊಳ್ಳಿ.
For that purpose, the documents are required, your lordships. In fact, I am the member of the society. In fact, there is no necessity for conducting the recruitment process, your lordships.
Who has rejected it now?
Not the respondents bank, your lordship. It's a cooperative
File an
society.
appeal, sir. File an appeal. Right to Information Act ಅಲ್ಲಿ ಕೇಳಿದ್ರ?
No, lordships.
ಹಂಗೆ
I submitted representation.
ಬರೋದೇ ಇಲ್ಲ. Yes, anything else?
In fact,
The petitioner is before this court seeking the following prayer. The petitioner is said to be a member of the Khanapur Cooperative Bank and submits an application before the bank seeking various documents concerning recruitment on the score that
second round of litigation, first round may not dishonorable.
On the score that it has caused huge loss. The bank does not divulge the same and therefore the petitioner is at the doors of this court seeking such divulgence. The petitioner has a remedy available and to seek the documents under the Right to Information Act, as admittedly the cooperative society, Right to Information Act admittedly the cooperative society is amenable to divulge the information under the Right to Information Act. Leaving open the said remedy, the petition stands disposed.
Much obliged.
Next.
24, Sirajuddin Ahmed.
Lordship for parole, Lordship.
2 years,
302, Lordship.
2 years, 9 months.
Please, Lordship.
ಸ್ವಲ್ಪ ದಿನ ಇರಿ. List the matter on 12th December.
Lordship, mother illness, Lordship.
ಪರವಾಗಿಲ್ಲ ಸರ್. ಇನ್ನು 2 years ಆಗಿದೆ. Yes, next.
2 years, 9 months.
ಪರವಾಗಿಲ್ಲ. Next. We'll grant you on that day. Yes.
Please, Lordship.
Your Lordship, restoration of kitchen work, Your Lordship, for the convict, Your Lordship.
Kitchen work ಇಂದ ತೆಗೆದ್ಬಿಟ್ಟಿದ್ದೀರಾ?
There are adverse reports against.
ಏನಿದೆ? ಕಿಚನ್ ತೊಂದರೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Yes.
ಏನದು? We can't direct the jail authorities to do in a particular way. ಅದಕ್ಕೆ ರಿಪೋರ್ಟ್ ಕೊಡಿ.
Last paragraph.
We can't go beyond this. ಈಗ ಎಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ? Where are you?
Your Lordship, ಏನು ಕೆಲಸ ಇಲ್ಲ, Your Lordship. He has been removed, Your Lordship, since 2 years without.
ಕೆಲಸ ಮಾಡದೆ ಹೋದ್ರೆ ಅದೇ ಆಗೋದು. There is a report against you.
Your Lordship, ಏನು ಹೇಳಿಲ್ಲ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನು ಆಗಿಲ್ಲ.
ಕೆಲಸ ಮಾಡಕ್ಕೆ ಒಂದು ಚಾನ್ಸ್ ಕೊಡಿ. The petitioner is before this court seeking the following prayer. The petitioner heard so and so. The petitioner is petitioner gets convicted for an offence punishable under section 302 of the 302 of the IPC and is set to undergo imprisonment, has completed 10 years, 11 months and 7 days in prison. The issue is not with regard to grant of parole or otherwise. He was employed in the kitchen of the prison and has been sent out from there. He is employed in weaving section in the prison. 1 minute, madam. Weaving section in the prison, he is sent out from there. Now the petitioner is before the court seeking a direction that the petitioner should be redeployed in the kitchen. The learned AGA has secured instructions and places a report before this court that the petitioner is not working anywhere he is posted. Therefore, the petition should not be entertained. Notwithstanding the aforesaid report, I deem it appropriate to direct the respondent prison authorities to give one chance to the petitioner to work in the kitchen. In the event he does not again work as it was earlier done, The present authorities would be at liberty to take necessary action in accordance with law. If the petitioner cannot again approach this court on the same ground that he wants to remain in the kitchen always, for the aforesaid reasons, the following order disposed, a
One more
mandamus issues.
submission.
Wait, madam. Mandamus issues to the respondent to to consider allotment of the kitchen work to the petitioner as was done earlier, subject to the aforesaid condition and bearing in mind the aforesaid observations. Next.
Your Lordship, remission, Your Lordship, all these days, whatever he has been worked, Your Lordship, since 2021.
Ian Beck, madam.
Remission, Your Lordship. Remission, they have not given, Your Lordship, for 2
ಮಾಡದೇ
years.
ಇದ್ದಾಗ ನೋಡೋಣ. Come, ಈಗ ಸದ್ಯಕ್ಕೆ ಕಿಚನ್ ಲಿರಿ ರೆಮಿಷನ್ ನೋಡೋಣ ಆಮೇಲೆ.
Okay, Your Lordship.
20?
26, my lords. My lords, this is a classic case of abuse of process.
Classic case. If you begin the case like this, henge.
Tender is invited, I participate, my lords, it's awarded in my favor. While I commence, my lords, the
Fecal
work,
sludge treatment plant.
please, while I commence the work, my lords, another tender is, my lords, invited for the same work, my lords. Annexure A, my lords, simply
What
before us.
has happened to the other tender?
Now, my lords, I'm not been given with the information, my lords, the respondent authorities. The work is invited, my lords, the portal shows that, my lords, the work is awarded.
The coordinate bench had on 16/9/2025 passed the following order. The learned counsel Shivraj Pulli submits that the tender was notified and is awarded to the petitioner.
Yes, ma'am.
Awarded to the petitioner. Notwithstanding the same, another tender is notified for the same work and for the same purpose. And there, the said tender also is said to have been awarded to someone else in the portal. Therefore, the subsequent tender and all its further actions shall remain stayed till the next date. The learned AGA, to secure instructions and make his submissions, list the matter on yavattu?
1 week.
Vande vara saka? Yes, list the matter on 18th.
Obliged.
In fresh matters. Next.
Please.
Till number 27, Abhijit is
Education. Illa. List the matter before the bench having roster. Yes, next. Nitin sir.
Please.
Idenu.
Lord, this case, on the last date, your lordship has specifically noted in the order sheet that in case the other side does not file its objections, it shall be treated as nil and we can go ahead.
My submission is, my lords, there's I'm instructed, I'm been told that, my lords, there was a death in, my lords, the family of the managing director. So the objections statement could not be signed. If, my lords, a week's time is, my lords, granted, my lords, with.
Only
And
statement
my lords-
signature, tomorrow it can be had. Let him sign it.
And,
He
my
has
lords,
come back.
as per the interim arrangement, my lords, this honorable court has directed that, my lords, the final work order is not to be issued. Now, my lords, the technical bids were opened. And, my lords, the third party assessment is in process. If, my lords, a week's time or 10 days time is granted, my lords, we will also assess, my lords, the technical bids, and, my lords, the financial bids would also be opened. And, my lords, it would be placed before your lordships for consideration.
This will create further vested interest, my lords, because so far what has happened is we have not challenged against any specific parties. This is one of those cases.
This court on.
My lord, can I just have one request, my lord? I'm sorry. My lord, I am appearing for one of the impleading candidates, which is allowed, and for one of the respondents.
Okay.
My lord,
No
now
problem.
what they seek to do is this, my lord. They seek to open the technical bid and say these people are not technically qualified, therefore they can't be heard.
Wait.
Very well.
This
Very well.
court on an earlier occasion had passed the following order date in.
My lords,
Please, so. The
17
learned counsel
minutes.
Shivraj Pulli submits a genuine grievance for not filing the statement of objections that that there was a bereavement in the family of the managing director and therefore it could not be signed. Seeks a week's time. Therefore, list this matter on 18th.
Please.
Further scrutiny of documents or otherwise shall not be undertaken till the next date on the score that no objections are filed as on today.
We can, my lords, assess the.
No,
please.
ಅದನ್ನೇ ಹೇಳಿದ್ದು. ನೀವು objection ಹಾಕಿದ್ರೆ ಅದು
Please,
ಕೊಡ್ತಾ ಇದೆ.
please.
18.
I will not take the objection is gone because of your grievance, but you can't proceed.
Please.
18th.
Great.
Obliged.
Very well.
18,
Obliged.
18, 11.
11 ಬಂದ್ಬಿಟ್ಟಿದೀವಲ್ಲ.
ಅಲ್ಲ.
1812 ಅನ್ಕೊಂಡೆ.
Saturday.
ಎಲ್ಲಾದ್ರು by mistake ಆಮೇಲೆ
ಇಲ್ಲ, ಇಲ್ಲ,
ಅದಕ್ಕೆ
1811.
wait.
Obliged.
Very good. My lord, in the same stage, my
Made in
lord.
the fresh notice.
Same stage.
Made state.
Tender ಎಲ್ಲ same stage.
Fresh.
Finish.
Please. Obliged.
Yes.
29 Praveen Kumar VS Council.
Shilling sir ಯಾವುದು?
Petitioner in this matter, Lordship, for implementation of the order, Lordship.
ಯಾವುದು?
Matter had come up, Lord, I appear for the fifth respondent, my lord, had made submission that government, my lord, seems to have transferred somebody, my lord, to a cadre post. And tried to
Oh,
fill
ex
up-
cadre, N cadre. All right.
ಹೌದು.
Exactly, Lordship.
Government had to, my lord, clarify because they have no right to, my lord, post somebody to a cadre post. It's already held.
Your Lordship,
ಯಾವ post ಇದು director ಆ?
Yes,
ಇಲ್ಲ,
Lordship.
CFO, my lord, Chief Financial
Joint
Officer.
Director.
No, CFO is a cadre post.
Yes, my lord.
Okay.
CFO
Yes,
is a
Lord.
cadre post and
Where is your C&R?
by promoting, Lord. Lord, it's they have not produced C&R, my lord. I can place it, but Lord, I'm making a
Case.
submission, Lord. CFO is a cadre post.
No. CFO
Filled through.
CFO is a post within the ranks.
Yes, my lord.
Now who is
Yes,
bought in?
it's in my R&P.
Who is bought in?
It's in my R&P. My lord, person, my lord, from the AG's office, my lord, who was earlier deputed to BBMP, is now posted to, my lord, as CFO and Director of Finance of, my lord, fifth respondent company.
I
Fourth
will
respondent company.
get
Lordship, I producing the today, my colleague is there, Lordship, is file a memo for production of document, Lordship, which provides that, Lordship, where the chief financial advisor, the statewide cadre is this, Lordship. Lordship, please comes to the chapter 5, Lordship. There is a tabulation, please comes to serial number 2, Lordship.
page nation ಇಲ್ಲ ಏನು ಯಾವುದು? ಯಾವ ಪೇಜ್ ನೋಡ್ಲಿ ಸರ್ ನಾನು ಇಷ್ಟು ಕೊಟ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
Immediate 39, Lordship. Please comes to ink page number 39, Lordship. The bottom of the page, there is a page number, Lordship. 38, immediately 39, start from chapter 5, Lordship. I'm apologies, Lordship. Yes, Lordship. It's not bearing page number, Lordship. I'm apologies.
All right.
Chapter 5.
Chief Financial Advisor.
Yes, state-wise. The deputation of any officer of the Indian Audit
Indian
and
Audit
Accounts
Account
Department
not below the rank of. Now who is deputed, sir? Now who is deputed?
Lordship, I am the I was
Rank. What is your rank, sir?
sir. I am the KS officer, Lordship. I am in the designated official, Lordship. That's why government is deputed to me
By deputation
to
of an
promote the
officer
transfer.
from the Indian Audit and Accounts Department.
Yes,
Not
Lordship.
below the
And,
rank of
Lordship.
Senior Deputy Accountant General.
Yes, Lordship. And Lordship, please come to the order, the last document, Lordship. I'm apologies, Lordship. It's not bearing the page nation, Lordship. I'm apologies. Okay, please come to the order dated 26/2024, the where government of India, Karnataka was given a clarification regards this, Lordship, where the central government officials is not available, state government can be deputed, Lordship. Same wise, the BESCOM is in BESCOM also the same cadre officials is from the state government only, Lordship. The state government itself is deputing these persons, Lordship. Likewise, the state government was promoting me and transferred to the respondent number 6 post, Lordship, and he doesn't have he doesn't have the authorized person to so I'm apologize. He was elevated from the government, the BESCOM, Lordship.
Who has assumed charge?
Still, they are not permit me to take a charge, Lordship. He's in.
Respondent number 6 is working there, my lord, as through. He's a my lord. He's the person, my lord, who's occupying.
Notice has been issued, Lordship.
R6.
Yes, sir. What else?
Once the transfer order is being issued by the government, Lordship, it's bound by the respondent's, Lordship, and he can't. Still, he's not challenge that order to anywhere else, Lordship.
Allah, I'm not. I'm kindly pass over, my lord, because I have not had the benefit of seeing what they have filed. But it is not the post of CF, my lord, the Chief Financial Advisor. It is CFO, Chief Financial Officer. Chief Financial Officer.
It is the latest.
Nan I will, my lord, produce my my lord, C&R, which is
Please,
Yes,
Lordship.
tomorrow matters this. Yes. Next.
Number 30, Avinash Mangli.
Order of externment, my lord, out by your lordship's judgment.
Externment ಗೆ there is some problem now. Covered ಗಿಂತ ಎಲ್ಲಿ ಏಜ್ ಗಂಗಾಧರ್
So please already heard the matter, this serial number
ಇದೇನಾ
30.
ಕೇಳಿದ್ದು?
ಅಲ್ಲ 35 ಕೇಳಿದ್ರಿ ತಾವು. Serial number 35.
Wait.
ಅದು ಏನು?
Gangadhar has some, Kalburgi bench, just Magdum has written something else.
Please.
That report need not be given and it is only prima facie idru you can be sent ಅಂತ.
Following
That's-
Deepak's case, Deepak's case ತಾವು follow ಮಾಡಿ.
ದೀಪಕ್ ನಾನು ಫಾಲೋ ಮಾಡಿದ್ದೀನಿ. ಬಟ್ ದಟ್ ಈಸ್ ಯಾವುದು ಸ್ವಾಮೀಜಿ ಜಸ್ಟ್ ಮಗ್ದುಮ್ ಅವರದಲ್ವ ಆರ್ಡರ್?
ಹೌದು.
ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಅಲ್ಲಿ. ದಟ್ಸ್ ಕನ್ಫರ್ಮ್ಡ್ ಬೈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಾವು.
Just 10 days back, my lord, your lordship has remanded, my lord, saying that. it's not been-
Correct. I am aware of it, but that's the judgment. We'll see. AAG says you have to tweak your own order.
Oblige.
We'll see.
Oblige.
You be ready with that. 35, it's necessary.
Oblige.
Get Deepak. Already, Deepak ಇದೆಯಲ್ಲ. Get Deepak.
Sachin MR.
ಅದೊಂದು. Get Deepak. I have, after Deepak, I have, following Deepak, there are 2 or 3 orders passed in Bangalore. Pursuant to that, government has issued a circular implementing my
Order.
judgment saying report has to be given. Now that there is a change, we'll have to do something about it. We'll see.
Oblige. Grateful.
Number 31, Ramchandra Mali.
Post immediately after service of notice upon respondents 3 to 5.
In this, my lords, the bank has been already shifted, my lords.
Infructuous ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Shifted?
Shifted, my lords.
So you're against that shifting alva?
My lords, I was seeking not to shift, my lords.
Already shift ಆಗೋಗಿದೆಯಾ?
Shift ಆಗೋಗಿದೆ.
ಮತ್ತೆ ಏನ್ ಮಾಡ್ತೀರಾ?
It's
What remedy do you have?
On 29th, my lords have ordered
We'll see.
hand summons, my lords.
The petitioner submits that the prayer is frustrated by the act already of shifting the bank, which has caused grave prejudice. List the matter on the respondent. Yeah, respondent state idara?
Three is the
Third respondent who is yet to be served shall explain with regard to the same post immediately after service of notice upon the third respondent. We'll see.
My lords on 29th issued the hand summons. I have served the copy on that.
ಯಾವತ್ತು shift ಮಾಡಿದ್ರು?
On that afternoon only they have, after the hand summons.
Let them come. If they don't come, we will direct something. Yes.
Please, man.
Number 32, PV Gunjas, R.H. Changli.
Respondent. I filed an application for vacating the interim order granted by this honorable court.
What's the interim order, sir?
Interim order, my lordship, that the deanship of
Not to appoint a vice principal against the.
the cancellation of appointment of dean, that is the petitioner was appointed as a dean to assist the principal of the college, my lordship. And he is not eligible to hold a post of vice, that is principal, my lordship. And even then, my lordship, by virtue of the order passed by this honorable court, my lordship, the entire proceedings have been stalled before the.
What proceeding is stalled?
For appointment of a vice principal, my lordship.
Vice principal?
Yes, my lordship.
Now he is working as.
He is working as a dean, my lordship. And he has been removed since, my lordship, there were serious allegations against the petitioner.
He is a senior most professor?
No, I'm
No, my
not.
lord,
I'm
he is not a
seeking-
senior most professor.
in fact,
May I take
I'm
my
not
lordship to.
seeking vice principalship also. What I'm saying is let the appointment of vice principal be in terms of ordinance number 6.
Yes.
Rule 6.
What's that
is-
rule? Which is
It
what is
says
that
rule 6. I've called it out at paragraph number D, my lord, grounds DL ಹಾಕಿದ್ದೀನಿ.
Page?
At page number 3 of the petition, my lord. Grounds D, page number 3 of the petition. An existing senior faculty member may be designated.
Where is the extract?
No, just at D, my lord, D, ground D, my lord. An existing senior faculty member may be designated as vice principal of the.
By calling for application from interest eligible persons choosing meritorious candidate.
Now what they have said is the senior most faculty member immediately next to the principal shall be appointed. That cannot be done, my lord. They have to call for, on merit, they have to do it.
as per annexure R7, my lord, there are other seniors that
Don't worry, follow the rule.
we are following the rules, my lord.
You
We
follow
are
the
following the
rules.
rules. As far as the removal of the
You
deanship
do
is
one thing.
concerned,
This is your rules.
yes, ma'am.
Aita, you
Yes,
file an affidavit that will follow the rules.
Yes,
For
certainly.
appointment. Tomorrow I'll close it.
Yes, and as far as my lordship, the second issue is concerned, my lordship, he is claiming that his deanship shall be continued. my lord.
Forget about that.
Yes.
Now, for the post of vice principal,
Yes,
you have a procedure in place.
yes,
File an affidavit that you will not deviate the procedure and do it. We'll
please,
close.
please.
As far as cancelling my,
tomorrow.
as far as
Tomorrow.
cancelling my appointment
ಅದು
as
affidavit
dean is.
ಬೇಕಾಗಿಲ್ಲ, but ಯಾಕೆ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ನಾಳೆ ಮತ್ತೆ you will generate litigation. by
ಇಲ್ಲ,
doing
ಇಲ್ಲ,
something.
My
we'll
lord,
file
as-
affidavit.
My lord, as far as this one is the cancellation of my appointment as dean is concerned, it is based on a complaint said to have been filed by a number of people. If at all that is so, he must have been heard in the matter before his appointment being cancelled.
We'll answer that also. Yes. Tomorrow.
Yes, in the preliminary.
Tomorrow in same stage, fresh
Please,
matters.
please.
Tomorrow,
You need not be there, don't worry. Yes.
I'll try, I mean, if at all my this one, I'll try to be there.
Yes, yes, next.
Bill number 33, Syed Arif, Sachinangri.
ಏನಿದು?
Surface Act, my lord.
Yes, sir,
How's
payment of the amount, my lord.
ಎಷ್ಟಿದೆ?
10 lakhs, I have held 8 lakhs, my lord. In
That's all right. ಈಗ what is the
2020,
outstanding? What is the
outstanding, they are showing at present also 10 lakhs, my lord. Already I paid it. And I am ready to settle it also.
ಮನೆ? House ಆ?
Outstanding amount.
But
Residential house.
residential, they seized it in April itself, Your Honor. They're outside the road, they are not having.
Restore ಯಾವಾಗ ಮಾಡ್ತೀರಾ? When do you restore possession to them?
My lord, there is outstanding, principal outstanding, my lord.
Forget that. You restore possession, I will direct them to pay.
Yes, my lord. I will seek instruction, my lord.
ಮನೆಯಿಂದ ಆಚೆ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, I will seek instruction.
This is why such petition should be entertained. Otherwise, you'll throw everybody out for 1 ಲಕ್ಷ, 2 ಲಕ್ಷ. 2 ಕೋಟಿ ಸುಮ್ಮನೆ ಇರ್ತೀರಾ.
It may be pass over, my lord. I will
What
seek-
kindly pass over? When do you restore possession? Seek your instructions and come. List the mat, I'll pass over. I'll take it at 4 o'clock.
Yes, my lord.
Yes.
Bill number 34,
ಯಾವಾಗ ಕೊಟ್ರಿ 8 ಲಕ್ಷ?
2021 ದಲ್ಲಿ 10 lakhs paid.
ಔಟ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇವತ್ತು ಎಷ್ಟಿದೆ, ಎಷ್ಟು ಪೇ ಮಾಡ್ತೀರಾ ಹೇಳಿ? You can't get a free fall. I'll restore the house.
Yes,
But
I
not
inquire.
free.
Meantime, I inquire.
Yeah. ನೀವು 4 o'clock instructions ತಗೊಂಬನ್ನಿ.
Much.
Yes.
34, Gauri-Shankar Mohan.
It may be allowed, my lords.
The petitioner is before this court. Is before this court seeking the following prayer. The petitioner is an advocate. Advocate, huh?
No, no, no.
Allah, petitioner engages the services of
Respondent number 1 in
respondent.
number 1. In the proceedings.
Illalla.
Illa.
The petitioner engages the services of an advocate. The issue is rejection of Vakalat of the said advocate before the, by the concerned court. In reason, you know?
Then
Reason
that
ಏನು?
already I agreed to pay the amount, lordship. It is submitted.
The Vakalat is not accepted on certain financial conditions imposed to the earlier advocate. The concerned court has stepped into the shoes of the advocate. This concerned court of the society. For whom Vakalat ಹಾಕಿದ್ದು?
Respondent number one petitioner.
Society.
Tribunal.
Yes, before
The
tribunal.
tribunal, second respondent appears to have stepped into the shoes of the advocate to secure the fees of the said advocate. The order rejecting the Vakalat is on the face of it illegal and untenable. In that light, the order stands quashed. The petitioner consequently allow the objections. Adu ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ sir. ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ.
So and so. And all consequential action be permitted to the petitioner in accordance with law ordered according. Yes, next.
Number 35, Girish Sirima.
In Parola.
Externment out.
Externment. ಗಂಗಾಧರ್ ಇದನ್ನೇ ಹೇಳಿದ್ದು. ಎಲ್ಲಿ ಇವರು ಅವರು
ಸಚಿನ್.
ವಿನಾಶ್ ಅಂಗಡಿ ತಾನೆ. ಇದನ್ನ ಸಾಯಂಕಾಲ ತಗೊಳ್ಳ 4:04 ತಗೊಂತೀನಿ. ಲೆಟ್ us do something. ನಮ್ಮ ಆರ್ಡರ್ ನಾವೇ ಚೇಂಜ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. But the whole thing is, pursuant to my order, government has issued a circular implementing the order and directing report ಕೊಡ್ಲೇಬೇಕು ಅಂತ.
ತಾವು ಮಾಡಿದ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ 50% ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಆಗಿದೆ. Even in respect of cooperative society, that compulsory individual notice has to be served. That is also government issued the notice on that to all the officers. We are following the judgments.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಬಿಕಾಸ್ ಹೇಳಿದ್ನಲ್ಲ 20 ಎಕ್ಸ್ಟೆನ್ಮೆಂಟ್ ಆರ್ಡರ್ ಎಲೆಕ್ಷನ್ ಟೈಮ್ ಅಲ್ಲಿ.
We are all beneficiaries of your order.
Yes. But I'll take it at 4:30.
But only thing is in respect
of 144 order.
I am not order is different. 140 that is on different aspect. Only to extent of judicial review I read that. But that judgment, honorable Supreme Court judgment, that is Justice Khanna's judgments, where it says why the purpose of extendment, why it should not be fully disclosed the material. And that only that context, my lord, maybe notice should be contained the broader aspect of why you are doing grounds.
No, it's not the entire report.
But not entirely.
Report in its form alla, just irbeku. These are the allegations against
that should
you.
be there, my lord. But not entire report should be furnished along with the notice. That is the only that extent, my lord, I require a reconsideration.
Let me see.
Please.
Avinash Angadi kelidini antara kelisi.
Please.
I will take it after 4:30.
Please.
Yes.
37, Subhash Ji Bhatti.
Same order.
No, it is not GMAC. It is not by one. My lord, in this case, the claim has been made by the insured seeking compensation on account of the injuries suffered by him before the claims tribunal, because under 165 claims have been constituted only to decide the dispute between the
Emergent
insured.
notice to the respondent. The petitioner is at liberty to serve on the counsel who represented the respondent. Idra, represented before the concerned court. Further proceedings before the concerned court shall remain stayed. List the matter on 10th December.
Much of
Next.
38, Furuj Ahmad.
Please, my lords. What's the very gist of this matter, my lords, pertains to the annexure P, my lords. If your lordships may kindly come to page number 101. My lords, there is a government order dated 3/2/2024, wherein, my lords, the government has relaxed certain conditions for the tender. Now, my lords, if your lordships may kindly come to page number 102, the relaxation which has been given at the clause 2. Initially, my lords, the earlier condition was mandatory satisfactory completion as a prime contractor for at least one similar work.
25%.
Please, my lord, for one similar work. Now, subsequently, that has been relaxed to as for any construction work. Not
Any
a civil,
construction
any
work
construction
at 25 to the
Please,
extent
my
of
lords.
25. Now, what
And
has happened?
further, my lords, the same was also extended to the people who fall under the category 2B, which is at annexure Q at page number 109. If your lordships may kindly come.
All right.
Please, my lords.
Now,
Now, my lords, at the impugned annexure A, if your lordships may kindly come to page number, my lords, 30. The condition that, my lords, at clause 3 that has been imposed, that is successful completion at least one similar work. So I am challenging the same, my lords, because, my lords, as per the annexure, page 30, my lords, of annexure A, impugned annexure.
Page 13.
30.
Tender document.
Please, my lords.
Idhರಲ್ಲಿ ಯಾವ
Technical
clause?
qualification conditions.
Clause.
Clause 3, my lords. The clause 3
Successful
states.
completion in at least one similar work of value of not estimated cost.
So, my lords, my submission is
Yaar
that,
is
my
the
lords,
respondent? State,
please, my lords, state. And, my lords, initially this tender was called for. I had participated. My bid was rejected, my lords, which I have also challenged in this, which is at annexure N, my lords. On the same ground, they have rejected. Now they have recalled the tender. I have even participated in the same tender, my
So
lords.
they will reject this also.
Please, my lords, my submission is that when it is contrary.
Petitioner, you file your objections. The petitioner is before this court calling in question twin actions of the state. One, the issuance of a new tender notification and the rejection of the tender of the petitioner. The petitioner participates in the tender on the strength of a circular issued by the state which depicted that the tenderer should have undertaken similar work to the extent of 25, similar work in any of the constructions, The said circular is followed again by a government order extending the same to category 1 and category 2 of category 2A, as which are depicted to be backward classes. The tender of the petitioner comes to be rejected that he has not done a similar work of value not less than estimated cost. The new tender is now notified and the petitioner has applied. The learned counsel submits it would be rejected owing to the same clause. Therefore, the tender document being contrary to the government orders noted herein above should fall in line with the government orders. Therefore, the proceedings in tender shall remain state till the next date.
No work order shall be issued.
ಏನು ಕೇಳಿದ್ದೀರಾ? Therefore, no work order shall be issued to any person without the leave of the court. List the matter on 24th.
Highly obliged.
25th in fresh matters list. Next.
Highly obliged.
Learned AGA is directed to accept notice for the respondent. ಇನ್ಯಾರಿದ್ದಾರೆ?
Please, all the
All
respondents
AGA,
AG.
yes.
Please.
Next.
Highly obliged.
Petitioner, my lords, seeking direction to consider my application for issuance of passport, my lords.
Crime pending ಇದೆಯಾ?
Crime pending, my lord, which has been stayed by this honorable.
ಪರವಾಗಿಲ್ಲ. What charge sheet ಆಗಿದೆಯಾ ಬರೀ FIR stage ಅಲ್ಲಿ ಇದೆಯಾ?
Charge sheet has been filed, man.
So short validity passport, no regular passport.
Issuance of fresh
Short validity.
Short validity, man.
SVP, not regular passport.
Not regular passport.
One external affairs, learned counsel, learned Venkatesh, DSG ಯಾರಿಲ್ಲೇ?
MP
ಕಣ್ವಿ DSG ಏನ?
Venkatesh Karvi. Sorry, my lords. Venkatesh Karvi.
Learned counsel Venkatesh Karvi. The petition to serve on Venkatesh Karvi list tomorrow in fresh matters list.
Yes.
We'll close it as my judgment. Santosh, where is that?
Yes.
ಅದು ಅವ್ರಿಗೆ ಕೊಡಿ, ನಂಗೆ ಬೇಡ. ವೆಂಕಟೇಶ್ ಕಾರ್ವಿ ಕೊಡಿ.
Number 40.
My apologies, my lords. Lords, my apologies. In serial number 38, may I request for hand delivery, my lords?
ಆಯ್ತು.
Please. Highly obliged, my lords.
ರಿಕ್ವೆಸ್ಟ್ ಅಲ್ಲ, ಮೆಮೊ ಕೊಡ್ಬೇಕು.
Please, my lords. I'll file.
ಎಷ್ಟು ಕಡ್ದೇವ್ರು?
Please, my lords. Lord, in this case, my lord, the petitioner my lord, is a society bank. Lord, in the year 2006, my lords, against one person, my lords, they have conducted my lord auction sale. The present respondent number 1, he is a purchaser, he is a bidder in the said sale, lordship, auction sale. Subsequently, my lord, the borrower, my lord, has challenged that auction bid. That has been set aside in the year 2012, lordship.
ಈಗ ಏನಾಗಿದೆ ಹೇಳಿ ಸರ್?
ಈಗ they have filed application under section 106 of the Karnataka Cooperative Societies Act 1959, which is itself is not maintainable. They have filed this petition for seeking refund of their amount. We are not, my lord, we are ready to, my lord, refund that amount. But they said, my lord, it has to give, my lord, with 18% of the amount, lordship.
Interest.
18% interest. That is the difficulty. Now arrest warrant is issued. 2 and 3 months.
Learned AGA accepts notice for respondents 2 and 3. The first respondent be served by way of hand summons and an acknowledgement to that effect be filed before the court by on or before the 13th of November. List the matter on 18th. Further, there shall be an interim order of stay as spread for till the next date. First,
Lord, I seek, Lord, hand delivery, arrest warrant is issued.
Next.
41 Girish Adva.
Much obliged.
Seeking mandamus, my lord. In the petitioner land, my lord, the government has made the road, my lord, without issuing the proper due process of law, my lord. In fact, has submitted the representation, my lord, that has been not considered by the respondent authorities.
Yes, government. Learned AGA is directed to accept notice to the
1, 2, 3.
AGA na ಯಾರು?
AGA.
ಎಲ್ಲ AGA na?
Please.
ನಾಳೆ ಹಾಕ್ಲಾ?
ಇಲ್ಲ, ಇದರಲ್ಲಿ 2013 ಅಕಾರ್ಡಿಂಗ್
ಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಿರೋದು ಅಷ್ಟೇ. ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ. ನೋಡ್ಕೊಳ್ಳಿ ಅಂತ ನಾಳೆಗೆ ಹಾಕ್ತೀನಿ. ಲಿಸ್ಟ್ ಟುಮಾರೋ ಇನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಪ್ಲೀಸ್. ಎಸ್.
42 Ishan Vistardevar.
Lord, this is yesterday's matter.
I appear for the respondent's date in this matter, my lord.
Vijay Kumar, 2:30 ತಗೊಂತೀನಿ.
Please.
Next. ಕರ್ಬಿಡಿ, preliminary ಮುಗಿಸ್ಕೊಂಡು.
43, Sajid Ahmad Godwala.
My lord, for petitioner, petitioner is seeking for quashing of the impugned endorsement, my lords, issued by the second respondent. My lord, the petitioners are the active members of the Lions Club, my lords, Ranebennur.
Lions Club.
Please.
ಏನಾಗಿದೆ ಈಗ?
Or already they have paid rupees 100, my lords, each member. Now they have issued an endorsement, which is at page 65, and stated that without affording opportunity and without notice, they have issued endorsement stating that the petitioner were not the members as per rule 14(3)(e) of the bylaws, my lords. My lords may kindly see the bylaws, which is at page 45.
Who has issued notice now?
Respond number 2, my lords. DRCS. My lords may kindly see page 45.
The AGA is directed to accept notice for the respondents 1 and 2.
Please.
Emergent notice to the third respondent returnable by the 24th. List the matter on returnable by 25th. List the matter on 25th in the fresh matters in the preliminary hearing. There shall be.
No, my lords, we are not seeking for.
Yes.
44,
For petitioner, my lord, petitioner was working as a village assistant, challenging the order of termination, dismissal from service, my lord.
Without inquiry?
Without inquiry, no.
Lordship, because your lordship, notice has been,
Notice has to be ordered, my lord.
no, I'll,
This is coming for the first time, my
First
lord.
time. HCGP 1, 2.
For all
please your
respondents.
lordship, we have the 1 to 6, I'll take notice your lordship. In this matter, from the purchase, the property which is sold by the purchaser, who is a dead person, your lordship. And for that person also, mobile number is given by the very same petitioner.
ಮಾಡಿರೋದೆಲ್ಲ fraud.
Fraud, please your
ಹಂಗಂತ ನೀವು
lordship.
ನೋಟಿಸ್ ಕೊಡದೆ ಕಳಿಸಬಾರ್ದು ಅಂತ. ಅಷ್ಟೇ ಬೇಕಾಗಿದೆ.
No
Notice.
inquiry was conducted, my lords. There is no finding.
You may have done many things,
Please your
but in
lordship.
accordance with law, you should send him ceremoniously. ಅಷ್ಟೇ.
Please, I will get tomorrow, your lordship.
List tomorrow in
Tomorrow.
fresh matters.
Under
Please,
fresh
your
matters list.
Where is my judgments?
There is a judgment by the Honorable Division Bench of this court, my lord, wherein
ಕೊಡಿ.
Tomorrow.
services cannot be terminated
Yo, that is too rudimentary, sir. You need not worry.
in the
Yes.
year 2024, my
That
lord.
is too rudimentary. Next.
45, Suraj Kim Road.
That's covered matter, my
Covered
lords.
by-
The petitioner has purchased the vehicle in the Union Territory of Puducherry, my lords.
Covered.
Disposed
Counsel
on.
for the petition. Both the parties in unison would submit that the issue in the list stands answered by the judgment rendered, Andena.
Please, my lords,
Judgment
your-
rendered by this court in
My lords, the order is not released.
section 49.
49.
ಇದ್ರದಲ್ವಾ? ಪಾಂಡಿಚೇರಿ.
Pondicherry, my lords.
Pondicherry matter. Disposed, yes.
Number 46,
For the petitioner, your lordship, we are challenging Annex Re, your lordship. That is an order passed by respond number 2, your lordship. Here, the petitioner was the director of the respond number 3 society, your lordship. And here, at the time of availing loan, he has produced all the necessary documents, your lordship.
Lords, may
But
I-
on the ground that
The order is passed under section 29C, my lords. That is an appealable order. They've also preferred an appeal. I'm filing with.
Plural remedies.
my humble submission is that, your lordship, the disqualification on which they have made, your lordship, that he has not produced any security at the time of
Appeal
availing loan.
ಹಾಕಿದಿರಲ್ಲ, pursue that. All contentions will be left open there.
But my submission is doesn't fall under section 29C, your lordship, because we have
Why
also
did you file
produced
an
the
appeal?
mortgage deed.
Why
your
did you
lordship.
file an appeal?
I may be permitted to withdraw that, your lordship. Because I have produced the registered mortgage deed, your lordship, that has been accepted by the respond number 3 society also. And without summoning the respond number 3, they have passed an order, your lordship. If they would have summoned, then the respondent 3 society would have made a submission that we have produced a mortgage deed.
Well,
And
we'll
it is
take
also
tomorrow.
reflecting in the RTC. your
We'll take it
lordship.
tomorrow.
Please.
ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ ನೋಡೋಣ. Yes.
47, Ganesh Raivagi.
Voting right. Voters right.
Notice
GB.
of learned AGA is directed to accept notice for respondent 1 2,
One,
1 to 3,
no, my lords. 2 is the state election commission.
1 and 3. Correct?
Yes.
Emergent notice to the remaining respondents. Voting rights, yes. Next.
48, Vittal Teli.
Petitioner is challenging the, my lords, the order of the Lok Adalat. Notes the.
Yavathinda? 21, 11, 22?
22, my lords. My lords, this there is impersonation. I was not present before a court. Notes even, my lords, after filing of an execution proceedings, I came to know about the impugned order.
Suit for?
No, suit for for a possession filed by me. My lords, I have not engaged any advocate. I have not executed Annexure C, which they alleged I have executed lease deed. Based upon the lease deed, suit for possession.
Petitioner shall serve the respondents by way of hand summons. The compromise decree so entered into Alabada. The execution proceedings in execution proceedings 432 of 2025 shall remain state till the next date. List on 25th.
Please.
And preliminary hearing. Next.
49, Pranav.
Ashal Sarumadi Vittal.
Lordships, notice under section 148, your lordships.
148A, faceless.
My lords, one more issue, section 119(2)B is
All
also there.
issues open, only faceless.
No, my lords, 119(2)B is also there, my lord. Delay application got rejected, my lords.
119, your lordships.
That may be left open, my lord. But if
Everything is left up. Allo ashte, lot of case. Madam, you're Tirumali's junior, right?
Yes.
My lords,
Yes, sir.
Tirumali, sir. Who is faceless, sir?
Allah, the first prayer is.
All other contentions will remain open, sir.
Allah, what I am submitting is that first prayer cannot be allowed at this stage, just.
Yen first prayer.
Caution of the order passed under 119, your lordships.
Next matter.
Sir, all other contents will left open. Anyway, if you are objecting to it, we'll take it tomorrow and close it. Yes, next.
Allah, what I am submitting is that only the first prayer need not be allowed. Only second prayer has to be allowed.
they need to be kept open.
They are kept open, sir. All allu ashte ella agide matte ನೀವು ಅದನ್ನೇ ಹೇಳ್ತೀರಾ ಇರ್ಲಿ ಬಿಡಿ.
May I make a submission? 179 serial number is also 140.
Tomorrow, both tomorrow. Yes.
Tomorrow.
17.
Once today, no, there is only 148 notice is there. There is no other issue.
ಅದರಲ್ಲಿ ಏನಿಲ್ವಾ?
Other you know.
Yes, ಅದರಲ್ಲಿ ತಿರುಮಲೇಶ.
Yes.
Yes, ತಿರುಮಲೇಶ್ sir 179.
Okay, madam, that's okay.
17 madam 179 faceless ಅಂತ ಬರ್ಕೊಳ್ಳಿ.
I will give the.
ಅದು ಮಾತ್ರ faceless, ಇದು baseless ಅಂತ ಬರ್ಕೊಳ್ಳಿ.
So far as 179 is concerned, it's fully covered. There are 5 issues.
ಎಷ್ಟಿದೆ?
5.
All 5 matters.
All 5 matters will be disposed of today. This may be taken up tomorrow.
This will be tomorrow.
My colleague will be there.
No problem. ಯಾರು ಇಲ್ಲ ಅಂದ್ರೂ ಪರವಾಗಿಲ್ಲ.
Number 50, Chetan Murali.
My lords, I appear for the petitioner, my lords. My lords.
50 minutes.
My lords, I appear for the petitioner, my lords. My lords, tender is awarded to me, my lords. Agreement is signed. After agreement is signed, I give bank guarantee. I start supplying. Then they, my lords, have issued a cancellation order. Page 24 is a cancellation order. My lords will find the award of work on 10th of September on page number 75. My lord, there is further development here, my lords. My lords, my colleague will just pass across an interim order, my lords. What has happened is that after I have been awarded the tender, making use of this cancellation order, the previous bidder has filed a writ petition before my lords and obtained an order of stay.
Oh.
My lords may just see the. I'm sorry, my lords.
ನಿನ್ನೆ ಮಾಡಿದ್ನಲ್ಲ ಇದನ್ನ.
Swami, Monne Swami. Now, because of this interim order, they are not paying me my money. My lords, in the face of this interim order, I can't ask any.
Tag this petition along with 108089 of 2025. List the two tomorrow in fresh matters list.
Oblige, my lords.
Yes.
Number 51, MB Raymond.
Petitioner, my lords. Petitioner herein is challenging the refusal endorsement issued at Annexure E to E5, my lords. It is covered by decision at Annexure F, my lords, wherein the fitness certificate is refused by the respondent authorities on the ground that, my lords, vehicles are more than 15 years old.
Please, I verify.
Judgment is 6 years old. ಈಗೇನಾಗಿದೆ ನೋಡೋಣ. Yes. The learned AGA is directed to accept notice for all respondents.
Yes.
List on 25th fresh matters.
Interim order, my lords.
An interim order.
Let's now, we have not been permitted to run the vehicles.
ಅದು interim
Those
model
are used as college buses.
college buses.
Yes. Petitioner herein is an college institution, Mulats,
VTU.
educational institution. Maratha
The
Mandal.
usage of the buses shall go unhindered till the next date of hearing. However, would remain subject to the result of the petition.
Great.
School bus amal tondre agbadu. Next.
52, Rahul is concluded.
Please, my lord, for petitioner, my lord. Petitioner is the contractor, my lord, on the basis of, my lord. From 2009, he is working as the, my lord, in the solid waste management, my lord, in the Dharwad Municipal Corporation. Now, my lord, from 2009, he is working, my lord. Now, recently, on the September 22, he issued a notice stating.
You're hungry, huh?
My lord.
You're hungry.
No, my lord.
Matma ಜೋರಾಗಿ ಹೇಳಿ.
Sorry, my lord. Annexure F, my lord, page number 48, my lord. Stating that, my lord, on 30th 9, we will terminate your contract, my lord, without issuing notice or show cause notice, anything, my lord.
39 ತಿಳುವಳಿಕೆ ಪತ್ರ.
Please, my lord.
ಸಂಖ್ಯೆ 70 ಗುತ್ತಿಗೆ ಸೇವೆಯನ್ನು ನೀಡಲಾಗಿತ್ತು. ಸದರಿ ಮಾನ್ಯ ಆಯುಕ್ತರ ಆದೇಶದ The petitioner is before this court calling in question a termination order. The termination order reads as follows. The termination order does not speak of any notice being issued to the petitioner. It is ostensibly passed on the instructions of the Commissioner, Hubli Dharwad Municipal Corporation. Therefore, there shall be an interim order spread for till the next date. HDMC yaru?
Irana Kabur. Acq Kabur.
So and so they are third.
May I seek for handle, my lord.
Yes, next.
53, Shivraj Balwani.
Please. Challenging the impugned order at Annexure A, my lords, wherein my applications were rejected for stay of Annexure F and Annexure G, my lords. Lords, I am working as a Chief Executive Officer of Abhyudaya Cooperative Society, my lords, pursuant to which I was suspended. And my lords, proceedings are going on before respondent number 2. Lords, I had filed my interim application, my lords, for challenging the for stay of the suspension, my lords. That is a resolution which is passed on 13/8/2025 at Annexure F at page number 40. Lords, this resolution, my lords, which is passed, it does not contain any signatures by whom it is written, and subsequently, my lords,
I get it. Secure instructions. List. Day after tomorrow in fresh matters.
Lords, meanwhile, stay.
Meanwhile, day after tomorrow. Let him secure the papers. Yes.
Please, my lords. Highly obliged.
Please, my lord. Lord, petitioner society is since 1969 is running college, and 10 hectares of land in Survey number 25A1 was granted on lease for 30 years, my lord. Lease expired in the 2004, and before expiry of the lease, an application was made for renewal of the lease.
Learned AGA is directed to accept notice for respondent 1, 6. Respondent 3,
1 to 6.
1 to 6.
Yes.
Government of India go nivena.
1 and 2 Union of India.
1 and 2 MB Kanavi, 3 to 6 Learned AGA. Learned AGA to secure instructions and make submissions. List on Monday 10th.
Please.
55,
Yes, next.
Surabhi Kulkarni.
Lordships, challenging the attachment of salary and retirement benefits of the petitioner, Lords,
Why?
for satisfaction of award amount in respect of a loan secured by respondent number 7, Lords.
Who is that?
Lords,
Who is respondent number 7?
he was the principal debtor. Lords,
Who are you? Guarantor.
petitioner is one of the sureties. And Lords, without satisfying the hypothecated goods
The
and
petition 1, and 2 state. 3 no rena?
3.
1, 2 state. 3, 4.
3 to 10, I'll take.
3 to 10
notice.
served by hand summons.
Please.
Agatha notice hogli bidi. The 10 yaru madam? Chief
10
Executive
Lords,
Officer.
the Sauharda Society.
The 3 to 10 emergent notice returnable by the 5th of December. List on 5th. There shall be an interim order of stay spread for till the next date.
Obliged.
Yes, next.
56, Shivraj P. Mudwa.
Collection of shares.
Huh?
Collection of shares.
The same
Covered.
illa ide. Page 57. Vijayalakshmi. 57 covered. Disposed.
DTN.
Huh?
I may direct take.
Learned, separate order sheet, learned AG is directed to accept notice for the respondent.
Please.
Both the counsel for the petition and learned AG in unison would submit that the issue in the list stands completely answered by so and so. Yes, disposed. And delivery.
One submission, my lords.
Morning, I had moved a matter for 2:30, that jurisdiction is given to division bench regarding education matter. I have not pressed the memo.
My lords, it list on 20th.
Submission, my lord.
Deputy Director of Food and Civilian has suspend the order. Please.
Submission, my lord. That matter is pertaining to Bangalore, my lord.
Madam.
Code officer, madam. Code officer, madam.
Madam, Madam,
Sir, ಹೇಳಿ.
am I audible, madam?
Yes, sir.
Thank you.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
Sir, ಹೇಳಿ.
ಮೇಡಮ್ ಬೆಂಗಳೂರಿಗೆ ಒಂದು ಸಬ್ಮಿಷನ್ ಇದೆ ಮೇಡಮ್, ಅವಾಗಲೇ ವೇಟ್ ಮಾಡಿದ್ವಿ, ಮಾಡಕ್ಕಾಗಿಲ್ಲ, ಸಾಹೇಬ್ರು ಎದ್ಬಿಟ್ರು.
ಮಾಡಿ ಸರ್, ಸಾಹೇಬ್ರು ಬಂದ ತಕ್ಷಣ.
ಹಾ ಸರಿ ಮೇಡಮ್.
May I make submission, my lords? Serial number 56, my lords, had stepped away for lunch, my lords. I've disposed the matter, my lords. I'm sorry,
Dispose
my lords.
ಮಾಡಬಾರ್ದಾಗಿತ್ತಾ?
ಮಾಡ್ಬೇಕಾಗಿತ್ತು, my lords. Date of appearance may be fixed on 17th, my lords, of this month.
17th.
17/11.
All right, we'll correct.
Please, grateful.
Submission, my lord. My lord, submission, my lord.
Yes, sir.
The matter pertains to Bangalore, my lord. I filed a IA for extension of parole, my lord. The file is already transferred to Dharwad bench, my lord.
It will come tomorrow, we'll take it. Yes.
My lord, serial number 12.
Much obliged, ma'am.
The morning it was disposed of, your lordship. The time limit was not fixed, your lordship.
Correct. Yeah, responded KBD.
Please, your lordship.
Will 8 weeks, 8 or 12 weeks, 8 weeks, sir.
Please. Grateful, your lordship.
The writ petition number is 10931, my lord.
You can't tell that. Where is the memo?
RJ memo I filed, my lord, already.
Yes, leave it.
Serial number 173 covered by the 400 bench decision. It could be taken up at.
Respondent here, state. ನೋಡೋಣ. ಅದು ಬರ್ಕೊಂಡಿರಿ 173 will see.
My lord, in serial number 47, my lord, notice has been directed to only 1 and 3. 2 and 4 also, my lord, GV Baramgowda may be directed to take. 47, an election matter.
ಮತ್ತೆ ಅವಾಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
I thought he was the
Baramgowda. Number?
47, 47, my lord.
Respondent number?
2 and 4 ge GV Baramgowda.
2 and 4 ge?
4. GV Baramgowda.
ಯಾರಿಗಾಗಿದೆ ನೋಡ್ಕೊಳ್ಳಿ.
Lordship, serial number 222, Lordship. 10 days matter is and settlement they have now proposed.
Parties to the list submit that the talks of settlement between them are afoot AFOT. List the matter after 2 weeks.
Please, interim order.
Parties are at liberty to move the matter once the matter is settled between them.
Yes.
Interim order subsisting would continue till the next date of hearing.
Please.
Till the next date of hearing.
My lord, the writ petition number is 1093/2025, my lord.
Will you send a memo or keep talking?
I sent
Yes.
RJ memo and even my file has come to the Dharwad bench, my lord.
Now stop. Yes. Yes, your third.
Number 70.
Lord, I have
Petitioner yaru?
NL Patkurki, MB Kadvi.
I appeal for the petitioner's
Lord, I have
Serial
filed
number
the-
70.
Please, I have filed the application for
Vacating the
stay.
interim order.
Lord,
All
this is
right.
listed for, Lord, the issue is that the railways have undertaken a very benevolent project of laying a new line between Bagalkot and Kudachi. On the upper side, we have the Londa Miraz line, and below we have the Gadag Ogati line. Now, people from Hubli have to go all the way to Londa to go to Miraz. Therefore, we came out with this plan of joining these two lines through the Bagalkot Kudachi. Out of this 140 kilometers, Lord, we have already completed 37 kilometers, which is operational for goods train. If I may show a Google map, Lordship will get a clear idea of what it is. I have it.
Yeah, there's an interim order here, is it?
There is an interim order for the last 4 years, my lord, and only 160 meters is holding up the 160 meters is holding up the entire project. Please have a look at that image that I have shown. My lord, on the right hand side is Bagalkot.
That's what 41,000 to 40,900.
Yes. Now 160 meters is belongs to the petitioner. About 2 kilometers prior to this, we have completed the line. No, my lord, the petitioner's grievance is that interim order was granted on 9th of December 2021, and it was confirmed by an order in Jan 2000.
What is confirmed?
The interim order, in the sense,
Vacating stay and baralla.
by a very faulty understanding of the facts. No, dear Lordship, please have a look at the interim order dated 12/1/2022. 12/1/2022.
12/1/22.
12/1/22.
12/1 ಯಾವ್ದಿಲ್ವಲ್ಲ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ, ಇದು ಒಂದೇ.
Another copy.
ಕೊಡಿ. ಇನ್ನೊಂದು ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ? ಕೊಡಿ. 5/1/22.
I've got eligible copy.
One second. This is Shyam Prasad.
Yes. The petitioner's case is that the land which is rich in limestone deposit is notified for acquisition at the interest of Southwestern Railways for laying
railway line between Bagalkot to Kudachi, Belgaum district. Notifications were issued for the alignment at the first instance way back in 2011. But on an overall consideration of different objection, including objections as to railway line running through a limestone rich area where there is extensive use of explosives, notifications not pursued. Thereafter, an alternative alignment was also proposed and the acquisition notification was issued in the year 2014, but there is no follow-up on that notification. However, the current impugned notifications are issued reverting to the alignment as proposed in 2011. The licensee who are permitted to mine limestone, use explosives extensively in the area, not only, but this is where the wrong understanding comes. Not only the petitioner's right to carry mining activities restricted, but there could be serious repercussions with the use of explosives because the relevant rules prohibit the use of explosives within the distance of 200 meters. Now, admittedly, the petitioner's license to quarry has expired in 2023.
Not renewed?
Not renewed, and his admitted position is not carrying on any activity there. No activity is going on. So therefore, the first sentence that it will restrain the petitioner's right is incorrect. Secondly, my lord, there is nobody using explosives there. This is the only quarry which is holding up our project for the last 4 years. My lord, millions of people will benefit. Cement industries, my lord, they are looking up to completion of this line so that transportation of cements can be done. And the petitioner, my lord, appears to be aggrieved by the grant of compensation. Not compensation, he can agitate separately. But why hold up our project? My lord, that's my question.
Yes, sir.
It's very difficult to counter the very forceful submission. I understand and I concede all that he states. But the simple
I am really grateful to his fairness.
The simple case of the petitioner before your lordships is mainly statutory. That is, the 3-4 times it was issued, withdrawn. After the issuance of the final notification under section 6(1), also it was withdrawn. Anyway, it's a policy decision, and I'm too small a man to counter that.
Railways.
This central government or the railways. So I also appreciate the fairness of the learned and the ASD. That all that I'm interested is the compensation. Now, having had the benefit of an interim order, the first question that I would like to press for your lordship's kind consideration is the preliminary notification was issued on 5/10/2020, and the final notification was issued on 3/1/2022. After the lapse of 12 months, which is contrary
21/7. 21/7.
19/7.
19/7. Sorry, 19/7.
19/7. And if I'm not mistaken, I may kindly be permitted to press the judgment of a coordinate bench of this honorable court.
Justice M.I. Arun.
No minutes.
Innondu Justice Sanjay Gaudru.
His lordship Justice Sanjay Gaudru. This is only
Subsequent is Justice M.I. Arun's order, where he says project should not be stalled like this, the specious plea of 1 year. But is there any extension on reasons recorded in writing?
No.
And 19/7, ASG sir.
Allah,
19/7.
His impugned notification at Annexure F is August 2014. I don't know where.
14?
Yes. That is what he has challenged.
14. I don't know, but there are many cases. The first case that I am appearing is the writ petition 102/907. In that case,
no, the second impugned notification is 1/12/2018, Annexure G. In the prayer, my lord, he has challenged Annexure G, which is 2018.
21 ಮತ್ತೆ ಯಾವುದು?
ಅಷ್ಟೊತ್ತಿಗೆ ನಮ್ಮ ಪ್ರಾಜೆಕ್ಟ್ ಸ್ಟಾರ್ಟ್ ಆಗಿಬಿಟ್ಟಿತ್ತು, ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೂಡ ಸ್ಟಾರ್ಟ್ ಆಗಿತ್ತು
19/7 mandates that project should be completed within 1 year. Proviso to that says that in the event it is not completed within 1 year, for reasons recorded in writing, you will have to, extension is there, you will have to extend it and publish it. The extension should be published.
Which is not that. Is the case. And unless the respondents prove the condition.
Justice M.I. Arun order concerning railways only, he has said it cannot be done. Ultimately, if you are entitled to compensation, interested in compensation, definitely we can direct to be paid, but not stalling of the project. Justice Sanjay Gaudru dadmele ad bandiradu.
On instructions, I have made it clear to my learned instructing counsel.
Because if 100 meters is holding this project and it has held for the last 4 years, that is
I have to be fair to the court.
Gross damage to public.
No, it is. There are various other considerations.
No, ultimately, sir, if you succeed, what do you do with that land? Nothing. Ultimately, what do you need is compensation.
Compensation.
Now today, 19(7) compliance agilla anta, even if I have to set it aside,
They may issue a fresh notification and I will all that I'll be.
all the
interested on
nuances or whatever is found by this court can be corrected by them now. In a railway track, when everything is done, ಮಧ್ಯದಲ್ಲಿ ನೀವು ಬಿದ್ರು ನೀವು ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ?
ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು, it's very difficult.
ಚಾಯ್ಕಿ ದುಕಾನು ಆಗಲ್ಲ ಅಲ್ಲಿ.
May for your lordship's kind consideration.
Yes.
Submit this. So far as the entitlement of the petitioner for a fair compensation under the 2013 Act.
Yes.
Notwithstanding the interim order granted.
Yes.
Notwithstanding the violation of 19(7).
Yes.
In what manner, the best manner, to get the fair compensation, I leave it to your lordship. Because,
See, Leonard
in this
ASG
case-
also said, if it is the case of compensation, definitely
Certainly.
court can pass any order. But project cannot be stalled. He is
I
right.
consider that. That's why I
On
said.
either side, madam, everything is done, madam. One side,
ಅದಕ್ಕೆ
100%, the
ಚಾಯ್ಕಿ
other side.
ದುಕಾನು ಆಗಲ್ಲ ಅಲ್ಲಿ.
They only for 160 meters, madam.
There is a pit of about 20 feet down, and even if the railway starts
ಏನು
playing,
ಆಗಲ್ಲ.
nothing can be done. My own.
No, we'll fill it up. No, in terms of the
not that.
execution
I'm
of work.
not
No,
trying to-
railways knows what they know
Yeah,
what
true,
best
true,
could be
true.
done.
Yes, yes, sir. I'm not requesting my lord to extend the interim order or not grant relief to you. My only concern is, this land, the dolomite and limestone, which I'm quarrying, will come to a standstill. That can be taken out of file.
But where is your license?
You see, it's there, but it's not true, or factually it's not correct that my license had expired. In fact, 2013, it had expired, and it is extended by another 20 years, by under the provisions of the deemed extension, which the Department of Mines and Geology itself has communicated to the government, the railway department. So it's extended, and on the date when the preliminary notification was issued, several preliminary notifications, quarrying activities were conducted. We had to stop that because, my lord, the previous order, just now read out to your lordship. It's true that the explosions had to take place. Now all that will be stopped. But with the stoppage of that explosion, my mining activity will be completely stopped, and I will be rendered.
No, I will record the statement of the Leonard ASG that there is no explosives will be used in that area at all.
No, in fact, my lord, by his own document, annexure B, it says 20 years. And with effect from
License,
86. Please have a look at the writ petition. Please have his own document. His document, mining lease, it says 20 years from 8/6/2023. Not, why will I not go by that?
8/6/2023.
From 2003, it has ended on 8/6/23.
No, 23 it expires, I understand, but by a communication dated 29.
He has not produced any other renewal. So why would I not take it that it has expired?
Let us not get into that. Now, we will not stall this project at all.
No, certainly,
Now, you are entitled to compensation, will direct compensation to be determined in accordance with law.
Yes, my lord, absolutely. Lord, it is his right. It is his right.
My only endeavor would be to persuade your lordship that on 24/7/25, communication was sent to the Deputy Chief Engineer, Construction, Club Road, so on, so Southwestern Railway, stating that under the deeming provision of extension, it is done, it's extended. So it's not my document, it's the document of the government.
Extension is done.
Yes, my lord.
Correct, but now extension is not, now there is, let us take it, there is no reasoned order. Now the entire project is over except your piece of land, all right?
Please,
Now I say 19(7) comply ಮಾಡಿ ಅಂತ ಒಂದು ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ ಅದು ಮಾಡ್ತಾರೆ. ಅದರಿಂದ ಯಾರಿಗೂ ಉಪಯೋಗ ಆಗಲ್ಲ.
I'm not insisting, I want your lordship to pass an order and dispose of all these cases today.
Yes.
Only thing is protect the interest of the petitioner.
Compensation.
Compensation.
Yes,
only.
certainly,
Compensation.
certainly. I concede to that.
All the rights of the petitioner are kept open to be agitated before the, and
Compensation.
Yes,
Yes, you have all the remedy in law.
No objection.
No objection
I
at
have
all.
also challenged the award passed, without hearing me. Now I have to go to the reference court, there will be delay, and all these things may kindly be clarified so far in the interest of the project only.
No problem. All that we will determine. Sir, award, compensation, let them agitate.
There is actually an award. Award is already passed.
If you are agreed with the award, you can challenge it.
Yeah, I can challenge it.
I have to, there is the limitation aspect which may.
All that we will hear, cover it up, saying if since the petition is pending here,
And there is an
in
interim
case
order.
and where you have challenged the award also.
It
you
will be
can-
considered
you-
on
you-
merits.
It should be considered on merits without reference to
Without
limitation.
reference to limitation.
Correct.
That right,
That's
Lordship?
Yes. That's precisely what I also wanted to.
Ashton.
And my lord, it would be a very unfair on the part of any of the citizens to stall a project like this.
ಅದು ಎಲ್ಲ ಆಗೋಗಿ ಇದು ಮಾತ್ರ ಉಳಿದಿದ್ರೆ and it is going to benefit
Yes, yes, true, my lord, I consider that. I consider.
scores and scores of people. So,
Please, please.
And industries as well.
whatever, it's. But why is this kept pending for the last 4 years?
Which is why, my lord, I came in.
No,
But,
my lord, adjournments were sought on the ground that Lord ASG would come and address the, well, assist this.
In fact,
Today it has
last,
happened.
in fact,
Today
I had
it
come
has-
once when Lordship Justice Yerur was here. No. Then, my lord, it was heard briefly and adjourned. And thereafter, it was not online, I appeared before the other courts.
No, because these projects,
Yes, yes.
why
yes.
keep it
I mean,
for 4 years?
It is in national interest, it is in public interest.
I do consider, my lord. That's why I'm not
No, if
arguing.
both of you are saying that and you are conceding that, why is it kept pending is what I'm asking.
That I don't know, because for
but
the
that
first
should
time
have
today,
been,
today I am engaged to assist your lordship.
that's not really. No, such things should get over fast.
Please, please.
Serial number 70, no? How many matters are there? 3, Three matters. The petitioners in all these cases call in question the acquisition process and the culmination in an award by the, initiated by the Government of India, state,
By state.
by the
Initiated
state
by the state.
for the benefit of laying down railway lines. The heard the learned senior counsel, Sri Gangadhar Gurumat, appearing for the petitioner, the learned additional Solicitor General of India, Sri Arvind Kamath, appearing for the respondent. Which respondent is this?
Number 3.
Respondent number 3, the railways and KSRTC sir yarige?
1 and 2.
1 and 2, counsel Sri Keshav Reddy representing 1 and 2. The petitioners claim to be the owners of the land as depicted in the petition to measuring and the measurements depicted therein. The issue is with regard to the quarrying of mining operations of the petitioner being stalled on account of the acquisition process instituted by the correct?
By the respondent.
By the respondent state by issuance of a notification under section 4(1) of the Land Acquisition Act and
That's long ago, my lord. After that,
It's under the new act.
the challenge before.
under the new act, all it.
The new act.
11(1) and 19(1).
Under acquisition preliminary notification being issued for acquisition, which was
Page 103.
which was from time to time changed, and the latest being of the year 2018.
2021.
21, na?
2020.
Latest being of the year 2020. The learned senior counsel for the petitioner submits that in terms of the new act, the 2013 act, taking this code through subsection 7 of section 19 of the said act would contend that an acquisition process, acquisition that was initiated by issuance of a preliminary notification under section 4(1) of the 4(1)
It's 11.
11(1).
Under 11(1), correct. Under 11(1) of the act must stand completed within 1 year from the date of its publication. The learned senior counsel submits that the proviso, though provides for extension, such an extension has not happened in the case at hand, and would seek to place reliance upon the judgment of the coordinate bench of this court. Justice Sanjay Gowda, the coordinate bench of this court. Per contra, the learned ASG would again take this court through the very documents to demonstrate that the petitioner, what the petitioner would lose is the mining operation to which license has also expired is the submission. The learned ASG would submit that the entire project is complete except 160 square meters.
One section.
160 square meters of the land of the petitioners, which is now locked by the railway lines drawn as it is in the middle of the railway lines already drawn of all the other land all the other land losers whose lands have been acquired for the said purpose. The learned ASG would further submit that all that the petitioner is wanting is compensation. Compensation in accordance with law as now the preliminary in accordance with law. In the light of the said submission and contra submission, what would necessitate consideration at this juncture is a railway line that is drawn on either sides has become railway line that is drawn has now reached a standstill on the ground of the land of the petitioner being in the middle of two railway lines coming. The learned ASG has taken this code to the project for which it is acquired, which would benefit scores and scores of people and industries. The learned senior counsel, Sri Gangadhar Gurmat, would fairly submit that yes, a project of national importance or the railway line that would help scores and scores of people must not be stalled for the interest of the few, but would submit that the petitioners are entitled to adequate compensation, and such compensation should be determined and the compensation be paid. At this juncture, the learned ASG would submit that the award is already passed and compensation is deposited before the concerned court. The learned senior counsel Gangadhar Gurmat submits that he would file applications for enhancement of compensation before the appropriate authority under the Act, District Court, Reference Court for enhancement of the under the Act. What would come in the way is the limitation under the statute. In the light of the petition pending before this court, where the award also is challenged and the petition pending for the last 4 years and an interim order subsisting in favor of the petitioners, I deem it appropriate to observe and direct that the reference court would answer the reference for enhancement of compensation if filed by these petitioners in accordance with law without reference to delay. In the event the petitioners would prefer the appropriate petitions before the reference court within 3 months from the date of receipt of the copy of this order.
Statutorily, we have to approach the LAO first.
Whatever.
To refer it.
He has to refer, alva? Government. You immediately refer it. The learned counsel Sri Keshav Reddy submits that the moment the application is preferred before the land acquisition officer, he would, without broking any delay, refer the matter to the reference court under section 18.
64.
64, under section 64 of the Act. In the event such a reference is made as observed herein above, the reference court shall answer the reference on its merit without getting into the issue of limitation. The other legal issue that is projected before the court with regard to section 19(7) and the order passed by the coordinate bench, should we answer that?
No, Your Lordship will say he has given up for in all fairness to the petitioner.
I dispute that.
Statutory.
Subsequent Justice M.I. or railway that is not.
We have the records, but since that ground was not raised.
No, that's so. Justice Sanjay Gowda munche barದಿದ್ರು adanna he has distinguished and written. Justice M.I. You have not seen Allah.
Without reference to that, the writ petition stands.
No, that's all right. In the light of the submissions as recorded here and above, the submission with regard to compliance with 19(7) or otherwise need not be gone into. The petitions would stand disposed on the aforesaid observations. For the aforesaid reasons, the following order: the petitions stand disposed, interim order of any kind stand dissolved.
The compensation can be determined by the court without reference to any of the limitation. Keeping all the content.
Correct. The petitioner is at liberty to petitioner stands with liberty to approach the reference court in accordance with law, seeking enhancement of compensation if he is so aggrieved by the award so passed, as the award itself is under challenge before this court. In the event the petitioner submits an application to the land acquisition officer within
2 weeks.
within 4 weeks from the date of receipt of the copy of the order, the land acquisition officer shall transmit the application before the reference court under section 64 of the Act without broking any delay. The concerned court shall answer the reference so placed before it without reference to limitation and on the merit of the matter. All contentions qua compensation shall remain open to be considered by the concerned court. With the aforesaid observations.
Small
Order
correction.
recording.
While dictating, your lordship was pleased to dictate that the amount is deposited. I'm instructed to submit it's not deposited.
Amount is deposit madilva.
Totally deposit madilla ante.
Award is passed. Sorry, adanna tagdu. We'll remove it. Award is passed.
Award is passed.
Award is passed.
Tomorrow they will be deposited.
Maybe they will.
All right. Anyway, award is passed.
No, while I am grateful to your lordship for disposing, I must express my deep sense
No,
of
sir.
gratitude for his fairness. Lord, it's very easy for lawyers to stand up and argue because they have received the instruction. But not to stand up and to be fair,
he is that way,
it
not
requires
today.
a different level of.
I have the
I am deeply
authority
obliged to him.
of instructions to make the submission before all. Therefore, I.
Council also.
Yes,
Council on record
Also
should-
deserves, my lord, both of them.
Yes.
Grateful to you.
Yes, sir. So now, what time is your flight?
That's at 8.
Inyavadu ilva?
Very circuitous route.
Then why
One more
Belgaum?
small submission.
Uh,
There are 3 different dates of notification in the 3 different cases that we can.
adondu. Idu Ravi.
Lord, if separate
already
orders are
instructed
passed, it is
counsel.
better. Separate orders are passed, it will be better.
Separate orders. Best.
Please.
No headache. Separate orders.
Obliged to you.
It is better for so many reasons.
Please.
Yes.
Number 57, Naveen Chatra.
50?
57.
FC.
Court notice is issued to the respondent is not served.
Not served.
What happens if the 13% is not appearing before honorable court?
Again, man.
The writ petition has to be, because what happens to
Report to the principal judge, service in respect to unserved. You are the wife.
Awesome.
What is the matter?
It's what happens,
What happens, Allah? What's the matter, sir?
The respondent here has filed 2 suits with the same prayer against the same party. Hence, the wife has filed an application for the stay of the subsequent suit.
2 wives.
Allah Swami. 2 suits are filed with the same
One
prayer.
wife ke ಎರಡು suit.
Third suit. With the same prayer, that to declare that the marriage solemnization is not pending and to not to take the name of the respondent. With the same prayer.
Not take the name of the respondent.
ಅಂದ್ರೆ ಅವರಿಗೆ ಅದು ಎರಡನೇ ಮಗುವನಿಗೆ ಜನಿಸಿಲ್ಲ ಅಂತೇಳಿ ಅವನಿಗೆ ಕಂಡೀಷನ್ ವಿತ್ ಸೇಮ್ ಪ್ರೇಯರ್ ಸೇಮ್ ಪಾರ್ಟಿ ಒಂದ್ ಏಟ್ ಹಿರೇಕೆರೂರ್ ಒಂದ್ ಏಟ್ ಹುಬ್ಬಳ್ಳಿ.
ಸರಿ, ಈಗ ಏನ್ ಮಾಡೋಣ ಹೇಳಿ?
ಮೈ ಅಪ್ಲಿಕೇಶನ್
ಹಿರೇಕೆರೂರ್ ಬೇಕಾ ಹುಬ್ಳಿ ಬೇಕಾ? ನಿಮ್ಗೆ ಯಾವ್ದು ಹತ್ರ?
ಅದು ಹಿರೇಕೆರೆಯಲ್ಲಿ ಹಾಕಿದ್ರೆ ಅದಿದ್ದು ಹುಬ್ಳಿದು ವಜಾ
ಹುಬ್ಳಿ ವಜಾ ಆದ್ರೆ
ಅಂದ್ರೆ ಅದು ಸ್ಟೇ ಆಫ್ ಸೂಟ್ ಹಾಕಿದ್ರೆ ಅದು ಸ್ಟೇ ಐ ಅಲೋ ಸ್ಟಾಕ್ ಸಮಸ್ಯೆ. ಮೈ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಓನ್ಲಿ ಫಾರ್ ಸ್ಟೇ ಆಫ್
ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರೆ ನಾನು ಬೆಂಗಳೂರಿಗೆ ಹೋಗ್ತೀನಿ. ಏನ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ ಯಾವ್ದು ಬೇಕು ಅಂತ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಇದ್ರದಿರ್ಲಿ ಅಂತ ಇದರಲ್ಲಿ ಅವ್ರು ಹಾಕಿದ ರೆಸ್ಪಾಂಡೆಂಟ್ he has to decide it because
List tomorrow in fresh matters list.
please.
Seal number 58, R.H. Angli.
Reporting settlement.
Please, my lord, matter was not settled, my lord. Earlier, there was a proposal that 20 lakhs towards mother and 25 lakh towards son, my lord. But there, one more term was that the son would not claim his right over property. On that reason, the settlement does not happen, my lord. And it
Counsel
is
for the petitioner submits that talks of settlement have failed. List the matter of preliminary hearing on 18th.
59, Satyojit.
Office of the council submission in Kodi. No.
Seeking mandamus, take instruction.
Grant compensation will.
Mandamus, land
The
compensation.
petitioner is, of his objections overruled. The petitioner heard the land counsel of the petitioner and the respondent. The petitioner is before this court seeking the following prayer. It is the case of the petitioner that in terms of a notification dated 14/8/2019, the government notified that 5 lakhs would be paid to flood victims and also 5,000 per month as the expenses for the next 10 months after the said date. The learned counsel, the bank, the representations to that effect have gone unheeded. Therefore, the petitioners are before this court seeking the aforesaid prayer. The learned counsel appearing for the state would submit that if reasonable time is granted, the representation of these petitioners should be considered and appropriate orders would be passed in accordance with law. In the light of the said submission, without entering upon the merit of the claim of the petitioners, I deem it appropriate to direct the respondents herein to consider the representations of the petitioners and pass necessary orders in accordance with law for the purpose for which such representations are rendered within an outer limit of 4 months from the date of receipt of the copy of the order, if not earlier. Please ordered accordingly. Next.
Number 60, Sridhar Prabhu.
Writ appeal is pending. Writ appeal is pending.
Lord. 60.5.
Lord, I appeal for the.
Prashant.
I appeal for the respondent. Lord,
You need an.
Lord, I represent the respondent.
You're not to be seen.
They are cemented by his presence, Lord. He now appears against us for the ESCOMs.
ESCOM?
ಹೌದು
ಯಾರು ಪ್ರಶಾಂತ್?
ಹೌದು ಹಾಗಾಗಿ ನಮಗೆ we have the misfortune of representing private entities.
Lord, I had filed a memo. Am I audible?
Memo that you will withdraw the impugned order?
No, I've produced 2 orders, my lord. On the last occasion, my lord had
all this I have considered and passed it. ಇದರಲ್ಲೇ ತಾನೇ detail order ಮಾಡಿರೋದು.
ಹೌದು. He says, my lord, that subsequent
appeal ಇತ್ತಲ್ಲ ಏನಾಯ್ತು ಮೊನ್ನೆ?
ಅದೇ ಅದು ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡಿದೆ. It is for their reply, my lord. He has to reply.
Lord, it is
ನಾಳೆ.
Lord, it is posted on the 14th. Lord,
14th. Let it be adjourned, my lord.
So far as
ಮುಗಿದಿದೆ ನಂದು ಆರ್ಗ್ಯುಮೆಂಟ್
ಮುಗಿಸಿ. This court had adjourned these matters on the score that the writ appeal, ಯಾವುದ್ರ ಮೇಲೆ writ appeal?
Against the order of the
writ appeal is preferred and the matter was being heard by the division bench. Yes. Learned counsel Sridhar Prabhu submits that the division bench has heard the petitioners, heard Sridhar Prabhu appearing for the
reply argument.
Appeal nimdena?
Their appeal, my lord. Their appeal. I succeeded. These are batch matters. One nan succeed.
ಯಾವತ್ತಿದೆ next ಹೇಳಿ?
It is 14th November.
This the matter on 18th in preliminary hearing.
Interim orders.
Interim order till then stands extended.
19th, my lord, I'm
difficult interim order extend ಆಗದು. Anyway, ಅಲ್ಲಿ appeal ಇದೆ ಅಂತ ಮಾತ್ರ ಮಾಡ್ತಿರೋದು.
ಅಲ್ಲ ನಾವೇ succeed ಆಗಿತ್ತು.
Just one matter. List the matter on 19th.
61 is in Karwa.
Office objections maintainability. Why? ಯಾವ್ದ್ರದ್ದು?
Claiming damages.
Damage award.
Award.
Office objections overruled. List the matter day after tomorrow in fresh matters list. Next.
62.
ಇದು ಅಷ್ಟೇ ಸೇಮ್. ಕಲ್ವಡಲ್ಲಿ ಇವರೇನಾ?
64, my lord. This is regarding.
Wait, sir. Sixty-two ಅಷ್ಟೇ ಸೇಮ್ ಆರ್ಡರ್. 63 ಯಾರು? Marthand.
63 myself, my lord. This is a case where in the reference, before the reference court, I was not made a party. I am the.
Office objections overruled. Day after tomorrow in fresh matters list.
Please.
64, Nitin Ramesh.
64, not, they seek some time to not get instructions.
This is a case of officers, I mean, assistant engineers, who are coming within various ESCOMs, madam. The KPTCL now has come up with a new policy where it has merged all the ESCOMs so far as preparation of the seniority list is concerned. This was initially done through a draft notification of new rules and thereafter finalization of those rules. My lords, all the petitioners before my lord are officers or applicants. Originally, they all had the status of under the 371J. That was prior to even joining. Now, these certificates are not in question. That is not the disputed fact at all.
All right, your position is not in question.
That is not in question. In fact, I put all of them in the part of the petition just for bona fides. The issue is, if the common notification is brought, and in the HKKK list which they have, my lords, they have the two lists, non-HKKK and the HKKK. Your lordship will see that the HKKK list is consisting only of those engineers who were originally recruited only by KPTCL.
No.
That is because they had the option at that time.
That's what. See, it may be a circumstance.
Please.
But under 371J and
Please.
the government order that was issued
Please.
Later.
2013, 2014.
2013,
Please.
the government order is issued.
Please.
Options were called.
Please.
All of them have opted to come within the
Please.
ambit of 371J
Yes.
and the seniority
Yes.
list separately to be
Please.
drawn there.
Please.
It may be a coincidence that everybody are appointed by the KPTCL,
Yes.
but that's an option.
No, my lords. In my case, I fall in a peculiar bracket. I was recruited based on a 2014 notification.
After this.
It was after the constitutional amendment, which gave me the right. But the operational guidelines came later in 2014.
Correct.
By then, the notification had already happened. And I was recruited without any of those options. So what happens, only one important fact I'll complete, my lords. Having recognized this peculiar circumstance in my case, in the draft notification rules, specifically in paragraph 8, the same KPTCL says that you will be given an option to choose now whether you want to fall in HK list or non-HK list.
You are never given an option?
No, I was never given an option. Now what happens is, in the final rules notification, they are giving some ground saying, no, cutoff is 1/1/2013, therefore I will not be taking you. My lords, I was always in that region. And if I may mention, my lords, His Lordship Justice Sanjay Gowda, in one of the, in fact, concerning Assistant Engineer, Your Lordship, remember Naveen Kumar's case, looking into the facts there said, no, this is injustice. We will give them an option this time to do it. Of course, that was only for the KPTCL. Facts are slightly different. I don't want to claim precedent value on that basis.
Option kodtira?
I want only that option. I want what they wanted in draft rules.
But I have to take instruction note because I was served with the notice note recently, last week.
No problem. Option you have to give because it's the constitutional amendment and the order that was passed by the government in 2013.
Yes.
With regard to that.
If those give rights, you cannot take away
Exactly.
saying that I will not give you option that cut off, this cut off.
Definitely, my lord, I will examine.
If the domicile is correct, see 371J is not a reservation that happens on other circumstances. It is a reservation qua domicile.
Domicile.
So domicile reservation is very difficult to take away because
Yes.
they are from
We
that
all
area.
have certificates. None of us is coming without that.
You
sir.
can't. So recently I've written judgment.
Your Lordship has written.
Last time,
Regarding some clerks, my lords, I remember.
seniority
but-
list ಅಲ್ಲಿ now.
Lord, I know it, Lord. Lord,
ನೀವೇ
I've seen that
ಇದ್ರಲ್ವಾ?
also.
He stood first in that list. Then given general merit. Then seniority ಬಂದ promotion ಕೊಟ್ಟಿಲ್ಲ because you belong to general merit ಅಲ್ಲಿದ್ದೀರಾ
merit, ಹೌದು.
KK ಬರಲ್ಲ ಅಂತ.
ಅಲ್ಲ, ಇಲ್ಲಿ
ಅಪ್ಲೈ ಮಾಡಿದ್ದು KK ಎಲ್ಲ KK ಇದೆ.
ಹೌದು.
Just because he is in general merit, that doesn't mean he loses his reservation,
His reservation.
domicile reservation.
Correct. And there's one more angle.
Kapil
Which is,
Akil.
Lord, I will just look, Lord, it requires, Lord, consideration, Lord.
they will have to file, my lords, it's
Lord,
been
even
4
I
months,
was-
they have not
Yeah,
filed
there's an interim
objections.
order.
There is an interim order
interim.
which says that so far as HK list is concerned, the finalization of seniority list must not be done, my lords. That is the,
What else can you get?
my lords, my problem is the promotions they're going ahead. Now, this cannot be clearly bifurcated.
Lord, I
my
can
lords.
understand, Lord, the very short time, Lord, the Lordship, Lord, give, Lord, will take
The
instruction.
learned counsel BS Kamte heard the learned counsel Nitin Ramesh appearing for the petitioner. The coordinate bench of this court on 4/7/2025 had passed the following order. Therefore, there is an interim order of operation of the seniority list. The learned counsel for the petitioner submits the promotions are going on.
Yes.
it is.
Likely to go on, not going on. I don't want
Promotions
to
are
make-
likely to happen. If the
Is-
seniority list itself is stayed, it is ununderstandable as to how promotion would be affected. Therefore, the learned counsel B.S. Kamte to secure instructions, file objections as the case would be by the next date of hearing. List the matter on 26th
Please.
November.
Can it be on 21? Would it be difficult?
21 is Friday.
Let it be on 26.
26,
ಇಲ್ಲ,
very good.
ಹಾಕ್ಬಿಡ್ಲಿ.
26.
ಇಲ್ಲದ್ರೆ ಮತ್ತೆ ಟೈಮ್ ಕೇಳಿದ್ರೆ. Objections, if an ಇನ್ಯಾರಿದ್ದಾರೆ objection ಹಾಕೋರು?
ಅಷ್ಟೇ. Very
Objections.
note, parties are there, no, private parties are there.
ನೀವು
Candidates.
objection ಹಾಕ್ಬೇಕಾ? ಏನಿಲ್ಲ, ಅವ್ರು.
Please.
Since they would file the objections to just help them, and once I make the submission.
wanna help
Lordship-
them file their
Alla,
objections?
your lordship will never forget it. So I only want to say
Alla,
this.
Hyderabad, Karnataka.
Other peculiar circumstances.
ಏನ್ ಅದರ
If the, ಅಲ್ಲ, ನನ್ನ ಕೇಸಲ್ಲಿ ಅಂದ್ರೆ, if the KPTCL is to some extent by coming up with a common merger of all ESCOMs, taking away certain privileges that I had of early promotion, my lords. What would have happened is, if I had stayed in the seniority list of only my ESCOM, I would have had a better chance at
So
promotion.
that is not yet happened.
No, ಅಲ್ಲ ಆಗಿದೆ. ಈಗ ಯಾಕಂದ್ರೆ the merger ಆಗೋಯ್ತು. So I come in the common pool. So I come way down anyhow. So if I suffer disadvantage on account of common seniority, I should also be entitled to the rights which the other
Will
KPTCL.
answer.
That is one. Fresh matter.
Will answer. Fresh ಇಲ್ಲ.
Preliminary hearing.
Preliminary hearing, yes.
Great.
That is.
Next.
65, Girish V. Bhatt, Girish Kulmani.
Office objections overruled. ಏನು?
Surface Act, my lords, 27 lakhs. 4 lakh I have deposited.
ಇದೆ?
18 ಲಕ್ಷ ಲೋನ್ 22
ಆಯ್ತು,
ಲಕ್ಷ
ಈಗ
ಆಗಿದೆ.
ಎಷ್ಟಿದೆ?
4 ಲಕ್ಷ ಡಿಪಾಸಿಟ್ ಮಾಡಿದಾನೆ.
28 lakhs is the outstanding amount, my lords.
ಮನೇನಾ?
ಮನೆ ಇದೆ.
ಆ?
ಮನೆ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಪ್ರಾಪರ್ಟಿ.
They are not coming forward to deposit the amount, my lords. They have obtained an interim order, even that order is also not complied, my lords.
ಯಾವ್ದು ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ವಾ?
4 ಲಕ್ಷ ಮಾಡಿದ್ದೇವೆ, 6 ಲಕ್ಷ ಮಾಡಬೇಕು.
25% of the amount.
ಮಾಡ್ತೀರಾ?
Another 2 weeks time.
No 2 weeks. I'll give you 1 week's time. 2 lakhs deposit ಮಾಡಿ. 1 week ಬಿಟ್ಟು ತಗೊಂತೀನಿ. ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ. List the matter on 17th in the fresh matters list. In the event 2 more lakhs as directed on 10/9/2025 is not paid, the petition would stand dismissed.
Please.
ಅವತ್ತು ನೋಡೋಣ. ಮನೆ.
Please, my lords.
Yes.
ಯಾವ್ದು ನಿಮ್ ಕೊಟ್ರು ಶೆಟ್ಟರ್?
I appear for
Post immediately after
petitioner.
service of notice.
Lord,
upon-
elections are over, Lord. I produce the declaration of election result along with memo.
No, that is not the thing. Here, my lord,
Okay.
what happened?
But they have to challenge.
But in my absence, my lord, vote is counted. It is against the rule 1410.
ನಾನ್ ಕೌಂಟ್ ಮಾಡಕ್ ಹೇಳ ಮೇಡಮ್ ಇಲ್ಲಿ.
ಅಲ್ಲ, ನನ್ನ, at the time of my present, my lord, my vote is 108.
ಓಹ್, ಇದು 108 ಪ್ರಾಬ್ಲಮ್.
Please, my lord.
ಅದು ಕೌಂಟ್ ಮಾಡಿದ್ರು
108. Thereafter, my lord, in my absence, my lord, it is 78. Therefore, my lord, in my presence, as per.
vote in another counting ಆಗ್ಬೇಕಾ?
ಹೌದು, 1410 ಅದೇ ಹೇಳುತ್ತೆ.
Returning
They
officer
have
is
to be
present.
present, my lord. The candidate to be present.
All the records are secured.
ಇಷ್ಟೇ ಇದೆ ನೋಡಿ. Counting
So typographical error of 108 is corrected as 78. ಬಂದಿರೋದೇ 78.
Subsequently count ಮಾಡಿದ್ದಾರೆ. Subsequently it is counted, my lord. Your lordship.
That's what prima facie I get.
I have also not
Your
counted.
lordship kindly see rule 1410 for a moment.
Lord, I have also counted, my lord. It is
14.
7. ಇದರಲ್ಲಿ tabular
ಅವರು-
ಅವ್ರದೇ ಇವ್ರದೇನೆ. ಅಷ್ಟೇ ಇದೆ, 78 ಇದೆ.
Defeated candidate ಕರ್ಕೊಂಡು
It is
ಹೋದ್ರು
78.
ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ನ ರೌಂಡ್ ಅಪ್ ಮಾಡಿ 78 ಅಂತ ಬರ್ಸಿದ್ರು. That is what happened.
Page 19 you
ನಾನು
lost
ಇಲ್ಲ
my
ಅಲ್ಲಿ. I am not there.
ಅಲ್ಲ ಅವ್ರು ಇದ್ದಿದ್ದೇನೆ my lord. Page 19 you lost my tabular ದಲ್ಲಿ
10 ಕೊಡಿ ಏನದು?
ಅಷ್ಟೇ ಇದೆ. Lord, memo my lord, along with memo.
1410, my lord. Counting of votes. Rules.
ಯಾವ ರೂಲ್ಸ್ ಮೇಡಮ್?
Rules, my lord.
Which rules?
Karnataka Cooperative Societies Rules 1960. 1410, Roman 10.
One moment.
After the polling is over, the polling officer shall close the poll and deliver the sealed ballot bags to the returning officer, who shall arrange for counting of votes immediately. Votes shall be counted by or under the supervision of the returning officer or the assistant returning officer. Each candidate or his authorized agent shall have a right to be present. I was present at the time of issuance of the annexure C, my lord.
108.
108. Thereafter, my lord, annexure D, my
Date you are not present.
ಇಲ್ಲ 9:30 ಗೆ ಆಮೇಲೆ subsequently after 9:30 I am not present.
You count it in our present.
My
Please,
my lords, may I permit continuation of reading?
Moreover,
But-
my lord, totally 1250.
Nothing is over, wait.
But the continuation of reading, my lords, section rule 14X, my lord. But the absence of any client or his agent at the time of counting shall not vitiate counting or announcement of result by the returning officer. The absence, my lord.
But shall present in presence of the
No, the whole
candidate.
problem is 108 ಇರ್ಬೇಕಾದ್ರೆ
I am present.
present.
But that is not final.
78 ಮಾಡ್ಬೇಕಾದ್ರೆ ಯಾಕಿಲ್ಲ?
Result was not announced.
My
my lord.
knowledge,
It's all right, sir. 78 ಮಾಡ್ಬೇಕಾದ್ರೆ ಯಾಕಿಲ್ಲ?
Lord, may I make
my
one
knowledge
submission?
it is recounted. I'm sorry.
Lord, I'll make one submission. Page 13, Lord, ಅದು ಟ್ಯಾಬ್ಯುಲರ್ದಲ್ಲಿ 78 ಕೌಂಟ್ ಆಗ್ತದೆ. Page 19, Lords may kindly say. Page 19, ಅವ್ರದೇ ಡಾಕ್ಯುಮೆಂಟ್.
108 ಯಾಕೆ ಬಂತು ಮತ್ತೆ?
Yes, Lord. Returning officer is present.
ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಯಾರಿಲ್ಲ? 108 ಯಾಕ್ರಿ ಬರದ್ರಿ? ರಶ್ನಾಗ
Crowd.
ಈ ಕಡೆ ಬನ್ನಿ. ಎಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿರೋದೇ ನೀವೀಗ.
ಪೋಲಿಂಗ್
108 ಯಾಕೆ ಬರದ್ರಿ?
ಇಲ್ಲ ಸರ್, ನಮ್ಮ ಪೋಲಿಂಗ್ ಸ್ಟೇಷನ್ ಸ್ಟಾಫ್ ಅವ್ರು ಹೇಳೋದ್ ಮುಂದೆ 78 ಅಂತ ಹೇಳಿದಾರೆ ಸರ್. ಅವ್ರು 108 ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು. ಫೈನಲ್ ಟ್ಯಾಬ್ಯುಲರ್ ಆರೋ ಕಡೆ ಬರ್ತದೆ ಸರ್. ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಫೈನಲ್ ಮಾಡಿದ್ಮೇಲೆ ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆಗ್ತದೆ ಸರ್.
ಫೈನಲ್ ನೀವು ಮಾಡಿ ಏನ್ ಮಾಡಿ ನೋಡಿದ್ರ?
ಹಾ, ನೋಡಿದೀವಿ ಸರ್. ನೋಡಿದ್ಮೇಲೆ ಅದನ್ನ ಮತ್ತೆ 78 ಮಾಡಿದೀವಿ ಸರ್. 108 ಮತ್ತೆ ಅದೆಲ್ಲ ವಿಡಿಯೋ ಇದೆ ಸರ್.
Elections result has been declared. ಆದ್ರೆ
In my absence, my lord.
Page
ಆಯ್ತು,
19
ಅದನ್ನು ಅಲ್ಲೇ ಅಜಿಟೇಟ್ ಮಾಡಿ ಮೇಡಮ್.
The
Before
thing is,
before the section 70 ಹಾಕ್ತಿರಲ್ಲ, ಇದನ್ನು ಅಲ್ಲೇ ಮಾಡಿ.
the thing is, my lord,
The thing
it
is
is a
nothing.
violation of the rule 1410, my lord.
ಎಲ್ಲಿದೆ
They
madam?
can do whatever they want, my lord. If it is in my presence, in the absence of my presence, my lord, they have.
By mistake 108 ಬರ್ದಿದ್ದಕ್ಕೆ ಇಷ್ಟೊಂದು ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲ, by mistake ಅಲ್ಲ ಅದು. Your lordship kindly.
Lord, ಈಗ Lord, one submission, Lord.
Your
ಈಗಾದ್ರೂ
lordship kindly,
ಒಂದ್ ನಿಮಿಷ.
returning officer
Page
is
19
present.
ದಲ್ಲಿ
ಪೇಜ್ 20 ಗೆ ಬನ್ನಿ.
Totally
19
notes.
Lord, 19 ದಲ್ಲಿ for a moment.
ಅಲ್ಲಿನೂ ಕರೆಕ್ಟ್ ಇಲ್ಲ. Totally
19 ನೋಡಿ.
1256 ballot papers if they have produced before your lordship, I will
ನಾನು
go
count
out from
ಮಾಡ್ಲಾ?
that. ಅಲ್ಲ ಇಲ್ಲ, ಅಲ್ಲಿ 1256 ballot papers ಇಲ್ಲ. That is the
ಈಗ 1256 ಎಲ್ಲಿ ಬರುತ್ತೆ ಹೇಳಿ?
your lordship in para number 3, total member is 1256. They have prepared 1256 ballot papers, voting papers.
ಆಯ್ತು.
That is not here.
Not
Returning,
here ಅಂದ್ರೆ?
that is not there. Ask the returning officer. If it is there, my lord, I will out of the court.
You will out of the court.
I will withdraw my petition. I will withdraw my petition.
Lord, for a moment.
ಅಷ್ಟು ಬ್ಯಾಲೆಟ್,
Lord, I'll make-
ಅಷ್ಟು ವೋಟಿಂಗ್ ಇದೇ ಇಲ್ಲ, ಪೇಪರ್ಸೇ ಇಲ್ಲ, ಮತಪತ್ರನೇ ಇಲ್ಲ.
Lord, I'll make one submission. Page 19 ದಲ್ಲಿ ಟ್ಯಾಬ್ಯುಲರ್ ಹಾಕಿದಾರಲ್ಲ.
ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಅಲ್ಲೇ ತೀರ್ಮಾನ ಮಾಡ್ಲಿ ಬಿಡಿ. This requires evidence.
ಆಯ್ತು, not to declare the result till the
ಇಲ್ಲ.
issue.
Already declared, my lord.
Declare ಆಗಿದೆ.
Declare
has
ಆಗಿಲ್ಲ.
been declared.
There is an interim order by your lordship not to precipitate further. It is not
Precipitate
declared.
ಏನ್ ಮಾಡಿಲ್ಲ, ಡಿಕ್ಲೇರ್ ಮಾಡಿಲ್ಲ.
Declare
Declare ಮಾಡಿಲ್ಲ. There is no declaration. For
No.
number 13 is not issued.
Lord, election result have been displayed. I produced not memo. Yes, declared.
ಎಲ್ಲ everything you agitate there only. ನಾನು 1256 ಏನದು ಮತಪತ್ರಗಳಿದಾವ ಇಲ್ಲ ಅದನ್ನೆಲ್ಲ ನೋಡೋದಿಲ್ಲ.
Recounting ಮಾಡಿದ್ರೆ it will come out, my lord. Recounting ಮಾಡಿದ್ರೆ, because your lordship kindly see the Supreme Court in the case of the Kuldeep Kumar Chandigarh Corporation case ಅಲ್ಲಿ it's
ಅದು
held that
ಗ್ರೇವ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದು after seeing CCTV footage.
even
ಅದಕ್ಕೆ recounting
ಇಲ್ಲಿ
order
pen drive ಇದೆ, pen
ಅದಕ್ಕೆ
drive.
recounting order ಮಾಡಿದ್ದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅದು.
Please, my lord, here also pen drive is available, my lord, but your lordship
Drive
has no.
ತಂದಿದೆ.
Last occasion your lordship directed to.
ಪೆನ್ ಡ್ರೈವ್.
ಹೌದು, ಹೇಳಿದಿರಿ
ಅಲ್ಲ,
ಅದನ್ನ.
page
pen drive
19
ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ತಂದ್ಕೊಡಿ ವಿಡಿಯೋ. What is the video?
ಟ್ಯಾಬ್ಯುಲರ್ ನೋಡಿದ್ರೇನೆ ಅದು ಅಷ್ಟೇ ಇದೆ. 78.
Videographed.
Page 19
ಈಗ
Lord.
ಪ್ರೈಮಾ ಫೇಸಿ ಸ್ಯಾಟಿಸ್ಫ್ಯಾಕ್ಷನ್ ಗೆ ಕಮ್ ಟು ಪೇಜ್ 19.
19 ದಲ್ಲಿ
19.
ಐಟಮ್ ನಂಬರ್ 2 ಅವ್ರಿಗೆ ಬಿದ್ದಿದ್ದು
108 ಅಂತ ಇದೆ ಇಲ್ಲಿ.
ಅಲ್ಲಿ ಕೌಂಟ್ ಮಾಡಿದ್ರೆ ಟ್ಯಾಬ್ಯುಲೇಷನ್ ನೋಡಿದ್ರೆ
ಎಷ್ಟಿದೆ ಹೇಳಿ?
Page
78 ಆಗ್ತದೆ.
Page 15, my
Page 19 ದಲ್ಲಿ
30,
ಈಗ
30,
ಇವರು
18.
ಬಿದ್ದಿರೋ ಮತ ಇಷ್ಟೇನಾ?
78 ಇಷ್ಟೇ. ಅಷ್ಟೇ.
ಇಲ್ಲಿರೋದು ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
ಅದು 78 ಹೆಂಗಾಗುತ್ತೆ ಇಲ್ಲಿ ಹೇಳಿ?
ಇದು ನೋಡಿ 5, 10, 15, 20, 25,
30, 30 and 18, my lord.
ಅದನ್ನೇ
30, 30,
18.
30, 30, 18.
ಅಷ್ಟೇ
5, 6, 35.
78
ಆ
ಅಷ್ಟೇ.
ಮತಪತ್ರನೇ ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. Therefore,
ಅಲ್ಲ, ಈಗ ಇದು ಬಂದಿರೋದು ಇದು.
ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಇದೆ
ವೋಟ್ ಬಂದಿರೋದು ಈ ಕಡೆ.
ಅಷ್ಟೇ.
108 ಮಿಸ್ಟೇಕ್ ಅಲ್ಲಿ ಬರೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲಾ ಪೇಪರ್ ಅಲ್ಲೂ ಬರೆಯಕ್ಕಾಗಲ್ಲ. ಎಲ್ಲಾದ್ರೂ ಒಂದ್
ಈಗ
ಕಡೆ
ಒಂದ್
ಬರ್ದಿರ್ಬೇಕು.
ನಿಮಿಷ
Annexure C,
ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್, ಇದ್ರಲ್ಲಿ 108 ಬರೆದ್ರು ಒಂದು.
ಪೇಜ್ ನಂಬರ್
now
15, ಪೇಜ್ ನಂಬರ್ 15 ಮೇಲೆ.
Same thing is carried forward here.
ಅಲ್ಲ, ಫಸ್ಟ್ is ಪೇಜ್ ನಂಬರ್ 15.
We will direct the ಯಾರಿದೆ section 70 dispute ಅಲ್ಲಿ ಫಸ್ಟ್ ಇದನ್ನ ತೀರ್ಮಾನ ಮಾಡಕ್ಕೆ. Please.
ಬಟ್ ಅಷ್ಟು ಮತಪತ್ರನೂ ಇಲ್ಲ. They have
ಅದೇನಿದೆ
irregularity ಆಗಿದೆ. Therefore it is covered by judgment of Kuldeep Singh. ಇಲ್ಲಿ irregularity ಆಗಿದೆ.
Kuldeep Singh is Chandigarh Municipal Corporation.
Please ಮೇಲ. ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಫೇರ್ ಅಂಡ್
ಇದು ಇದರಲ್ಲಿ I am not seeing the gross unfairness here to apply Chandigarh administration case. Yes, the petitioner is before, I will record everything and send it. The petitioner is before this court seeking quashment of an order dated 25/10/2025 and seeks declaration of election of the petitioner, declaration of counting of the petitioner to be erroneous. This court permitted, this court on interim order ilva?
Yes, it is there, my lord.
Where,
They have violated the interim order.
Where, madam?
On 28/10/2025. This is the order.
28/10/25
Yes, interim order.
CCTV ತರಕ್ಕೆ ಹೇಳಿದ್ದಷ್ಟೇ.
Not to precipitate further.
This court on 28/10/2025 has passed the following order. The learned counsel Shivraj Mudhol, appearing for the petition respondent, submits that the results have been declared
On 25/10/25.
on 25/10/25 itself, long before the passage of the interim order on 28/10/2025. In the light of the results being declared, the petition would in the petition for the petition in the form that is presented would not be entertainable. The learned counsel Srimati Vidyavati Kottur Shettar, appearing for the petitioner, would project a different circumstance. According to the learned counsel, the petitioner has secured 108 votes.
Please, madam, in 4 booths.
In 4 booths has secured 108 votes. It is deliberately corrected to 78 only to defeat the right of the petitioner. The learned counsel for the respondent submits that all the votes that the petitioner has got, if added together, will not amount to 1 vote beyond 78. Therefore, 78 was to be written, and it is out of inadvertence, the number 108 was printed. Therefore, the correction has happened at a subsequent point in time. The learned counsel for the petitioner seeks to place reliance upon section rule 1410
Roman 10.
Rule 14 Roman 10 to buttress her submission that once the counting has happened, it cannot be changed. The rule itself says once the counting has should take place in the presence of the person, presence of the contesting candidate. If that is not done, it is violation of the statute. The learned counsel submits that when the votes were declared to be 108, the petitioner was present. And when it was changed to 78, he was not present.
It is not in the knowledge of the petitioner.
Sir, it is not in the knowledge of the petitioner. When it became 78 is not within the knowledge of the petitioner. Therefore, would submit this court should entertain the petition and obliterate the voting process and direct recounting of the votes. In the light of the results of the society being declared, the results of the election being declared, I deem it appropriate to dispose the petition as is being done in every other case, leaving open all the remedy available, leaving open all the contents to be urged before the competent authority in a dispute being raised under section 70 of section 70 of the Cooperative Societies Act. The district registrar, the assistant registrar of cooperative societies before whom a dispute, if presented, shall consider this issue at the outset, as it requires evidence as to whether what are the votes polled in favor of the petitioner, whether it is 108 or 78. leaving open all contentions to be urged before the authority, I deem it appropriate to dispose the petition as is done in every case before this court. Yes,
Great.
ordered accordingly.
Sri Seven, Shivraj P. Mudhod, is be there now?
Appear for the petitioner, my lord. This I may be heard along with main, my lord. Next.
We'll hear it.
Please.
Application will be heard along with the main matter. List the matter on 25th.
Please.
25th in preliminary hearing.
Please.
Yes.
68,
Early disposal. Back matter ಏನಿದು?
My lord, there is a settlement between the claimant and insurance company in the Lok Adalat. And that order has been challenged by a writ, stating that my client has not signed the joint memo.
Yes, Your Honor. She is not appeared before the Lok Adalat and she is not aware of the compromise, Your Honor. They have reduced 9 lakh something to the 7 lakh something, Your Honor.
9 lakh to 7 lakh.
Means totally the tribunal has awarded 9,80,600 rupees, Your Honor. On
Since insurance company is in appeal, challenging the quantum of compensation.
Quantum challenge ಮಾಡಿತ್ತಾ?
ಹೌದು, I have challenged the quantum of compensation based upon the admitted document that is in a wage register produced before the tribunal. It has been calculated. That was the only contention which have been taken before the.
ಈಗ ಎಷ್ಟು ರೆಡ್ಯೂಸ್ ಮಾಡ್ತು?
ಸ್ವಾಮಿ ಅದಲ್ಲ ಸ್ವಾಮಿ ಪ್ರಶ್ನೆ, ಅವಳ ಗಮನಕ್ಕೆ ಬರ್ದೇನೆ ಅವ್ರು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದಾರೆ.
ನಿಮಿಷ ಮಾಡಿ. ನೀವು ಸೈನ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ. Kindly peruse the.
My lord, in the practice is normal practice in the local government, not even when we are more than lakhs compromise have been taking place.
ಇದು ಸರ್ ಸೈನ್ ಮಾಡಿಲ್ವಾ ಇವರು?
Oh, they have not signed the petition.
Why?
Advocate has signed the petition. In the ಲೋಕದಲ್ಲಿ not a single party.
Advocate has signed.
But the advocate has signed it.
But
ಎಷ್ಟು ರೆಡ್ಯೂಸ್ ಆಗಿದೆ?
My lord, 7,82,000 has been compromised. Total award was
9,18,000.
3 ಲಕ್ಷ ಕಮ್ಮಿ ಆಗಿದೆಯಾ?
9,18,600.
So 2 lakhs, close to 2 lakhs is
Close
reduced.
to 2 lakh has been reduced.
2014 ದಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. 18 ಅಲ್ಲಿ ಅಪೀಲ್.
ಡೆತ್
ಸ್ವಾಮಿ ಡೆತ್ ಅದು ವಿಡೋ ಇದ್ದಾಳೆ, ಒಬ್ಬ ಮಗ ಇದ್ದಾನೆ. ಈ ಸರಿ PUC ಯಾವಾಗ ಒಂದು 4 ವರ್ಷದ ಮಗು ಇದ್ದ.
ಏನಾಗುತ್ತೆ ಬಟ್
ಕ್ರಿಟಿಕಲ್ ಕಂಡೀಷನ್ ಇದೆ, ಫೈನಾನ್ಷಿಯಲ್ ಸ್ಟೇಟಸ್.
ಒಂದ್ ನಿಮಿಷ.
ಅಲ್ಲ ಅವ್ರದ್ದು ಪರಿಸ್ಥಿತಿ ಹಂಗಿದೆ ಸ್ವಾಮಿ.
ಈಗ ಏನಾಗುತ್ತೆ, ನಾವು ಇದನ್ನು we are very lenient towards the claimant, but ಏನಾಗುತ್ತೆ ಲೋಕತ್ ಅವಾರ್ಡ್ ಅನ್ನ easily interfere ಅದನ್ನ it will become an opening a Pandora box for the future case. We cannot able to settle the matters.
ಸರ್.
Unless or until.
ಡೆತ್ ಯಾವಾಗ?
ಡೆತ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ
2014, I think 2012, my lord.
ಆಕ್ಸಿಡೆಂಟ್ ಆನ್ 16/8/2012, ಯುವರ್ ಆನರ್.
ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಯಾವತ್ತು?
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದ್ದು ಸ್ವಾಮಿ joint memo.
My lord, it is on
13th July 2019, Your Honor.
ಪ್ರಣಯಿಸ್ಯತಿ ಅಷ್ಟೊತ್ತಿಗೆ.
ಅಲ್ಲ my lord, but ಲೋಕದಲ್ಲಿ.
What is the age of the deceased?
Deceased on the date of death 40 years, Your Honor.
I'll place one document.
Impossible for 7 lakhs.
My lord, I'll produce the document. On what basis the settlement have arrived? My lord, I'll place one document with my lord regarding the what.
Who died?
Pardon?
ಯಾರು ಸತ್ತಿದ್ದು ಯಾರು?
Husband, Your Honor. Husband.
Which is now a widow.
She is a widow.
My lord, I'll place one document. On what basis settlement have arrived, my lord? Because the main content is that they have produced one document before the.
40 years, look at the multiplier. What happens to magma and other cases? Pranayaseti, all that.
No, that was not. My lord, that was not there. My lord,
What was not there?
The magma was not there. Magma was not there.
Magma comes in 2020, that's all right.
Magma was not, at that time magma was not there. My lord, that what was the calculation based upon not been anything?
Pranayaseti ittalla.
Pranayaseti with that has been taken into consideration.
Settlement alla.
Because the.
Settlement you have taken Pranayaseti.
Yes, it has been taken, my lord. It has been taken. Because it has been calculated based upon the document produced by themselves as a wage register. That was because they produced the wage register before the tribunal, and based upon the calculation has not made any other thing, based upon the wage register produced by them only. I'll place, because if they wanted to satisfying the court, if the court concludes that the incest has been caused to the other party, then it can be, I say no objection, but think that, my lord, I'll place the document before the, my lord.
List on 17th in fresh matters list. ಅವತ್ತೇನ್ ಕಾನೂನು ಇತ್ತು ತಗೊಂಬನ್ನಿ ಸೆಟಲ್ಮೆಂಟ್ ಆದ ದಿನ ನಿಮ್ಗೆ ಅವ್ರಿಗೆ ಪ್ರಣಯ್ ಸೇತಿ ಗೆಟ್ ಅಂಡ್ ದರ್ ಅದರ್ ಜಡ್ಮೆಂಟ್ಸ್ ಆಸ್ ಆನ್ 2019.
Pranay says that Magma came in 2000, but Pranay was there.
Pranay Seti is 2017, sir.
17th, my lord. Magma was in 2020, my lord. And that was no concession for other person, only 70,000.
Magma came in June 2020.
22. And that was Pranay is holding 70,000 the convention light.
Right? Not
69 MS Service EV Angi.
This matter has been pending, madam, you know, of the pendants of the SLP before the Honorable Supreme Court. Now the SLP has been disposed of, madam. The facts of the case that, my lord.
What is the issue?
Issue regarding the termination of service, my lord.
ಅದಕ್ಕೂ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನ್ ಸಂಬಂಧ?
The government has prepared the SLP before the, my lord, Honorable Supreme Court, my lord. That has been disposed of at next produce that document.
Kindly day after tomorrow, your lordship, because I'll.
Kindly day after.
Please, your lordship.
In press matter system, madam.
No, preliminary hearing, yes. Let's day after tomorrow in preliminary hearing. Next.
71 Sridhar Prabhu.
No representation behalf the petitioner.
Sorry.
Yes, sir. 2 weeks.
I'm sorry. Now, this matter, my lord, my learned friend says he has some disability appearing offline.
Yaru?
That Shahbaz Hussain, my lord, yes, this matter.
Your lordship, I appear for the respondent in this matter.
ಪ್ರಶಾಂತ್ ಗೌಡ್ರು ಇದ್ದಾರೆ ಅಂದ್ರೆ ಮತ್ತೆ ನೀವು?
ಇಲ್ಲ ಇದರಲ್ಲಿ
ಅಲ್ವಾ?
No. This is different matter, my lord. This matter, my lord, we have challenged the KERC's order and regulations as well. The core contention is, my lord, that
there's an interim order here.
Yes, there is an interim order.
We'll hear it.
Yes, I'm ready.
Your lordship, we have moved an IA for vacation of the interim order, your lordship.
We'll take it in preliminary hearing and close it.
Yes, 19th, your lordship.
List the matter on 19th in preliminary hearing. It is made clear the matter would be heard and disposed. Interim order subject to the aforesaid conditions stands extended to the next date of hearing.
Very well. Grateful.
Girish V. Bhatt. Shankat Gowda.
I'm for respond number 2. I require for
Yen Prashant?
2 weeks time for filing objection.
Senior counsel is there. Have you informed him?
I informed him. Already informed. Senior.
Interim order में के लिए
Interim order.
Humpy world.
Senate counsel Prashant Gowda seeks 2 weeks time, huh?
Yes, ma'am.
2 weeks time to file statement of objections. List the matter on 25th Agata.
Please.
List the matter on 25th. Interim order subsisting would learned senior counsel submits that interim order be continued. Interim order stands extended to the next date of hearing.
Please.
73 Shashank Segre.
73 next week kindly out.
Wait, please, your lord.
70?
73, my lords.
Senior
kindly out next week.
I am appealing this.
Yes, sir.
My lord, the short issue is the deposit collectors are appointed by the banks.
Correct.
Supreme Court has already decided that these are employment contracts.
No doubt. Indian Banks Association. Yes.
Yes, absolutely. Your lordships have got it. I have nothing more to argue because employment contracts, my lords, therefore.
Absolutely. They were pygmy
outside
agents.
the purview of-
Pygmy agents are construed to be employees.
Yes.
In terms of Indian Banks Association order.
Yes.
After that, everyone is an employee. Now, what is the
Yes.
problem?
The issue, my lords, is under section 7(2), read with schedule 3 of the GST Act. Employment contracts are outside the purview of GST. So, you cannot issue me a show cause notice and ask me to pay tax on the remuneration paid to these people because it's beyond your jurisdiction. That is the simple case. This is
ಅದಕ್ಕೂ GST ಹಾಕಿದ್ದೀರಾ?
ಹೌದು.
ಏಜ್ ಇದರಲ್ಲಿ ಅಪೇರ್ ಆಯ್ತು.
There is nothing more than this, my lords.
1 week time.
At the heard the learned senior counsel Raghuraman appearing for the petitioner. The issue in the list is with regard to imposition of tax -GST upon the remuneration paid to the pygmy agents, erstwhile pygmy agents. The apex court in the case of Indian Banks Association considered this issue and held that every pygmy agent who collected deposits deposits to the benefit of the bank were all employees of the bank. In that light, remuneration became an entitlement of those petitioners. The state prima facie could not have imposed tax GST upon the remuneration paid to these employees, the learned AGA submits that the learned additional advocate general would making his submissions. List the matter on 18th.
Please.
List the matter on 18th in preliminary hearing. Object submissions be made.
18th senior has some other.
19th. Raghuram sir, yavat beku?
Any date which you will tell my lord, sir. Whichever is to your convenience also. If your lordships finds that some date is inconvenient, please mention. I'll adjust my dates.
Sir, I am here only. Any day you tell me.
24th would be better.
24th, fine. Yes. List on 24th in preliminary hearing.
Please.
Deeply
Application seeking vacation of the interim order thus stands rejected. List the matter from preliminary hearing. The understanding is the matter would be heard and disposed. Next.
74.
Deeply obliged.
Ashte issue. Yes, AGA. Ashte.
Yes.
Yes.
One request. The previous matter, lordships adjourned to 19th, Lord. One matter is missing. I'll give that. That also may be tagged along with this.
Bangalore da.
Alla, ille. Barlilla.
Number.
And 60 also may be had on 19th.
60.
I'll tell Sriranga.
Yes.
I'll.
Next.
74.
Lord, I seek leave of the court to appear for petitioner. Petition number 5 has, my lord, is died. LR's application along with Vakalat has been filed. It may be allowed. My lord. Petition number 5.
Petition number 5.
Yes, my lord.
Abatement.
Abate.
All applications. IA1 alla, IA2 setting aside abatement. IA4 to bring LRs on record. IA continuation of delay. IA2 for continuation of delay. For the reasons indicated in the respective affidavits accompanying the application being satisfied with the same, allowed the petitioner to amend the cause title or file an amended cause title as the case would be forthwith. Early hearing.
My lord, case of a regularization, 35 years they have been served. In the same corporation, some of the persons has already been.
Application seeking early hearing of the petition stands rejected. List the matter for preliminary hearing on 25th. Yes. Rule issue ಆದರೆ ಮಾತ್ರ early hearings. ಎಲ್ಲ early hearing ಆಗ್ತಾರೆ.
75. Sunil Desai.
Lord, I appear for petitioner.
Impleading ಏನು?
It can be allowed.
For impleading application.
The order on IA1 is for the reasons indicated in the affidavit accompanying the application, the impleading application stands allowed more so in the light of the fact that it is unopposed. The petitioner to file an amended cost title or amend the cost title as the case would be. List the matter.
Any date, my lord. Any date, my lord.
List the matter on 26th.
Please. Interim order maybe.
Interim order subsisting would continue to the next date of hearing.
Please.
26. Prashant Escarve.
Vacating stay.
Appear for respond number 5.
Yes, Prashant.
I was.
Prashant versus Prashant.
Lords, respond number 5, Lords, was appointed as a village assistant. Lords, that order, my lords, after my lords paper publication, my lords, interview was attended by both the candidates, the petitioner as well as this respond number 5. Lords, on 24/4/2023, my lords, that appointment order was passed.
24/4/23.
23.
Annexure K, page 44.
Please, my lords. But he keeps quiet for more than 1 year, then files his writ petition.
Who is he?
He is, my lords, one of the contenders to that post. Interview was called for. In interview, my lords, this
not succeed.
My lords, I have not succeeded. That is why, my lord, I am before this. Lord,
anything else?
It may be taken any day, my lords, for final,
Today, sir.
for disposal.
ಇದೆಲ್ಲ
Please,
ಯಾವ-
I'll make submission. Lord, challenging annexure K, my lord, this is pertaining to, my lord, appointment of Grama Sahayaka. Lord, as per annexure F, they have issued, my lord, a notification for seeking calling applications. For a moment, I'll read.
I am all ears, sir. ಹೇಳಿ.
ಅರ್ಹತೆಗಳು ವಯಸ್ಸು 25
My eyes need not be on the file. My ears are.
Please. Lord, the last point, my lord, is ವಾಲಿಕಾರ ಮಂತನದವನು ಹಾಗೂ ಈ ಹಿಂದೆ ಗ್ರಾಮದಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸಿದಲ್ಲಿ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಬೇಕು. This is the, my lord, the conditions, my lords. And my lord, accordingly, my lord, the petitioner, my lord, has filed, my lord, his application. is at page number 40, my lord, annexure H. He has furnished, my lord, all the documents, and my lord, he has shown, my lord, that, my lord, since last 7 years, my lord, he has been working without any remuneration as Grama Sahayaka, without any appointment,
ಬೇರೆ ಕಡೆ ಎಲ್ಲಾರಿದ್ರೆ ಕೊಡ್ಲಿ ಅಂತ.
without any appointment.
Yes, madam.
And, my lords,
With
to
admittedly.
that effect, my lords, the
documents-
villagers also,
Villages, document produced by him is in compliance with what is necessary.
Lords, I have also produced
He-
all those documents.
Lord,
Lords,
he,
which
my lord,
after
being a, my
interview was
lord,
conducted,
he
both.
being appointed,
One qualifying marks ಏನಿಲ್ಲ ಇದಕ್ಕೆ.
ಅಲ್ಲ,
ಇಲ್ಲ,
ಅದೇನಿಲ್ಲ.
It's only
Interview.
and subject to satisfaction of the interviewing authority.
annexure P may kindly be seen, my lords. My lord, he was working in the, my lord, one society as a clerk.
Who?
The respondent, my lord, contesting respondent. He has resigned there, my lord, then after appointment.
This is more lucrative.
In fact, my lord, he was having 12,000 salary there.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ನಾನು ಏನಕ್ಕೆ ಹೇಳಿದೆ ಇಟ್ ಇಸ್ ಮೋರ್ ಅಂತ.
Lords, I have been, Lords,
Comment.
working.
Please, your lordship.
ಪಕ್ಕದಲ್ಲಿ ಎಲ್ಲಾರು ವೇಕೆನ್ಸಿ ಇದೆಯಾ ನೋಡಿ.
I will verify, your lordship.
As a special
because
case will permit him some.
I'll verify
ಖಾಲಿ
and
ಇದ್ರೆ.
submit because once, if order is passed, your lordship, it will be very difficult. I will
I'm not
verify.
passing any order.
Please, your lordship, I
You
will
verify and submit.
make submission.
Or if your officers want an order, I will pass an order.
Please, your lordship.
The petitioner is before this, will not disturb you.
Please, Lords, one submission which I make. There was an interim order, my lords, in January 2025. From that day, my lords, I have not received any salary. Though, my lords, it was the interim order is subject to the result of the writ petition.
No, I'm not disposing it now.
No.
We'll grant
Please.
negative salary. The petitioner is before this court calling in question the appointment of what respondent?
Fifth respondent.
Fifth respondent to the post of Gram Sahayak. The learned counsel for the petitioner submits that the petitioner was working as Gram Sahayak. Alle.
ಹೌದು.
As Gram
Without-
Sahayak
Since last 7
for
years.
7 years. And this candidate now
That is in
selected
fact belied by, my lords, this very same authority. They say, I'm not on that
and
because let him.
would submit that the selected candidate is not. The document submitted by the petitioner would also drive home consideration of appointment is the submission. The learned counsel further submits that there are several vacancies existing in the nearby villages where the petitioner can be accommodated, as petitioner admittedly has worked as Gram Sahayak for 7 years prior to loss of this appointment. The learned HCGP to secure instructions in this regard and make her submissions. List on 18. ಆಗತ್ತೆ ಒಂದು ವಾರ.
Please.
ಅವ್ರನ್ನೇನ್ ತೊಂದ್ರೆ ಕೊಡ್ಬೇಡಿ, ನೋಡೋಣ ಎಲ್ಲರ.
ಆಯ್ತು. Please.
So direction, my lords, to the government, at least 2, my lords,
The
to
learned counsel
release the salary.
ಪ್ರಶಾಂತ್ ಹೊಸ್ಮನಿ ಏನು
ಅವತ್ತು ಡಿಸ್ಪೋಸಲ್ಲೇ ಮಾಡ್ಬೋದು.
ಒಂದ್ ನಿಮಿಷ. learned counsel ಡಿಸ್ಪೋಸಲ್ ಆದ್ರೆ ಒಂದು ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಅವ್ರು ಕೊಡಲ್ಲ, ಆಮೇಲೆ ಅವ್ರನ್ನ ತೆಗೆದು ಬಿಡ್ತಾರೆ. The learned counsel Prashant Hosmani appearing for the selected candidate submits that since January 2025 he has been working as Gram Sahayak.
From the date of the appointment, but after the interim order, my lords, they have stopped my salary.
From the date of the appointment, he has been working on and from the date of passage of the interim order, i.e. on 25/1/2025, the 25/1 na?
Please, my lords.
25/1/2025, salary has been stopped. If the salary of the person who is, if what the learned counsel for the respondent submits is correct, the state cannot practice begar by making someone work without paying them salary, which is hit by Article 23 of the Constitution of India. Therefore, the state shall not. ನಿಮಗಲ್ಲ ಸರ್ ಸ್ಯಾಲರಿ, ಅವ್ರು ಕೆಲಸ ಮಾಡ್ತಿರೋ ಕೊಡೋದು ಬೇಡವಾ?
ಅದು ಸ್ಟೇ ಆಗಿರೋದ್ರಿಂದ ಕೆಲಸ ಮಾಡಿಲ್ಲ ಸರ್.
ಮಾಡ್ತಾ ಇಲ್ವಾ?
Well, I have been, my lords, going to the office and working, but
He's not
salary
working.
is not released.
Going to the
He is not
office.
working, your lordship.
I have been assigned works, but since because of the interim order, my lords, salary is not received.
ಈಗೇನ್ ಸಸ್ಪೆನ್ಷನ್ ಇಟ್ಟಿದಾರ?
ಇಲ್ಲ, ಏನು
So
ಇಲ್ಲ.
since it is stayed,
Therefore, the state
he is
shall
not working.
verify the records, and if the petitioner respondent has worked, he shall not be denied salary.
Please.
Earlier, it was subject to result of the writ petition and that was the order passed by this court.
25/1/25 modify ಆಗಿದ್ದ?
Well, that is the only order, that is the only interim order.
To subject result and
Subject, appointment is state subject to the result of the writ petition. Please, 18. Wait, please.
27, Chair Kambiyavar.
For the petitioner,
107 na?
ಅಲ್ಲ ಮಲ್ಲಾಡಿ, this is.
119.
out of Income Tax Act, my lord.
Out of Income Tax Act.
Act. Petitioner is an agriculturist, my lord.
Agriculturist, no
Farm-
tax.
Poor,
Ayyo.
poor farmer,
No tax.
poor farmer,
Poor farmer.
illiterate people.
50 ಎಕರೆ ಇದೆಯಾ?
Thumb.
ಅದು ತಂಬಲ್ಲ, 50 ಎಕರೆ ಇದೆಯಾ? 100 ಎಕರೆ ಇದೆಯಾ? ಎಷ್ಟು ಏಕರ್ಸ್?
2 acres.
2 acres. ಟ್ಯಾಕ್ಸ್ ಇಲ್ಲ ಬಿಡಿ ಆಗ. Yes, Tirumalesh sir.
There are a batch of matters.
No, let them, he should have mentioned the facts, my lord. The facts are like this, that.
What facts, sir? If they're agriculturists, you can't impose tax at all.
No, that is, it depends
That
on the land
is
under which
issued
act they have been
billeted.
acquired.
Government
No,
of Karnataka.
It is not explicit from the petition under which act they have acquired. They have filed an application for delay, condoning the delay in filing the return, which was rejected for the reason that they are not eligible for exemption. Pardon, my lord?
ಇಲ್ಲ ನಿಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ ಬಿಡಿ. Yes.
ಅಲ್ಲ, so
ಹೇಳಿ ತಿರುಮಲೇಶ್ ಸರ್.
My submission is that he has not filed the return in the appropriate time. So he has filed an application before the commissioner for condoning the delay. That delay has been
ಫೈಲ್ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? ಟ್ಯಾಕ್ಸ್ ಪೇ
ಫೈಲ್
ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ.
ಮಾಡಬೇಕು. TDS ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. TDS
Only
ಆದ್ಮೇಲೆ
to
ರಿಟರ್ನ್
obtain
ಫೈಲ್
the
ಮಾಡಬೇಕು.
refund, ಇದು TDS amount ಗೆ ನಾನು I post to file return of income, but TDS certificate itself is issued belatedly by 11 months. This is a fault of government of Karnataka.
Government of Karnataka.
No fault of the petitioner. Why should he run to pillar to post?
Where are you running?
Pillar to post.
Pillar to post.
For that, under section 119(2)(b), this principal commissioner has the power to condone the delay and permitted to file, obtain the refund. For that effect, he has rejected on the ground of delay.
And then make a claim for refund.
No, he must be permitted, my lord.
Yes,
It is
true,
under
that
section
is-
139(1) and 4, the time limitation stipulated is 11 months delay, my lord.
ಈಗ ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿರೋ ಡಿಲೇ ಮೇಲ.
Please. Parameteria judgment, your lordship judgment is applicable under the GST Act. Parameteria.
Yes, Tirumalesh sir.
GST Act is a different issue. This is falls under 119. My lords, your lordship may allow the matter saying that the bona fide reasons are made out for delay in filing the return because the TDS certificate.
Otherwise, where should I go? There is no appeal.
Next flight to Delhi.
My lord, my 6 lakhs TDS amount remains under it is violation of the Article 265 without authority of law.
Otherwise, where should you go now?
Where should I go?
Yes.
Poor farmer, my lord. Thumb person. ಅವರು 11 ಬರ್ತಿದ್ರೆ 11 ಹಾಕಿ ಮಾತಾಡ್ಬೇಕು.
ಏನ್ 11?
11th
ಇಲ್ಲ
ಬೇಡ ಅಲೋ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ ಅವರೇ. ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ ಅದು? ಅದನ್ನ ಫಸ್ಟ್ ತಿಳ್ಕೊಬೇಕು ನೀವು.
It is really exempted under section 1037 of the IT Act.
Why is your thumb like this only? ಅದು ಕೇಸ್ ಆಯ್ತದು.
It is exempted income, my lord, under 1037 of the IT Act.
No, that is a subsequent issue that has to be
ಅದೆಲ್ಲ ಅಲ್ಲಿ
examined.
ತೀರ್ಮಾನ ಆಗ್ಲಿ ಬಿಡಿ.
Subsequent condonation of the delay, my lord. Once he permits, I'll file. There is no embargo to process my return and assess the tax liability. I am ready to discharge everything. In action of it is not permissible under the law, and substantial benefit to the taxpayer or petitioner. You should not deny on the technical ground.
Understood. ಅದು operative portion ಬರ್ಕೊಳ್ಳಿ. All these petitions are allowed. The order impugned of ಯಾರ್ದು ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು ಯಾರು?
Annexure D, my lord.
Annexure
Wide
D.
Annexure D.
Annexure D stands quashed. The matter is remitted. ಯಾರು ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು ಸರ್?
Rejected by the
Commissioner of Income tax, Principal Commissioner of Income
The
Tax.
order passed by the Principal Commissioner of Income Tax, which respondent come here?
Here R3, my lord.
The third respondent stands quashed. The matter is remitted back to the
Allala.
hands of the.
The assessee is permitted to file the return, and
The
it shall be processed in due course.
Assessee, in the light of the reasoning barkontine, the assessee is permitted to file his return of income, which shall be assessed in accordance with law, without reference to limitation, and necessary action necessary orders be passed thereon in accordance with law.
ಇದು ನನಗೆ ಟೈಮ್ ಕೊಡಿ ಮಲಾಡ್ to file.
In the event the petitioner shall file his return of income within 4 weeks.
2 months.
Within 8 weeks from the date of receipt of the copy of the order. In the event the return of income is filed within 8 weeks as observed herein above, the return of income shall merit consideration on the return of income should be return of income would be considered on its merit.
Merits of the case.
The
all contentions urged before this court, the petitioner would be at liberty to urge before the appropriate forum.
Please.
Limitation is condoned ante. Limitation.
Condoned,
The
correct.
delay.
Yes, right. Yes.
In first case, Annexure D requires to be quashed.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಎಲ್ಲ all in all first
ಅಲ್ಲ
case
ಇದು ಕ್ವಾಶ್ ಆದ್ರೆ
D quashed
Annexure
in
D ಹೇಳಿದ್ದಾರೆ ಅದು.
Annexure D quashed.
ಅಷ್ಟೇ.
Annexure D, every case is Annexure
In
D.
every case Annexure D quashed certificate dispensation ಕೇಳಿರೋದು ಅದೇನೆ. Yes, Annexure D quashed ಇಲ್ಲ.
Please.
28T Hanumareddy.
Now where are you going?
This case, my lord.
I have another 3 batches.
ಇಲ್ಲೇ ಇದೆಯಾ? Yes.
My lord, I'm appearing for the respondent in this case, my lord. I pay for a short accommodation to file objections.
ಯಾವ್ದು ಅನಿಲ್ ಕುಮಾರ್?
Please, my lord. 78 respondent.
Learned Counsel J.M. Anil Kumar appearing for the fourth respondent seeks 10 days time to file statement of objections. List on 25th objections if any by then. Regularization, huh?
Yes, ma'am.
ಎಷ್ಟು ವರ್ಷ?
18 years, ma'am.
Let's see. List on 25th. Next.
79.
My lords, one submission, my lords, my objections may be recorded.
What objections?
No, means my strongly objected ಅಂತ ಹೇಳಿ.
ಅದು ಮಾಡ್ತೀನಿ. The Learned Counsel M. Tirumalesh puts up vehement opposition to the submissions made by the Learned Counsel appearing for the petitioner seeking dismissal of all these petitions. Saka?
Yes, ma'am.
Okay.
79 Harish Maigur.
My lords, I have challenged Annexure F, my lords. Impugned passed by the family court, my lords, by passing the interim maintenance of rupees 7,500, my lords.
ಯಾಕೆ ಸರ್?
And my lords, in the year 2017, my lords, I have filed a restitution of conjugal rights, my lords. And after 2 years, I have waited, my lords. But since then,
2 years?
I have waited, my lords.
You have?
Waited, my lords, from 2017, my lords, after filing a restitution of conjugal rights, my lords.
ಬೇರೆ ಮದುವೆ ಆಗಿದ್ದೀರಾ?
Agide, my lords. And a decree of divorce is also granted, my lords.
Lords, this is ex parte decree they obtained, which is under challenge, lordship. Petitioner and petitioner's son, lordship, both have filed 125 proceeding, lordship. So altogether they have awarded 7,500 interim maintenance, lordship, which they have challenged, lordship.
ಏನಾಗಿದೆ? Divorce decree ಏನಾಯ್ತು?
Divorce decree, we had filed a MFA and they have.
My
appealed,
lords,
lordship.
I have filed a divorce in the year 21, my lords, and it came to be decreed on 23, my lords. And till then, they haven't challenged, my lords, the decree of divorce. Once after the issue of notice of this writ petition, they have challenged that decree of divorce, my lords. And my lords, I have got a second.
You got married, huh?
No, my lords. In the 21, I have got a decree of divorce, my lords. And in 23, I have got second marriage, my lords.
2024 he got married.
ಆಯ್ತಾ ತೀರ್ಮಾನ ಆಗಿ ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲಿ?
Yes, lords.
List the matter on 10th December, 12th December.
Stay may be
Interim order subsisting will continue to the next date of hearing.
Please, lords.
Bill number 80.
Recalling the order. Chimdala. Recalling ಏನು? Non-prosecution.
Non-prosecution.
For the reasons indicated in the affidavit accompanying the application being satisfied so and so, order date 26/9/2025 stands recalled, the petition is restored to file. What's the matter?
My lord, the petitioners seeking mandamus against the respondent number 1 and 2, my lord.
For what?
For consideration or representation, my lord.
You have to collect a copy, my lords. It was in non-compliance stage. Copy are not collected, my lords.
Non-compliance.
Non-compliance, my lord. Lord, I will.
Place the matter on 17th. In the event office objection should be complied with.
Please.
And if it still stands not complied, it would be dismissed
Please.
for its non-prosecution.
Please.
ಆಮೇಲೆ recall ಮಾಡಲ್ಲ.
Please.
Yes.
81, Surabhi Kulkarni.
Mandamus ಕಂಪ್ಲೈ ಮಾಡಲಿಲ್ಲ.
No, my lord. Due to oversight, my lord, the
ವರ್ಕ್ಲೋಡ್
Yes, my lord. Sorry.
ಕಡಿಮೆ ಮಾಡ್ಕೊಳ್ಳಿ. ವರ್ಕ್ಲೋಡ್. Yes.
For the petitioner, my lords.
Yesterday's matter, my lord.
Challenging, my lord, the transfer of the division post of the.
He has joined now to the transferred post.
The issue, my lord, I have challenged the very validity of the transfer order. My lord, he is
Divisional manager.
division wise post, my lord, class 4 division wise post. He is a driver cum conductor. Lord, there is a C&R regulations, my lord, which is governing, my lord, the
I
transfer.
think join
He
ಆಗಿದ್ದಾರೆ.
has joined. He has joined.
ಕೇಳೋಣ ಬಿಡಿ.
Since May, my lords, he is working in the transferred post.
Place the matter on 12th December. In the light of the fact that the petitioner has joined the transfer post and is working since May. However, it would remain subject to the result of the petition.
Agency is, my lord, that he is suffering from certain medical ailments.
What certain?
My lord, neck pain, my lord, the medical report.
Neck pain.
He was, my lord,
Hoಗಿದೆ sir.
my lords, medical, my lord, documents are produced.
ಕೊಡಿ. No wound, healthy body.
Second page.
Second page.
Neck pain, my lord, radiates to right upper limb since 5 months.
Neck pain.
Lord, he is a,
Tingling sensation.
he is a driver, my lords. He has
Who is
to.
this doctor who has given certificate saying tingling sensation?
The doctor.
What do you mean tingling sensation?
With some, my lord, weakness, my lord, in the right leg is what, my lord, has been stated. at
Tingling
the,
sensation ಅಂದ್ರೆ ಏನು?
my lord, the medical.
Hmm.
Since 5 months, he is suffering from the neck
What
pain.
you are suffering? ಏನು ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ.
Adu, my lords,
Neck
and
pain ಎಲ್ರಿಗೂ ಇದೆ.
he has spent next page more than 50,000 rupees.
ಹಾ.
It is a class 4 employee post.
50,000 rupees ಯಾಕೆ neck pain ಗಾ?
Adu, he was admitted for 3-4 days. I will also produce the document regarding that.
For what?
He said, my lord, the treatment. My lord, now, my lord, if he
Neck pain since 5 months. ಟ್ರಾನ್ಸ್ಫರ್ ಆದ ತಕ್ಷಣ ಬಂದಿರೋ ಪೇನ್ ಇದು.
since 5 months,
ಅಲ್ಲಿವರೆಗೂ ಏನು ಇರಲಿಲ್ಲ.
he was suffering, my lord, but he had, it may be referred to medical board, my lords.
But I am really interested to know what is this. Tingling sensation. Medical certificate ಕೊಟ್ಟಿದ್ದಾರೆ.
But if he is not in a position to, my lords, discharge duties, let him, my lords, approach the medical board, get a certificate, then we'll consider.
It may refer to medical board, my lords. I will.
We'll refer it to the biggest specialist of the state. Tingling sensation ಏನಿದು ಸ್ವಲ್ಪ ಕೊಡಿ. ಇದು ಒಂದು ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ಗೆ.
He's a driver, has to
What
drive
sir?
from-
No urgency.
from
December
Chikkodi, my
12th.
lord, to Bangalore, he has to drive 8-9 hours, my lord, driving.
8 to 9 hours.
From Chikkodi, my lord, to Bangalore, he has to.
Chikkodi to Bangalore.
He has been given that the duty, my lord, to discharge. He's a driver.
ಬೆಂಗಳೂರು ಕೊಟ್ಟಿದ್ದೀರಾ?
There are buses, my lords, which run from Chikkodi to Bangalore.
Driver?
A driver, how?
It affects, my lords, the said diagnosis.
ಅದಕ್ಕೆ ಕತ್ ನೋವಿರೋದು. ಎಲ್ಲ ಡ್ರೈವರ್ಸ್ಗೂ ಅದೇ ಇರುತ್ತೆ. ಏನ್ ಮಾಡಕ್ಕ?
One, my lord.
12th December. Yes.
Please. Meanwhile, my lords, refer to medical board, my lords, he may appear before that.
For what?
Only, my lord, to.
Yes. Next.
82, Satish K.
I appear for the petitioner.
Where are you appearing?
I appear for respondent number 2.
ನೀವು ಯಾವಾಗ್ಲೂ ಪಾರ್ಕ್ ಇಂದಾನೆ ಅಪಿಯರ್ ಆಗ್ತಿರಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಈಗ ಹೈಕೋರ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎರಡರ ಎದುರುಗಡೆ ಇದ್ದೀನಿ. But very short point, my lord. The PhD degree conferred on the petitioner is held to be, my lord, valid. Now, my lord, the state government writes a letter. I am an employee of university. State government cannot write letter. My lord, the law is settled on this issue.
What letter they have written, sir?
to terminate the service and to impose, my lord, launch a criminal prosecution against the petitioner on the ground that, my lord, fake PhD certificate.
ನಿಮಗ್ ನೋಟಿಸ್ ಕೊಟ್ರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಂಗೇನ್ ಕೊಟ್ಟಿಲ್ಲ.
ಯೂನಿವರ್ಸಿಟಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಯೂನಿವರ್ಸಿಟಿನೂ ಕೊಟ್ಟಿಲ್ಲ, ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಏನು?
The petitioner is before this court seeking the following prayer. The petitioner pursuant to a recruitment process is selected and appointed as what?
Assistant Professor Geography on 29/3/2012.
Is appointed on 29/3/2012 in the discipline of geography as an assistant professor. Long thereafter, it transpires that the state government has directed termination of the petitioner on the score that the PhD certificate that he has submitted at the time of appointment is said to be bogus.
Fake.
Is said to be fake, not said to be fake. Therefore, the directive of the university is taken, a directive of the state government is taken by the university, and the university has now sought to issue an order of termination. The order of termination is what has driven the petitioner to this court in the subject petition. It is the issue at this juncture would lie in a narrow compass as to whether the order of termination emanating from the hands of the state could have been issued against the petitioner without compliance with the principles of natural justice. The issue in the list need not detain this court for long or delve deep into the matter. The coordinate bench of this court in the case of Marthandappa Hosalli, Justice Vishwan Marthandappa Hosalli so and so reported in ILR 2014 so and so has clearly held, interpreting the old act where in terms of section 8, the state had power to issue directions to terminate any employee could not have been issued without at the outset the employee being heard in the matter. In the light of the said issue being answered and answered by the coordinate bench way back, coordinate bench the coordinate bench is also the fact that the issue being too rudimentary that any order entailing civil consequences could not be passed at the outset without issuing a notice and hearing the employee on whatever ground it may be. Therefore, on this short ground, the petition deserves to succeed. The foresaid reasons, the following got allowed quashed. The respondent university shall now issue notice to the petitioner hear him, issue to the petitioner, grant him an opportunity of hearing and pass necessary orders in accordance with law. Ordered accordingly. Yes, next.
Only one small indulgence, my lord. The Public Accounts Committee has closed the issue with regard to PhD certificate, my lord, your lordship.
That are urged in the petition shall remain open to be considered at the appropriate time if need arises. Next.
Lordship, Sangram Kulkarni sir name may be deleted. Sangram Kulkarni sir name may be deleted for account number 2 university since I have appeared.
So and so deleted, so and so entry. Yes.
Deeply obvious.
Judgment ಕೊಡಲ್ಲ ನೀವು, ಅದಕ್ಕೆ ಅಲ್ಲಿಂದೆಲ್ಲ ಅಪಿಯರ್ ಆಗಬಾರ್ದು.
83, my lord, I am appearing for the
petition.
Election is already been held. Then only counting is required to be done. But in fact, serial number 83. But he has permitted to, my lord.
Counting will permit, badwa?
Illa. Interim order passed by your lordship has been misinterpreted by the fifth respondent and permitted contest for the election. The results are withheld.
Yes. List,
in fact,
list tomorrow in fresh matters list.
Please.
Next. Anil Kale.
Appear for the respond number 7.
Annexure G, my lord, suspension order beyond 6 months, my lord. It was part
Jay
of-
Kumar.
Pending inquiry, my lords, he was suspended.
Charge sheet issue ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ದಾರೆ.
Charge sheet is issued.
ಯಾವಾಗ?
Inquiry immediately, my lords.
ಮತ್ತೇನು?
Now, my lords, what has happened?
Now what had happened, my lord? Rules provides for, my lord.
Review.
Rule provides for 6 months. Bylaws of the society.
No. Maximum 6 months illa. It should be reviewed once in 6 months.
Once, my lord, it has to be, well, suspension is for the period of 6 months. If at all, my lord, they are extending, the reasoned order to be passed. Now, my lord, 6 months is, my lord, over.
Lords, what has happened here, this, my lord? pending inquiry, he was suspended. Lords, he comes to this.
My lord, the rule of this bylaws, their own bylaws. Please.
Yes.
Lords, he obtains an interim order saying that he had filed complaint against the directors of the society, and to wreak vengeance against him, Lords, they have passed the suspension order. Lords, the police, Lords, investigates that complaint, files a B report saying that it is the petitioner, when he was working as a secretary, misappropriated amount of rupees more than 6 crores. And to wriggle out of that situation, he has filed this complaint. This is, my lords, the B report that the police have filed. My lords, after, my lords, obtaining an interim order, my lords, he never comes to the society office. On the contrary, my lords, he keeps writing letter to the society saying, making allegations against the directors. Thereafter, my lords, the inquiry is set up. He doesn't come before the inquiry officer also. Audit is also, my lords, conducted of this.
ಈಗ suspension set aside ಮಾಡ್ಬೇಕಾ?
Yes, my lord. Here, my lord,
because-
he was
let me
appointed
finish,
in
my lords, because of the-
2003. Till 2023, my lord, he has no any blame. He served, my lord, for 20 years. 2023, new management has, my lord, was elected to the society. His cousin is the president.
Whose
who-
cousin?
Cousins of this petitioner, who wants him to be removed from the post. He, my lord, submitted a resignation. His resignation was not accepted, and the allegations were made. All the allegations were, my lord, regarding the loans were not recorded, my lord, recovered. My lord, he is ready to face any inquiry. Let them, my lord, hold inquiry. He has no-
His resignation was not accepted because, my lord, there is 6 crores, my lord, misappropriation that he has committed. There is audit report.
All right, ಈಗ suspension ಅಷ್ಟೇ ಅಲ್ವಾ ಇಲ್ಲಿ?
It has also been after elapse of, yes, it's only suspension pending inquiry.
Let's day after tomorrow in fresh matters list.
Please.
85, Tushar Kambiawar.
Last date of hearing, there is a direction to the Secretary Finance Department to file an affidavit. When tribunal under section 109 of the GST Act is going to be function.
ಹೌದು.
But direction is to third respondent instead of fourth respondent. Central government is a competent authority to state that.
ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಅಲ್ಲ ನಮಗೆ ಸ್ಟೇಟಿಗೆ ಕೊಟ್ಬಿಡಿದ್ರು. ಅದು ಫೋರ್ತ್ ಆಗ್ಬೇಕೈತೆ, ಥರ್ಡ್ ಆಗಿದೆ. ಯಾಕೆ ಅವರೇ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿರೋದು.
ಯಾರಿದ್ದಾರೆ ಇಲ್ಲಿ? ಪಾರ್ಟಿನೇ ಇಲ್ವಾ?
ಇಲ್ಲ ಪಾರ್ಟಿ ಇದ್ದಾರೆ, ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾರೆ.
ಯಾರು? ಹೂ ರೆಪ್ರೆಸೆಂಟ್ಸ್?
ಇಲ್ಲ ಕಣಿವಿ MB ಕಣಿವಿ ಇಸ್ ಅಪಿಯರಿಂಗ್.
ಎಲ್ಲಿ ನಮ್ಮ DSG ಎಲ್ಲಿದ್ದಾರೆ?
ಯಾವ ಇಲ್ಲ. Already it is constituted but not functioning. ಬಂದಲ್ಲ? Yes.
ಎಲ್ಲಿ? ಡೆಪ್ಯೂಟಿ ಸಾಲಿಸಿಟರ್ ಜನರಲ್ ಆಫ್ ಇಂಡಿಯಾ.
ತೋರಿಸಿ ಇದು ಆರ್ಡರ್ ನಮಗಿದೆ.
ಹಾ.
ನೀವು ಹೇಳ್ಬೇಕು ಗೊತ್ತಾಗ್ತದೆ ಅಂತ.
ಓ ನಿಮ್ಗಿದೆಯಲ್ಲ ಅದು?
ನಮಗಿದೆ ಅದು, ಬಟ್ ನಾವು ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಲ್ಲ, ನೀವೇ ಮಾಡಿದ್ದೀರಾ ಆಲ್ರೆಡಿ. ಅಲ್ಲಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ
ಆಗಿಲ್ಲ ಅಂತ 10% ಮ್ಯಾಟ್ರ್ ಎಲ್ಲ ಕಡೆ 10%.
Interim order is
ಗೊತ್ತು.
operation.
Operation?
Operation.
In operation. All right. Affidavit when the tribunal be constituted and start functioning by the next date of hearing.
So
Venkatesh Karve avare.
So my lords, we'll take the instruction.
Tribunal is constituted. When it is going to function.
Not functioning.
It's not functioning.
Then AC chamber illa anta ansutte. ಅದಕ್ಕೆ.
Take the instruction, please.
This court, coordinate bench of this court on 9/9/2025 had passed the following order. The learned Additional Advocate General submits that the direction ought to have been issued to the fourth respondent, the Union of India, and not the state, as the tribunal is to be constituted by the Union of India. The Deputy Solicitor General of India, Venkatesh Karve, to secure instructions as to the functioning of the tribunal after its constitution, as the contention in plethora of cases presented before this court is that the tribunal is not functioning despite its constitution. The affidavit be filed by of the competent officer be filed by the next date, lest the matter on 17th in the fresh matters list.
Please.
DSG ಅವರೇ, ನಿಮ್ ವೆಂಕಟೇಶ್ ಕಾರ್ವಿ ಅಂದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. Yes. Affidavit, please.
Another connected matter.
Kodi, tag along with sounds.
So instead of 17th, may I seek on 24th?
ಯಾಕೆ? ನೀವಿರಲ್ವಾ? Where are you going? Where do I go ಅಂತ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ. Yes. Just on 24th.
Interim order.
Interim order subsisting.
Number 86, Shivraj is Baldati, ML 20.
So I moved the matter, my lords, seeking consideration of interim relief. In the connected matter 86.1, there is an order of status quo, my lords, directing both the parties to maintain status quo. Matter arises out of land acquisition. My lords, I've challenged, my lords, the acquisition, very acquisition itself, my lords, and the endorsement issued by, my lords, the respondent. Land is acquired, my lords, in the year 1999. Till date, my lords, possession has not been taken.
Yes, sir.
It's not correct. But in the
2000
endorsement we have stated it.
Kindly turn to
Land was
page number
acquired,
27.
Land was allotted to some other fourth respondent.
2015, the beneficiary returns back the land, my lords, to KIDB. Till date, my lords, we are in possession.
Anyway, we'll take it. Objections hakidira. Learned Counsel Shivkumar Badodgi submits that seeks 10 days time to file statement of objections. 26th objections, if any, by then interim order of any kind subsisting in any of these cases shall continue to the next date of hearing.
6.1, my lords, there is an interim order directing to maintain status quo, my lords. May I request
That will
for-
continue.
Like in 86 also, my lords, if similar order is.
If you are in possession, you will continue with this. Next, yes.
87,
Obliged.
Nicholas Daly, Hashim Kharvi.
Amendment filed. An amendment.
To amend the prayer para and notes one paragraph notes in grounds.
What's the matter?
It is where my lords, I have delayed in my lords unloading the goods from the railways. They have imposed a fine, my lords. Notes for a delay reason is that.
Will not interfere with all that.
Notes demurrage is charged. Demurrage is charged, my lords. My submission, the regulation which my friend is relying upon. According to that, when there is a rain, when I am unable to unload the vehicles, there is a scope for my lords waiving off. That is what the notification, that notification is what my knowledge.
We filed objection, my lords. Connected, one more
One more
petition filed
connected
by-
I had filed. Please.
One more.
Tag this petition along with so and so.
Please.
12th, my lords. Kindly have it on 12th.
12th bada. Thursday bada. Next
Please,
Thursday.
please.
List on 6th.
Notes, interim order may be extended.
Interim order subsisting will continue to the next date of hearing. Yes, next.
Number 88, Mantesh Hiremat.
But application is filed. not
Objections
for-
filed with the respondent.
Your Lordship, counsel is held up in another court. I'll kindly have it tomorrow or day after tomorrow.
Yes. Again, Shrikant.
Can be taken.
List the matter on 25th.
Please.
Interim order, yeah?
Yes, ma'am.
Idea.
Extendment.
Interim order subsisting will continue to the next date of hearing. Yes, next.
89, Sadiq Godwala.
This proceedings arises because of this impleading applicants. Lord, annexure C is without jurisdiction. Lord, Tahsildar passes an order.
Reading is there. Any objection?
Impleading in his application, he says they are the residents of, my lord, they are public strangers.
So, objection hakbaka?
Oral objection, it can be considered.
Yes, so it's,
My lord, I kindly see annexure C. Tahsildar passes order, my lord, shifting of my lord deity to another place, which is, my lord, it is a private deity of the family of the petitioners.
Deity is shifted.
Ad madidare. Kindly see annexure C in page 52.
ನೀವೇನು ಕಂಬಿ ಅವ್ರ ತರ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಏನು?
ಅಂತ.
ಇಲ್ಲ.
ಸರಿ.
Tahsildar has no power. It is,
Right,
my lord,
right.
private property of the petitioners, proceedings of 1924 till 1957. Now the public, my lord, gives their representation to the Tahsildar. On their representation, the order is passed. Kindly see annexure C, my lord, in page 53.
Interim order ಇಲ್ವಾ ಇದರಲ್ಲಿ?
Interim order ಇದೆ.
List the matter on 18th in fresh matters list.
Please.
We'll close it.
Please.
ಯಾಕೆ MLA MP ಯಾರಾದ್ರೂ?
ಅದು ಅವ್ರ ಕಡೆಯಿಂದ ಕೊಡಿಸಿ ಇಷ್ಟೆಲ್ಲ ಮಾಡಿದ್ದು.
90, MB Hiremat.
Pray for short accommodation, it's 2 days. There is an interim order.
19th?
Please,
List on 19th, yes.
let's, there is an interim order.
That will continue.
Yes.
Their matter, interim order.
ಕರ್ದು ಬಿಡಿ.
230 mood list, serial number 1, Ganesh Rai Bagi.
Voting. ಗಣೇಶ್ ರಾಯಬಾಗಿ ನೀವಲ್ಲ
Serial number 47 ಆಗಿದೆ, same order.
serial number 47 same order ಮಾಡಿ.
And 2 and 4, 2 and 4 my lord ಇದೆ. ಬರ್ಮನ್ ಅವರು.
2 and 4 ಯಾರದು? ಬರ್ಮಾ.
1 and 3, my lord.
State. Yes,
5 process. Highly.
voting, next.
Till number 2, Sridhar Prabhu.
Forest,
Idರಲ್ಲಿ for 1961, my lord, the 90 acres land is granted to me, easement is granted to me, and my lord, that 35 to 40 yards length nalli on easement ಕೊಡ್ತೀವಿ for approach ಅಂತ ಹೇಳ್ತಾರೆ. Now, my lord, they say from 60, I constructed the road for my easement to my factory. Now they say that part of it is, my lord, forest. You have not, ಅಂದ್ರೆ ಏನಾಗಿದೆ, actually, my lord, the fact remains that 45 yards ಗಿಂತ ಅದು ಜಾಸ್ತಿ ಇದೆ. It is a fact, my lord. When it was granted to me, no actual survey was conducted. Government at that point, my lord, approximately wanted to create an easement.
ಅಲ್ಲಿ ಏನ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
Sorry, my lord.
ಮನೆ ಇದೆಯಾ?
ಇಲ್ಲ, factory, my lord. There are about 4,000 workers, and from 61 onwards, I have been running. And now they issue.
ಏನಿದು iron ore ಇದ್ದಂಗಿದೆ?
Sorry, my lord.
Iron ore?
Yes, yes, that manganese and iron ore.
No, ಅಲ್ಲೆಲ್ಲ would have destroyed everything.
No, my lord. It is not that mining belt. This is 61. We are conventionally, my lord, we have never, my lord, traced. We have never harmed the environment, my lord. I can say it with conviction.
Yes, government.
Get instruction.
Begin urgency.
Ingress, that is blocked, my lord. Lordships may see, the printout is, today, my lord, they have come and blocked the ingress. I have not been able to enter the premises, my lord.
ಎಲ್ಲಿ?
I will get it right here. It is issued today to me. They have said, you please vacate you can't enter the factory premises. From 61 onwards, my lord, the situation remains. The lordships will see, my lord. Lordships will see, my lord, the last ಮೇಲ್ಮನವಿ ಪ್ರಾಧಿಕಾರ so ಒಂದು ಒತ್ತುವರಿಯನ್ನು ತೆರವುಗೊಳಿಸಿ ಅರಣ್ಯ ಇಲಾಖೆ ಸುಪರ್ದಿಗೆ ವಹಿಸುವಂತೆ. The issue is, my lord, they also acknowledge I have easement. Only because they are taking advantage of that 40 feet, 50 feet ಅಂತ ಇರೋದ್ರಲ್ಲಿ. That is all, my lord, I am saying. And they also, ಈ ಕಡೆ 50 feet, ಆ ಕಡೆ 50 feet ಅಂತ ಅವರು ಹೇಳಲ್ಲ. They are also in confusion. I have never harmed anything. Same length I have used, my lord. Bitumen road I have constructed. I have never harmed any environment, my lord.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ. I have served it. I get answer.
Heard the learned counsel Sridhar Prabhu appearing for the petitioner. The petitioner has moved the matter on account of his ingress and egress to the industry being stopped. It is stopped by the officials of the forest department on the score that the road is constructed on a forest land. The learned counsel for the petitioner submits that the petitioner since 1961 has had the easementary rights for ingress and egress to the said industry. The learned counsel for this ingress and egress to the said industry. Even otherwise, even otherwise, section 27 of the Act permits ingress and egress to the persons who have set up houses or industry within the forest area. Therefore,
I didn't know. I'm sorry. I concede. First time I'm doing
27 of the Forest Act, no day.
Grateful.
Yes.
Grateful.
In that light, there shall be an interim order of stay of the impugned action till the next date of hearing. List the matter on 19th. I think 27, just Forest Act only the note.
Yes.
Section 27, if I remember.
Yes, I'll check right away. Annexure A, my lord, and B.
Whatever.
I am directed take notice.
Learned AGA is directed to accept notice for the respondents.
One end.
ಇನ್ಯಾರಿದ್ದಾರೆ?
And someone.
ಆಯ್ತು, ಇನ್ಯಾರಿದ್ದಾರೆ? ರೆಸ್ಪಾನ್ಸ್ ಇನ್ಯಾರಿಲ್ವಾ? ಎಲ್ಲ ಸ್ಟೇಟಾ?
ACF, yes. The ACF and DCF. ACF and CF.
Yes.
Great.
Till number 3, Joshi Shri Prasad.
Lordship, this is a GMRC matter. I have moved this matter for the reason that
ಬರಲ್ವಾ?
it comes before this one.
Yes.
The petitioners are hereditary Archakas of the temple at Ammanigi, and this was notified. That is not under challenge. Now, the problem is the Tahsildar who was appointed as an administrator in 2024. Now, even after lapse of his period as an administrator, now without any order, he is trying to evict these hereditary Archakas from the premises. Please, Lordship.
Hereditary Archaks.
Hereditary Archaks. And I have protection.
Protection what?
I have protection under section 9, Your Lordship, of the Endowments Act. So I am seeking.
Petitioner shall serve. ಯಾರಿದ್ದಾರೆ ರೆಸ್ಪಾನ್ಸ್ ಯಾರಿದ್ದಾರೆ?
Government.
ಎಲ್ಲ ನೀವೇನಾ? Learned AGA is directed to accept notice for all the respondents. Copy ಇದೆಯಾ ರಮೇಶ್?
Yes, ma'am.
The AGA to secure instructions in the matter. There shall be an interim order of stay spread for till the next date of hearing. List the matter on 19th.
May I request for hand delivery?
No.
I'll give him. Please, Your
Memo.
Lordship. Please, Your Lordship.
Till number 4, Avinash
ನೀವು
Mangali.
ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ ಮೆಮೋನು ಐಪ್ಯಾಡ್ ಅಲ್ಲಿ ತಂದಿರ್ತೀರಾ, ಐಪ್ಯಾಡ್ ಕೊಡಿ ಅಂತ ಕೇಳಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ ಮೆಮೋ ಕೊಡಿ.
Please. Please. My lords, I'm appearing for the Land Council in this.
Yavudu
My
ಇದು?
lord, this KBJL matters, my lord, the same matter which your lordships are pleased to hear. Now, my lord, what they do is, my lord, they don't erase as parties, get orders in all these cases.
I
Despite there
granted
is
stay.
a please.
Monday
Please.
15
Now, my-
matters are granted stay. Heard the Learned
Please.
Senior Council KPTCL appearing for the petition. Tag same order.
Please. I only
Sorry.
pray your
Tag
lords,
ಬೇಡ.
please.
Identity
ಹೌದು.
ಸೇಮ್ ಆರ್ಡರ್ ಎಲ್ಲದರ ಟೈಪ್ ಮಾಡ್ಬಿಡಿ.
18.
This and 18th matter, it need not be 18th because we may not be able to serve. 18th, your lords may decide the point, my lords. Whether my lords without notice it's proper or not. 18th is there. This can go to some
18th.
other date because my lords, I don't know whether we'll be able to serve so soon, my lords. Non-service again, it will.
Don't worry, even I don't know whether I'll be able to take it or not. Yes.
And also, I wish to bring to kind notice, my lord, there are several matters before different benches in the same subject matter, my lords. Unless this is decided once for all, my lord, there are thousands of cases going on this, like this, my lords. Therefore, I humbly pray, my lords.
Thousands of cases.
18th, my lords, when the matter comes up, my lords, because some matters before different benches, my lord. So therefore, unless it's decided once for all, my lords.
ಆಯ್ತು ಕೊಡಿ. Yes.
Please.
State may direct to take notice. I may direct to take notice, my lords.
ಅದ್ರಲ್ಲಿ ಆಗಿದೆ, ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅದೇ ಮೇಡಮ್, ಆಗ್ಲೇ ಆಗಿದೆ. Whatever is there in that, ವಿಜಯಲಕ್ಷ್ಮಿ ಅವ್ರ ನೋಟಿಸ್ ಯಾರು ಕೊಡಿ. Next.
Please, I am grateful, my lords.
ಅಡಿಷನಲ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಯಾಕೆ ಆಯ್ತದೆ? ಪೆರೋಲ್ದ ಎಕ್ಸ್ಟರ್ನ್ಮೆಂಟ್ದ? ಬನ್ನಿ. You found Avinash?
Lord, Your Lordship and Lord. Agli tavu WP in my lord in one of your judgment, my lord, in WP 9461 of 24.
I guess so.
Sachin, in that, my lord, your lordship has referred Deepak versus State of Maharashtra. I'm getting it, my lord. Just, my lord, I thought, my lord, your lordship has passed an order.
Gangadhar,
Please.
see this, the two operate on a different footing. ಯಾವುದು prohibitory orders or this.
Please.
Now, in these cases, issuance of show cause notice is mandatory.
Yes.
There is
Yes.
no doubt.
Yes.
The provision itself says.
Yes.
If issuance of show cause notice is mandatory,
Please.
can it be a blind show cause notice?
Regarding the content of the, yes, there is a content of the general, the notice should be contained, general instructions, not.
General instructions.
General ground should be contained, but not.
ನೋಡಿದ್ರೆ ನಮಗೆ ಆಗೋದಿಲ್ಲ.
But not the, only to the extent that furnishing of the report, because by report, the police authorities for various reasons.
In report andre, this is not an investigation report. You would have drawn a prima facie report through the hands of the assistant commissioner or whatever.
The report will be forwarded by the policeman.
Police to the assistant commissioner.
Please.
Now the police will forward a report, not an investigation report after registration of a crime.
Yes, surely not.
It is a report that is used to deny a fundamental right of movement of the petition of any person.
Please.
So if you give a blind notice without enclosing anything, what sort of?
Because sometimes the report consisting of that is what in that Supreme Court that says only one paragraph. The last that full complete disclosure of particulars, such requisite in open prosecution will frustrate the very purpose of extremate proceedings. So that is why they said it is not, they are not entitled. Not suppose for the sake of hypothetical example, if there is any materials collected by the police saying that they are going to commit some offense from any other means, if we furnish those reports, that will.
No, that is your investigation, preliminary investigation at ಬೇಕಾಗಲ್ಲ. ಈಗ ಏನು ಹೇಳ್ತೀರಾ ಅವರಿಗೆ?
Regarding
report ಕೊಡಲ್ಲ. What do you say?
The authority should mention the grounds on which the proceedings have been initiated. See why there is the threat to the system and all those things, dependency of the cases and all those things they have to mention, my lord. But exactly the report they are not entitled, my lord. If any some information which is mental information is available, that is not entitled, my lord. That only to that extent, my lord. My submission is that they are not entitled to the report as such. In Deepak case also, my lord, they refer this judgment, but not these the paragraph. Subsequently, again, Supreme Court has followed this judgment in the case of State of Maharashtra and Hasan Khan also. It is consistently has followed. But these two judgments have not been these ratios have not been referred by in the Deepak case. This is the ratio, my lord.
ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲ ಅದು ಮಾಡಿಲ್ಲ, ಮಾಡಬೇಕಾಗಿತ್ತು. So therefore, that is well, the purpose has been discussed, my lord, in this case.
Yes, sir.
Not my submission, my lord. Under section 58, my lord, hearing to be given before an order is passed under section 54, 55, and or 56. Lord, in this case, my lord, in instant case, my lord, order has been passed under section 55 insofar as the petitioner is concerned. Lord, before an order under section so and so is passed against any person, the officer acting under any of the said sections or any officer of the above rank of inspector authorized by the officer shall inform, my lord, shall inform the person in writing in the general nature of material allegations. Lord, here, my lord, the word is used shall. My lord, with all due respect to the judgment referred by the AG, my lord, insofar as this issue is concerned, my lord, he says all reports should not be incomplete, but it specifically says that material allegations must be mentioned in the notice which, my lord, the assistant commissioner ought to have been sent to us. My lord, in this case, he openly says that the proceedings have been initiated, you come and appear before us. This is the only notice which they have issued to us, my lord. No such grounds which have been mentioned in my particular notice. On that ground, my lord, it is on the technicality, my lord. Insofar as the merit is concerned, my lord, I have a case also, my lord, because the Honorable High Court in a division bench, my lord, because the contrary orders have been passed by the, my lord, this my lord, different court, my lord, the coordinate benches. The division bench and the order is there. Writ petitions are maintainable.
Writ petition is meant why?
Please no, my lords. They are saying in some of the judgments, they are saying that under section 59, my lord, there is an appellate authority, my lord, that is ACS home. We'll have to go there and file an appeal. That is why, my lord, the honorable court has passed an order. The writ is also maintainable.
I have no doubt about that at all.
No, my
need
lord,
not give me judgment.
next point, my lord, they are going to urge before this court. The appellate, my lord, there is an appeal provision under section 59 of Karnataka Police Act. All these, my lord, subjects have been dealt by the honorable division bench and held that this writ is maintainable. And, my lord, in my case, my lord, the petitioner, my lord, he is a 65 years old. And, my lord, not even a single case, my lord, he has been convicted. And, my lord, since all last 2 months, my lord, he is suffering from some illness. And he has been externed to, my lord, Chamaraj Nagar. He's from Bagalkot district, my lord.
Bagalkot to Chamaraj Nagar.
Sir. Yes, so, my lord, not even in single case, my lord, he has been convicted.
Case pending ಇದೆಯಲ್ಲ, externment ಗೆ convict ಆಗಿ ಬರಬೇಕು ಅಂತ ಇಲ್ಲ.
Correct. But, my lord, another point.
It should be a threat to the society.
Please, my lord, under section 55B, my lord, it says with the permission, my lord, that there are reasonable grounds for believing that such person is engaged or is about to be engaged in a commission of an offense involving force or violence or an offense punishable under chapter 12, 16 and 17 of the Indian Penal Code, or in abatement of such offense when in the opinion of such officer witnesses are not willing to come forward. But in this case, my lord, no such threats have been imposed by the petitioner. And, my lord, not even a single application has been filed on behalf of the prosecution to seek cancellation of bail. If there is any threat by him, my lord, to the witnesses of the prosecution, my lord. And, my lord, the 3 cases, there are 4 cases which have been registered against me. Lord, 3 cases are of the year 2019. 1 case is of the year 2025, my lord. Lord, there is a gap of nearly about 4 years, my lord, in registration of another crime.
Local election ಏನಿತ್ತು ಅವಾಗ?
And, my lord, he belongs to a...
ಈಗ ಯಾವ್ದು?
ಅಲ್ಲ, ಇವಾಗಲ್ಲ. ಇವಾಗಲ್ಲ. So, my lord, with all political rivalry, my lord, he has been implicated.
I will take all these and pass some orders. Reserve one ತೋರಿಸಲ್ಲ. I will post it and we'll do something about it. We'll get the judgments, don't worry.
36, 37 also.
Same. ಮೂರುನು.
35, 36.
ನಿಮ್ದು ಯಾವುದು?
35.
Mine is 30, my lord.
ನಿಮ್ದು?
35 and 36.
35 and 36 and so and so. All
30.
Post them all on 21st and ಹಾಕಿರಿ, ಅಷ್ಟರಲ್ಲಿ will pass orders.
Oblige.
Pass order. ಕೊಡಿ.
Bill number 33. Syed
Sachin
Arif.
Angadi.
I sought instruction, my lord. They said, my lord, already ಅಲ್ಲೇಗ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಹೇಳಿದೆ ಸರ್ 50% at least ಕಟ್ರಿ ನಾವು ಪೊಸಿಷನ್ ಕೊಡ್ತೀವಿ ಅಂತಂದ they are not paid there, my lord.
ಈ ಪೊಸಿಷನ್ ಕೊಡ್ತೀರಾ ಹೆಂಗೆ?
If they are ready to pay, my lord.
ಇಲ್ಲ, ಫಸ್ಟ್ ಕೊಡಿ.
Because we are initiating surface proceedings and
problem,
afterwards,
sir. I
my
will
lord.
take care of that. ಈಗ ಯಾವಾಗ ಕಟ್ತೀರಾ?
2 lakhs rupees I pay on Monday.
Monday possession ಕೊಡಿ. Yes, the learned counsel appearing for the petitioner submits 2 lakhs would be paid by Monday. The learned counsel further submits that out of the amount outstanding, the petitioner has already paid 8 lakhs, and therefore the petitioners are now put on the streets as the only dwelling house is in the possession of the bank. Therefore, the moment that the bank receives rupees 2 lakhs from the hands of the petitioner, the possession shall be handed over to the petitioner, which shall however remain subject to the result of the petition. List the matter on 17th in the fresh matters list. Interim order subsisting would continue to the next date of hearing.
One, my lord, we are ready to one-time settlement also.
We are also ready.
Possession ಕೊಟ್ಬಿಡಿ.
Yes, my lord, we are ready, my lord.
ಯಾರು 10 ಲಕ್ಷ ಲೋನ್, 8 ಲಕ್ಷ ಲೋನ್ ಮನೆಯಿಂದ ಆಚೆ ಹಾಕ್ರೆ ಎಲ್ಲಿ ಹೋಗ್ಬೋದು?
Yes, my lord. Yes.
2 crores, 3 crores ಇಂಡಸ್ಟ್ರಿ ಆರಾಮಾಗಿ ಅವ್ರ ಜೊತೆ ಇರ್ತೀರಾ, ಏನು ತೊಂದರೆ ಕೊಡಲ್ಲ. ಸರ್ಫೇಸ್ ಪ್ರೊಸೀಡಿಂಗ್ ಎಂಟರ್ಟೈನ್ ಮಾಡಬಾರ್ದು ಅಂದ್ರೆ ನಿಮಗೆ ಬಿಟ್ಟೆದ್ ಸಿಕ್ಕಿದ್ ಮಾಡ್ಬಿಡ್ತೀರಾ ನೀವು. If we stop entertaining these petitions, you will do whatever you want. Yes. ಏನಂದ್ರೆ
Bill number 91.
One sufficient. There is one more password matter.
ಗೊತ್ತು ಇರ್ಲಿ.
91 SM Palwad, RH Angadi.
Please, my lord.
Hmm.
My lord.
2010.
Yes. As per section 27 of Karnataka Urban Development Authorities Act, my lord, if the scheme is not implemented within 5 years from the date of publication of 19-1 notification, acquisition proceedings would be lapsed, my lord. So, my lord, 19-1 notification issued on 7/10/2003 and
Urban Development Authority Act.
Urban Development Authority. And 16-2 notification issued on 6/2/2009.
Yes.
Already 5 years lapsed, my lord. And
My lord, the lands are already developed and allotted to the several members, my lord. And this similar matter went up to the Supreme Court, and Supreme Court has also held that the petitioner's land cannot be deleted. Earlier, they have filed a writ petition, and on the strength of interim order, my lord, the authority has passed a resolution for the deletion of their land. Later, the government has rejected the same, that if their land is deleted from the acquisition, the entire purpose would not survive. For that reason, my lord, they have rejected the same, and also it was also notified to them and notified in Gazette, my lord. Later, my lord, the intimation was also served to the petitioners, my lord, and the award is also passed by the LAO, my lord.
ಇಲ್ಲೇನು interim order ಇದೆಯಾ ಈಗ?
interim order.
ಏನಿಲ್ಲ.
It was there, subsequently it was not extended.
ಹೋಯ್ತು.
It was not
ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ. What happened, my lord?
Yes.
That writ petition was not filed by this petitioner. It was filed by some other landowners.
Regarding the same.
In that case, my lord, 19-1 notification was issued. A challenge. Here in this case, my lord, as per section 27, my lord, the scheme itself is not implemented within 5 years. And also, my lord, in respect of very same other landowners, my lord, they have dropped the acquisition proceedings, my lord. As per Annex N and Annex N, I produced those documents, my lord. So they have acted in arbitrary manner.
File a synopsis.
Please.
List of dates and events and their submissions. List the matter on 18th. The petitioner shall file a short synopsis of list of dates and events. Yes, next.
Please.
Please.
Bill number 92 Ananthi Saudi.
Preliminary hearing. Rule issue ಆಗಿದೆಯಾ?
Appear to respond.
Post the matter in final hearing since rule is issued on 31/1/2023, 2013. Next.
Please.
Bill number 93, Ganapati M. Bhatt.
Madam, regularization allada? Allala?
Questioning the appointment of fourth respondent for the post of Anganwadi.
Anganwadi?
Yes, ma'am.
12 ವರ್ಷ ಆಯ್ತು ಹೇಳಿ ಈಗ. ಹಾ.
My contention is as per Answer B, the appointment itself is illegal as per their bylaws of second respondent. Already there is as per in page number 15, there is specific provision who is serving as a Anganwadi assistant to that post, higher post. The government should appoint herself. But instead of that, the called post to that post, even though the petitioner filed application, that one is rejected and considered the application of the fourth respondent. She is actually
Stay ಏನಿಲ್ಲ.
no doubt.
ಕೆಲಸ ಮಾಡ್ತಾ ಇದಾರೆ.
Since 12 years she is doing
ಯಾರೋ
that
ಒಬ್ರು
job.
ಮಕ್ಕಳು ನೋಡ್ಕೊಂತಾ ಇದಾರೆ. ನೀವ್ ಈಗ ಹೋಗಿ ಏನ್ ಮಾಡ್ತೀರಾ ಅಲ್ಲಿ?
Still she is aged about
ಏಜ್ ಇದೆಯಾ?
43.
Next apply ಮಾಡಿ. The petitioner is before this court seeking the following prayer. The petitioner and the respondent number 4 were both participants in a selection process initiated by the state for the purpose of appointment of Anganwadi worker. The fourth respondent comes to be selected while the claim of the petitioner that only she has to be appointed as Anganwadi worker comes to be declined. The learned counsel appearing for the petitioner submits that the petitioner was earlier working as Anganwadi assistant.
Since 10 years.
Anganwadi assistant for 10 years. And in terms of the circular issued by the state, only those persons who are working as Anganwadi assistants should be given preference while appointing an Anganwadi worker, while calling for applications for the post of Anganwadi worker. While the submission may merit some semblance of consideration, the recruitment has taken place 12 years ago. And what the learned counsel for the petitioner projects is an issue of preference. Preference ostensibly would come about only when both are equal. Merit, who is more meritorious?
Same.
Same merit.
ಮಾರ್ಕ್ಸ್ನಲ್ಲಿ ಮೇಲೆ ಇಂಪ್ಯಾಕ್ಟ್
ಮಾರ್ಕ್ಸ್ ಅಲ್ಲಿ ಸೇಮ್
ಅಲ್ಲ ಜಾಸ್ತಿ ಇದೆ
ಯಾರ್ದು?
ನಮ್ದು.
The learned counsel appearing for the respondent submits that the selected candidate is more meritorious than that of the petitioner. In the light of the solitary plea projected by the petitioner being that she should be appointed as Anganwadi Karyakarte on the score that she was already working as Anganwadi assistant for 10 years would not merit any acceptance. In the light of the appointment taking place 13 years ago and no interim order being granted at the hands of this court, it is too late in the day to consider the grounds set out by the petitioner unless the grounds set out were palpable and demonstrable arbitrariness, which I do not find in the case at hand. For the aforesaid reasons, finding no merit in the petition stands. Sumna pending ಏನಆಗಲ್ಲ. Next.
94, Shivraj C. Ballaki.
Before petitioner disposed of matter, my lord.
Disposed of matter.
There was a direction, my lord, to allot the sites. On petitioner paying the value of the site, but he couldn't, within time, he couldn't pay the value of the site. My lord, that's why
Order is dated
application is filed.
20th February 2015, my lords. He was supposed to pay, my lords.
Extension of time ಯಾವಾಗ ಕೇಳ್ತಾ ಇದ್ದೀರಾ sir? ಈಗ.
There's one.
That too not by the original allottee, by his legal heirs.
Lord, there are two applications. One is by petitioner number 2. Lord, earlier, my lord, the time was extended in the same matter, my lord, by order dated 27/8/2021. ಇದ್ರಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ.
This is second extension.
ಅಲ್ಲ, ಇದು ಬೇರೆ petitioner. There are several petitioners. Lord, there is one more judgment also. In 2021, my lord, it was allowed at same value of the site.
Do you know the latest judgment of the apex court on this 2025 3 SCC? Those who have not paid the entire amount, no indulgence should be shown at all by the high courts. All the housing board cases, all of us had granted orders. ಇದು ಸ್ವಲ್ಪ ತಗೊಂಡ್ ಕೊಟ್ಬಿಡಿ, ಅದು ಸ್ವಲ್ಪ ತಗೊಂಡ್ ಕೊಟ್ಬಿಡಿ. Supreme Court says nothing, ಎಲ್ಲ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
These are the sites, my lord, allotted pursuant to
Supreme
award.
Court says if allotment letters are violated by not paying the amount in time, no indulgence should be shown.
It's not allot.
This is gross.
It is not allotment order. It's an order from this honorable court. That is that extension, my lord. In 2021, my lord, more than 2 to 3%, my lord, it was extended. Seeking parity and, my lord, one of the matters, my lord, freshly it was allowed.
Freshly?
ಅಂದ್ರೆ fresh matter ಅಲ್ಲಿ allow ಮಾಡಿದ್ರು ಅಷ್ಟೇ.
ಇದು fresh matter ಗೆ ಹಾಕ್ಲಾ?
ಅಲ್ಲ, ಇದು 2015 matters ಅಲ್ಲಿ extension ಮಾಡಿದ್ರು. One writ petition and a fresh matter.
ಅಯ್ಯೋ, ಶಾಕ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
They have accepted.
ಕೊಡಿ.
After 7 years it was extended.
Sir, nothing. Get that latest judgment and stop doing all this.
But this person's, my lord,
Done foul of Supreme Court's order.
yes, part of this special task force, my lord, for nabbing Veerappan.
Oh, same identical issue le matters.
But I'll verify the judgment. And I'm seeking parity, my lord, the 2021 order.
ಇಲ್ಲಿವರೆಗೂ
extend ಮಾಡಿದ್ದಾರೆ. ಇದು same.
ಇಲ್ಲಿವರೆಗೂ parity. Supreme Court judgment ಆದ್ಮೇಲೆ clarity. Yes. List. Day after tomorrow in fresh matters list.
95, Suresh S. Bhatt.
ನಾನು ಬೆಂಗಳೂರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಸುಮಾರು.
I will. Say 95, day after tomorrow.
Why,
Fresh-
sir?
Fresh matter, 95.
Why, sir?
Pleadings are to be completed, my lords.
Completed.
Not yet completed, my lords. We have-
Completed.
So next week, my lords
Just
will
on
come.
25th.
Please, my lords.
Not
Why,
20.
sir? ಏನ್ ಇಶ್ಯೂ ಹೇಳಿ?
18,
ಡಿಸ್ಮಿಸಲ್.
Dismissal.
ಅದಕ್ಕೇನ್ ಅರ್ಜೆನ್ಸಿ?
Subsistence allowance ಅವ್ನು ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾನೆ.
ಡಿಸ್ಮಿಸಲ್ ಸಬ್ಸಿಡೆನ್ಸ್ ಅಲೌನ್ಸ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾನೆ ಪಾರ್ಟಿ. That's why
ಯಾರು ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ?
that candidate, SDC.
ಹಂಗಾರೆ ಬರೀ ಉಳಿದಿರೋದು ಬ್ಯಾಕ್ ವೇಜಸ್ ಮಾತ್ರ.
ಅಷ್ಟೇ.
ಅದ್ರಲ್ಲೇನ್ ಸಬ್ಸಿಡೆನ್ಸ್ ಅಲೌನ್ಸ್ ಇಲ್ಲ. ಎಸ್. ಏನೋ ಅಂತ ಕೇಳಿ.
11th.
List on 25th, objections if any by then. In the event objections should not come about, it shall be construed that there are no objections to the petition.
Please, my lords.
96, Satish K.
Senior will appear. 96.
Lord, I appear for the counsel for the petitioner, my lord. But short question is, my lord, whether the petitioner who is not in a group B, my lord, holder of group B post can be removed from service by the not managing director under the rules. He is neither appointing nor the disciplinary authority.
ಯಾವ ಕೇಡರ್ ಸರ್?
Assistant engineer, group B post, my lord. Rules have been produced, my lord.
Where is the latest judgment?
My lord, rules are there.
Rules ಬಿಡಿ. When the disciplinary authority is required to pass an order, when the appointing authority is required to pass an order. ಎಲ್ಲಿದೆ? August ಅಲ್ಲಿ Supreme Court has written. Latest. Where?
But with reference to the rule, I'm.
No, sir, reference to the rule, Justice Dipankar Datta has written, yes.
There is no delegation of power, Lord, under the way.
This is the matter on 18th in preliminary hearing. Next.
98.
But interim order may be continued, my lord.
Interim order subsisting will
Interim order
continue.
may be continued, my lord.
Yes, sir. Next.
98, Shreyas Nirupan, A.L. Larkhan.
My lord, petitioner is challenging impugned order at annexure A, my lord. That is form number 60 under section 52 of Waqf Act.
No representation on behalf of the respondent. List the matter on 19th in preliminary hearing.
Obliged.
Interim order, yeah?
Yes.
Interim order continue to the next date of hearing.
Obliged.
99, Dinesh and Kulkarni.
Yes,
Let's-
Babu.
Writ of mandamus, my lords. Karnataka Housing Board had acquired my land, my lords. Now, next year came, my lords, page number 65. According to that report, my land may be denotified, my lords.
Yes, government. Housing board error.
My land was not utilized, my lords. And they have submitted a report.
Presentation ಕೊಟ್ಟಿದೆ.
Yes, I had given representation to respond number 2, my
Housing
lords.
board, ಯಾರು appear ಆಗ್ತಾರೆ housing board generally?
Let's, last occasion.
ಹಾಕಿದಾರ?
Yes, my lord.
R3 and R4. Heard the learned counsel Vaibhavi Namdar appearing for the petitioner. No representation on behalf of respondents 3 and 4 awaiting their appearance list on 18th in the fresh matters list.
last time,
Vanillilva?
ಇಲ್ಲ.
There has been no representation, therefore list the matter on 18th in the fresh matters list. We'll dispose it on that.
100 Hemant Kumar L. Havargi,
Please,
Anuj G. Deshpande,
for the petitioner, my lordship. Illegal recruitment made by the, illegal recruitment made by the.
Legal?
Recruitment, my lordship.
Recruitment. Oh, ಇದು NET SLT ಆಗಿಲ್ಲ
Please,
ಅಂತ.
please. Lordship, the.
ಇನ್ನೊಂದಿನ ಕೇಳುವ. We'll fix 18th.
Please.
Readings are complete?
In one matter, I have not yet filed a statement of objections. In second matter.
The first matter.
First matter. 107.
19th.
425.
19th or 20th, yes.
Please.
Will 20th, yes. List on 20th.
Please.
Yes.
Fresh matter list.
Preliminary hearing. Yes.
Please.
101 Harshvardhan M. Patil,
Additional documents filed by petitioner.
In this matter,
Manappuramma.
Manappuram.
ಏನು?
Lord, I had availed loan from the financial institution and had also, Lord, availed insurance over the said loan amount.
Repudiate ಮಾಡಿದಾರ ಈಗ?
ಅಲ್ಲ, ಅವರು ಅದನ್ನ ಇನ್ಶೂರೆನ್ಸ್ ದವರಿಗೆ ಪ್ರೀಮಿಯಂ ಪೇ ಮಾಡಿಲ್ಲ. After the death of the insured, my lord, they have paid the insurance amount to the respondent number 3, who is the insurance company. Manappuram.
ಅವ್ರು ಮಾಡದೆ. ನೀವು ಮನ್ನಪುರಂ
ಅಲ್ಲ,
ಅಲ್ವಾ?
ಅವ್ರ ಮ್ಯಾಕ್ಸ್ ಲೈಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಗೆ Manappuram is being served and they are unrepresented.
What's the order?
Lord,
what is the order you want?
Lord, please. The order, my lord, is at Annexure G, page number 46.
Relief ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
Relief, my lord, to waive off, to set aside the order, my lord, passed in the criminal miscellaneous. That is, my lord, to repay the loan amount they have initiated Surfacia Act.
List day after tomorrow in fresh matters list.
Lord, even after the interim order is being granted, they are not appearing and they are sending notices.
You will dispose it, sir.
Please, please,
Yes.
please,
Day after tomorrow.
please.
102
Grateful.
Yes, I pray time.
ಹೌದೇನಾ?
Yes, Parag.
101 ಆಗಿದೆ ಮೇಡಮ್ ಈಗ. ಕರೆದಿದ್ದ? ಸಾರಿ.
I pray 1 week time in this
Parag,
case, 1 or 2.
One submission, Lord, very short issue.
Short issue objection ಬೇಡವಾ?
ಇಲ್ಲ, ಹಾಕಿದ್ದಾರೆ, objection ಕೂಡ ಹಾಕಿದ್ದಾರೆ. It's only this, whether, my lord, non-claiming of ITC in the monthly return, that is GSTR 3B. Now, what has happened is, my lord, there is also no interim order in this writ petition. Notice is issued.
ITC ತಾನೆ?
ಅಲ್ಲ, notice is issued for payment on the levy and penalty of the output tax credit now in both these petitions.
AGA seeks a week's time to make his submissions. Finally lists the matter on 18th. In the event no submissions are made, petition will be disposed on hearing the counsel for the petitioner. Next.
Now, interim order may kindly be granted. ಅಲ್ಲ, ಕೊಟ್ಟಿಲ್ಲ, because on all the earlier occasions, my lord, it was for disposal anta we had made submission. Now this notice is issued, my lords may kindly see.
The respondent shall not precipitate the matter, quay the issue till the next date of hearing. Please.
103 Shivkumar S. Badwadgi,
Please, my lords.
Shall not precipitate.
Yes, sir.
Yes, in this case, my lords, the petitioners have approached, my lords, in this writ petition, challenging the endorsement issued by, my lords, the third respondent, whereby, my lords, the application submitted by the petitioners came to be rejected.
For what?
That's on the ground that, my lords, petitions.
For what applications were given?
My lords, earlier, my lords, the petitioners are working as, my lords, the teachers in JOC course, my lords. Annexure A is appointment order, my lords. Annexure B is, my lords.
ಏನ್ ಕೇಳಿದ್ರಿ?
As per Annexure C, government has taken a decision to close down all the JOCs.
Correct.
They have taken a decision to absorb all the employees who are working in these institutions. Plus, one of the condition in the Annexure C notification is, plus, those who have completed 5 years, they will be taken into consideration for absorbing. But though the petitions have completed 5 years, but they have been relieved from service. They approached the Assembly Court by filing a writ petition. As per Annexure F, the Assembly Court has granted an order of interim order directing not to relieve the petition if not already relieved. Later on, as for Annexure G, plus the sum court dispose of the writ petitions, directing plus the authorities to consider the case of the petitioners in terms of plus whether they have completed 5 years or not, their representation has to be considered. Pursuant to that, plus we have submitted detailed representation and we have furnished plus page 51, plus may kindly see. I have furnished all the details when I have been appointed and when I have been plus relieved from service. That clearly goes to show that plus I comes under that condition of plus 5 years.
Why left out?
They have not considered it.
Your Lordship, in first petition, Your Lordship, 5 years agide, Your Lordship. But in the second petition, 4 years, 11 months, 15 days agide.
No, it is not. That's why let's
Petition we will direct consideration.
no first petition let's page 51 let's may kindly see let's I give her the details of let's
First petition, no, in terms of what Justice Indresh has held, we will direct consideration.
page 51 let's may kindly see let's I have given the details.
Yaudu 101946.
Yes, let's
Page
51. Initially, have been appointed on 6/4/2006. I worked in
55 ದಿನ.
289 days.
Yes, madam.
In both the cases, we have completed 5 years.
15 days kadime ide anta what I have got instructions, Your Lordship. That is,
ಚೆಕ್ ಮಾಡಿ ಡೇಟ್ಸ್ ಏನು ತಗೊಂಡಿದ್ದಾರೆ.
please, Your Lordship.
ಮಾಡ್ಬಿಟ್ಟು ಹೇಳಿ. List on 18th fresh
Please, Your
matters
Lordship.
list. Yes. Next.
No.4, Shan Madhpati VS Kamti.
My lord, petition.
Even before starting, why are you laughing?
Lord,
Time ಆಗೋಯ್ತಾ?
ಇಲ್ಲ.
ಇನ್ನೊಂದು ದಿನ ತಗೊಳ್ಳ.
ಇಲ್ಲ, my lord, today I am ready.
You are ready?
Please.
Yes.
My lord, petitioner, my lord, says appointed as a meter reader in respondent Gescom. Was 2004 to 14, lords, he was worked, my lord. Thereafter, 2014, a case came to be registered against the petitioner, alleging that, my lord, he is tampering the electricity. Based on that, my lord, I got terminated. Thereafter, a criminal case also registered. Now, my lord, the criminal case petitioner has acquitted, and he made a request to the respondent to consider the.
Lord, he is seeking. Lord, he was a GVP, my lord, Grama Vidyut Pratinidhi.
ಅದೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ.
ಅಲ್ಲ, ಇದು ಏನಿದೆ, my lord, the reason why, my lord, my learned friend was smiling, my lord. The 10 years back, my lord, he was removed from GVP on the ground that he was assisting the, my lord, consumer in committing theft of electricity. Then, my lord, criminal case was booked against him. Then, my lord,
He is acquitted there.
then, my lord, ಇಲ್ಲ ಇನ್ನೊಂದು ಆಗಿದೆ. He filed a writ petition before this honorable court against removal. Writ petition dismissed, confirming removal. Then, my lord, he has come after 10 years, my lord, saying that I am acquitted by the criminal court. Please reappoint, my lord, in the GV post. That has been rejected by the Gescom. He is asking to reappoint, my lord.
List on 25th.
Please.
Next.
105, Seema S. Naik, MB Kanvi.
Petitioner. Annexure B, my lord, in page 26. My request for compassionate appointment is rejected.
Government of India na?
HLL, Hindustan Latex. HLL,
Hindustan?
Latex.
Latex Limited.
Hindustan
HLL
Latex
ಅಂತ ಇದೆಯಲ್ಲ?
Limited. Annexure B in page 26.
Date of death?
My lord, date of 28/1/2019.
2019?
19. ಹೌದು. In page 26.
ಏನೋ ಬಾಂಬ್ ಬ್ಲಾಸ್ಟ್ ಎಲ್ಲ ಅಂತೆಲ್ಲ ಹೇಳಿದೀರಾ?
My lord, petitioner, my lord, in the 1994, there was a bomb blast in Gadag. There was an injury to his leg. My lord, he was, my lord, dependent on the, my lord, her sister, who died in the, during the, my lord.
ಈಗ who was an employee of the respondent?
My lord, Bharti Mallige.
That is sister.
Elder sister of petitioner.
You are what?
I'm brother. There are my mother and two other two sisters. Along with them, we made a request. They rejected my lord, application on the ground that you are already, your account has been settled. Therefore, there can't be any.
And brother is entitled.
My lord, this court, my lord, has held. Please.
Brothers, others, ಎಲ್ಲರಿಗೂ ಕಟ್ಬೋದು.
So, this court has directed me to file undertaking affidavit of mother and my lord.
KSRTC.
ಅವರು ರೂಲ್ಸ್ ಇಲ್ಲ, ಅದು ಅವ್ರಿಗೆ ಮಾಡಕ್ ಬರಲ್ಲ ಬಿಕಾಸ್ ಈಸ್ ಎ ಮ್ಯಾರಿಡ್ ಅಂತ. ಕೈಂಡ್ಲಿ ಸಿ ಮಾಡೋರ್ ಪ್ಯಾರಾ 5. Para 5, they say that there is
Too much
no.
of violence to compassionate appointments.
My lord, now I have filed affidavit of mother and sisters. My lord, this court said, if you give an undertaking before this honorable court to look after my lord, mother and sister, my lord, that can be done.
We will be passing orders contrary to rules. The rules ಪ್ರಕಾರ ಏನು? Rule ಇಲ್ವಾ ಇಲ್ಲಿ?
Rule ಇಲ್ಲ.
This is a memorandum of settlement entered into between.
Settlement ಎಲ್ಲಿದೆ?
Page number 30.
What
I
is the
produced.
settlement? Compassionate appointment, what does the settlement say?
No, if she was unmarried, then brother was entitled to. She was married.
Who was married?
The deceased, and whom he is claiming. Deceased sister.
Children?
She herself, no, she did not. Her husband had passed away. He was working with us.
ಅದೇ compassionate appointment.
ಅದನ್ನ ಅವಳಿಗೆ ಕಂಪ್ಯಾಷನೇಟ್ ಕೊಟ್ಟಿದ್ವಿ. ಅದಾದ
She
ನಂತರ
also died.
She died.
Accident
And
in
now
the
brother
company
claims. If she was unmarried, then brother is included within the definition of dependent. Since she was married, my lord, she doesn't fall within the definition of
issues,
dependent.
Huh?
And in fact,
No issues at all.
ಕೊಡಕ್ ನೋ ಇಶ್ಯೂನಾ?
ಇಲ್ಲ, ಅದಕ್ಕೋಲ್ಲ. ಮಕ್ಕಳು ಯಾರು ಇಲ್ಲ. ಮಕ್ಕಳಿಲ್ಲ ಅಂತ
ಗೊತ್ತಾಯ್ತು.
even the declaration which was submitted by her before the management showed that only mother was dependent.
ಡಿಫಿಕಲ್ಟ್ ಸಾಧಿಕ್ ಹೆಂಗೆ ಕೊಡ್ತಾ ಹೋದ್ರೆ ಕಷ್ಟ ಆಗ್ಬಿಡುತ್ತೆ. ರೂಲ್ಸ್ ಪ್ರಕಾರ ಆಗಲ್ಲ. ಇದೆಯಾ ಇದ್ರಲ್ಲೂ ರೂಲ್ಸ್ ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, ಅದೇ ಹೇಳಿದ್ರು ಅವರು. ದೇರ್ ಇಸ್ ನೋ ರೂಲ್ ಅಂತ ಅವ್ರು ಅದೇ ಹೇಳಿದ್ದಾರೆ. ಮ್ಯಾರಿಡ್ ಇದ್ದಿದ್ರೆ ಕೊಡಕ್ ಬರ್ತಾ ಇರಲಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ, ರೂಲ್ ಏನು ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಂತಲ್ಲ.
This is a settlement between the union and the military.
ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಇದು ಸೇಮ್ ರೆಸ್ಪಾಂಡೆಂಟಾ?
ಅಲ್ಲ, this is military KSRTC.
ಇದು HL ಇಲ್ಲ.
ಇದು HL.
KSRTC ಇದಕ್ಕೂ ಚೇಂಜ್. ಅದು ಸ್ಟ್ಯಾಚ್ಯೂಟ್.
ಅವ್ರು ಹೇಳಿದ್ದು ಅದು ಅದೇ ಹೇಳಿದ್ರು.
ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 18.
This yes,
ಅಲ್ಲ 18 ID Act settlement.
Yes, between the union.
Then bindings. ಇರ್ಲಿ, ಟೈಮ್ ಆಗೋದು. ಏನಂದ್ರೆ ನೋಡೋದು. 25th.
Please.
25th in fresh matters list. Yes.
Not 6.
Madam.
In this case, I appeal for the petitioner lordships. In this case, more the petitioner challenging the impugned order passed by the first respondent, wide annexure Q lordships, where more the first respondent more the denies the more the retrospective more the absorption and promotion to the petitioner lordships, on the ground that they have withdrawn the order dated more the 29/11/2007 order lordships. As per annexure F, in that order lordship, the first respondent more has given promotion to the more the juniors engineers, those who have observed as than more 28 and 2005 lordships. In fact, that order is not applicable to the petitioner lordships. But the similarly placed persons who lordship approach this honorable court. This honorable court has allowed the writ petition as per annexure V lordships. And not the
allow ಮಾಡಬಹುದಾ?
And not the in those writ petitions, not the first respondent has not considered the absorption or as on 28 and 2005 and promotion to the not the 2009 lordships. Annexure V lordships at page number 120. V.
Yes. What do we do? ಹೇಳಿ.
Your Lordship, page number 97, Your Lordship, the case which here they are relying, it is not applicable to the petitioner.
First, ಆಮೇಲೆ.
Because Your Lordship, after the absorption, Your Lordship, ಆದೇಶಿಸುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ದಿನಾಂಕ 19/1/2004 ವಿಲೀನಗೊಳಿಸಿ ಆದೇಶ ಹೊರಡಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. He was not absorbed, he was not continued, Your Lordship. Hence, the case is not applicable to this petitioner, Your Lordship.
18th preliminary hearing is next.
Fresh matter
Preliminary hearing.
Under it in preliminary hearing still ಇದೆ.
ಇದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇರಲಿ. Yes.
Fresh matter is to lordships.
Preliminary.
Please, Your Lordship.
Not 7. Reddy Sahukar.
For respondent.
My lords were pleased to hear this matter. Compromise petition.
Matter was compromised in the, my lord, before the Lok Adalat. After deleting, my lord, some of the defendants who are entitled.
Yes, my lords were pleased to hear. Earlier
January.
ಇಲ್ಲ ಮೊನ್ನೆ 4 ದಿನ ಹಿಂದೆ. They were required to make submission a previous compromise which entered by the wife of the first petitioner and mother of the.
Oh, this wife.
Yes, ma'am.
ಎಲ್ಲ ಆಗೋಗಿದೆ. Done and dusted.
No, my lord, it is not.
ಮಕ್ಕಳು ಬಂದು ಮಾಡಕ್ಕಾಗಲ್ಲ.
No, it is not like that, my lord. In the compromise which according to them is given.
This is that some name by Shobha.
Yes.
Yes. Did she ever in her lifetime challenge it?
No, my lord. What has been given to her is not even given. It is still in the name of the brother, and because of that reason only she has committed suicide. And criminal case is going on against the brother for forgery and everything. He has obtained the power of attorney, and he himself has given up the property, and he himself want to enter his name.
We'll see. List on interim order idೆಯಲ್ಲಿ.
Yes, my lord, it is there. Because he want to alienate all the properties, brother.
List on Thursday.
In the
Day after tomorrow.
Interim order may.
Fresh matters.
Fresh matters.
Interim order may kindly be.
Order subsisting will continue to the next date.
Please.
Note 9, Mr. Dariva.
Pertaining to selection of Anganwadi worker.
Anganwadi. ಯಾವ ವರ್ಷದಿದು?
Initially, she appointed as Anganwadi worker in the year 2013.
Who is the appointee?
She is appointed in the year 2013. That is challenged by the non-selected candidate before this honorable court. Annexure E,
ಏನಾಯ್ತು ಹೇಳಿ ಅದು?
my selection is cancelled, set aside. And direct the authority to accommodate the petitioner to the entire
ಈಗ ಅಕಾಮಿಡೇಟ್ ಮಾಡಿಲ್ವಾ?
ಅದು ಮಾಡಿಲ್ಲ. ಮುಂದೆ the resolution passed by the KDP committee. She appointed the one Kalikeri village. Now not issued any appointment order, not paid salary.
They have filed contempt also, your lordship, on that.
Salary ಕೊಡ್ತೀರಾ ಇಲ್ವಾ?
Not upon the salary, your lordship. As per the direction of this honorable court, in the writ petition 79897, your lordship, this honorable court has directed to appoint the petitioner in respect of ಅವ್ರಿಗಾಯ್ತು. The second, third one, any other vacant position ಇದ್ರೆ ಮಾತ್ರ ಕೊಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರು.
ಇಲ್ವಾ vacancy?
ಇನ್ನು no vacancy.
Vacancy ಇದೆ ಅಂತ resolution pass ಮಾಡಿ annexure G malad.
Yes. 18th fresh matters. Next.
Your lordship,
Interim order. Interim order.
They are
Yeah,
pressing for
interim.
contempt
Idre
also, your lordship. They are pressing for contempt.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
Learned counsel for the petition undertakes that he would not press the contempt petition so filed by him.
Please, your lordship.
Next.
110, K.S. Patil.
ಇಲ್ಲ ಅಂದ್ರೆ 2 weeks. 2 weeks.
Please, my lords.
ಏನ್ ಎಲೆಕ್ಷನ್ ಆಗಿದೆಯಾ?
ಆಗ್ಬಿಟ್ಟಿದೆ my lord election.
ಮತ್ತೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ.
ಅಲ್ಲ ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಂಡು ಹೇಳ್ತೀನಿ ಮತ್ತೆ.
ಎಲೆಕ್ಷನ್ ಆಗಿರುತ್ತೆ. ಆಗಿಲ್ಲ ಅಂದ್ರೆ ರಿವೈವ್ ಮಾಡಿ. ಎಸ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಆರ್ಡರ್ ಮಾಡಿರಿ. If there is anything before I sign, we'll revive it. Yes,
Please.
111, M.B. Hiremat.
Appear for petitioner, my lords. Appear for petitioner. The petitioner herein is challenging annexure H, my lords. The notice issued by the respondent.
Infructuous ಆಗಿದೆ.
No, my lords.
ಏನು ಹೇಳ್ತಿದ್ದಾರೆ ಮತ್ತೆ?
My lords, there is one more matter at serial number 136. It is in continuation of this. Let's
ಅದು
note.
infructuous ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಯಾವುದು
ಯಾವುದು ಆಗಿಲ್ವಾ?
In fact, my lords, pursuant to this, an inquiry was conducted and my lords, an order is passed. Pursuant to which my lords, revision was
ಇದ್ರಲ್ಲಿ
preferred.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇದ್ರಲ್ಲಿದೆ.
List on 25th.
In fresh matters, my lords.
I vote till then in the fresh matters.
136.
My lords, along with serial number 136.
Tag the petition along with 136. Yes.
Great.
113, Sajid Ahmad Gudwala, Girish Yadav.
My lord, the petitioner is seeking for quashing of the impugned order passed by the third respondent, my lords, which is at annexure E. The petitioner is the educational institution, my lords. The respondent number 4 to 9 are the ex-board of directors. My lords, the respondent number 4 to 9 submitted an application on 3/2/25 to the third respondent seeking enquiry under section 25 of the Act, my lords. On 6/2/25, the third respondent passed order to conduct detailed enquiry, my lords. That only on the application.
Will assign dates.
Please.
ಎಲ್ಲಿಗೆ ಬಂದ್ವಿ ಈಗ ನಾವು?
113.
113.
In this, I have filed vacating stay application.
Right, we'll
Last
take
occasion list. It may be taken in fresh matters.
List the matter on 18th in fresh matters list.
Interim order mechanic.
Interim order subsisting will continue to the next date of hearing. You want the page wise karnabadi.
Please.
All right. List after 2 weeks. Next.
Lordship.
Interim order, yeah?
Interim order, Lordship. First time, fresh matter.
Yes.
Page
25th. 150.
24, 122 to 126.
134, madam.
60 minutes.
The tax matter.
Kindly have this matter.
26.
Day after tomorrow.
Day after tomorrow is already again 200 matters. Wait. ಎಲ್ಲಿಗೆ? 24, 119 to 127. 119 to 127. 120 to 126.
123.
Very rate code. List on 9. ಯಾವ್ದಿದೆ ಮೇಡಮ್ ಕೊಡಿಲ್ಲ. ನಾನು ಹಾಕಿದ್ದೀನಿ ಪ್ರಿಲಿಮಿನರಿ ಮತ್ತೆ ಯಾವುದು ಹಾಕೋದು.
Not it is seeking for the mandamus issuance of the enrollment certificate. Status matters.
We'll take it on 12th. Enrollment certificate.
Enrollment certificate. Regarding Bar Council as collecting the excess amount.
So yesterday's matter, madam. You have not collected it. Infructuous. The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that the excess amount that is being collected by the bar council should not be collected in, as it runs counter to the judgment of the apex court in the case of Gaurav Kumar. The learned counsel Srimati Archana Magdam, appearing for the state bar council, submits that after the judgment of the apex court, in no case the judgment of the apex court or contempt hakadmela. After the contempt proceedings are initiated or an order passed by the apex court in the said contempt petition, in no case the bar council is collecting in excess of what is statutorily permitted. In the light of the said submission, the petition would not, in the light of said submission, the petition would not survive for any further consideration. Where idea? Ashatan? Further consideration ordered accordingly. Yes.
Page number 25, 129 to 133.
127 is regarding in charge allowance of the Karnataka University to hold the post of director. And also I heard the matter last week. Under Rule 32, my last 4 years I am working as in charge director.
Yeah, 12th.
120. Fresh matter.
12th.
127.
Nimsha. 12th, 13th, 14th, more, madam.
CA Shetter, Nimdila.
ಇಲ್ಲಿ ನಾನು ಕರಿತಾ ಇದ್ದೇನೆ ಸ್ವಲ್ಪ ಈ ಕಡೆ ನಾನು ಹೋದ್ಮೇಲೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಹತ್ರ ಮಾಡ್ತೀನಿ. ಈಗ 12th, 13th, 14th, all these matters you distribute, including B group. If there is any problem for anybody, you ask. Interim orders ಎಲ್ಲಿದೆ ಅದೆಲ್ಲ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. 12th, 13th and 14th. Entire remaining matters list. ಒಂದೇ ವಾರ ಒಂದೊಂದನ್ನೇ ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
196 mandamus is consider representative.
ಏನಾದ್ರೂ ಇರ್ಲಿ 12th, 13th, 14th, because there are less matters that they will.
Can it be little earlier?
Covered judgment. 134 covered by judgment.
ಕವರ್ಡ್ ಇದ್ರು ಪರವಾಗಿಲ್ಲ ಅವತ್ತೇ ಬರ.
Lord sir. 133.
ಯಾವ್ದು ಒಂದು ವಾರ ಕಂಪ್ಯಾಷನ್ ಹೋದ್ರೆ ಏನಾಗಲ್ಲ.
Lord sir, serial number 2.
ಎಲ್ಲ ವಿಲ್ ಕಮ್ ಇನ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಫ್ರೆಶ್ ಬೇಡ.
196
ಮೇಡಂ ಎಲ್ಲ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್.
Lord sir,
preliminary hearing.
Lord, 215 to 218 election matters. Lord sir, declaration of citizens.
215 to
18.
Yeah, respond. Disposed. ಯಾವುದು ಜಸ್ಟ್ ಶ್ಯಾಮಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್.
Serial number.
ಬನ್ನಿ ಸರ್ ಸ್ವಲ್ಪ ಮುಂದೆ.
Serial number 139.
My lord,
Dispose ಮಾಡ್ಬೋದಾ ಅದು?
My lord, 215 is concerned, my lord. I filed the statement of objection, my lord, by producing the document to show that the rule 13D, rule 2A. is
ಹಾಗಾದ್ರೆ
complied.
ಬೇಡ. Then we'll not close it.
Serial number 116, my lord.
Maybe you have the covered. 173? No, we'll see. We'll post it on, ಇನ್ನೊಂದು ಯಾವತ್ತು ಹಾಕಿದ್ವಿ ನಾವು? 24th, yes.
Serial number
Number
116, my
139.
lord. Covered by judgment, my lord. My
Eight.
writ of mandamus.
ಬರಲ್ಲ madam.
Petitioner is seeking EMD
One
FST
more
amount,
week
my lord.
time, please wait. 18th, 12th, 13th, 14th. We'll post on all the remaining cases on those 3 days.
Your Lordship,
Serial-
serial number 162, 63, it may be taken
Otherwise-
upon 25th, Your Lordship.
No, sir. ಅವತ್ತು ಹೇಳಿ. Again, going on passing orders
My
cannot
lord,
be.
serial number 139. Notice ಆಗಿಲ್ಲ, please kind in the fresh matters.
Notice ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ my lord.
GS served ಅಂತ ಇದೆ. ಯಾವ notice?
Notice issue ಆಗಿಲ್ಲ my lords.
ಯಾವ್ದು ಪಾಂಡಿಚೇರಿನ ಇದು?
Tax matters.
Sorry, transfer
Trans-
of ownership of vehicle. Then wait. ಅದು ಅವತ್ತೇ.
No, 196 not.
Notice has not been issued to respond serial number 120. Notice to respond number 3 has not been issued. May be taken up on Friday.
120, yeah.
Yes. That was deferred for some time.
No, it will come on the same day, yes.
My lord, on submission, serial number 154, my lord. My lord, it may be listed on preliminary hearing, my lord, on 10th, my lord.
ಎಲ್ಲ preliminary hearing, all matters will come into.
My lord, serial number 143, my lords, DRT, my lords, 143, my lords.
It will come on preliminary hearing. Preliminary hearing only it will.
Lords, 143.
ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು ಹೇಳಿ? 24th ಅದು, yes.
My lord, serial number 143, my lords, the Salakot was granted interim order to deposit 10 lakhs, my lords. I am ready to deposit, my lords. They are not accepting the DD, my lords. The bank, my lords.
Bank ಯಾರು?
ಸಚಿನ್ ಅಲ್ಲಿ ಹೋಗಿ ಕೇಳಿದ್ರೆ ನೀವು ಕೋರ್ಟಲ್ಲಿ ಅಪ್ರೋಚ್ ಆಗಿದ್ರೆ ಅಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ಕೊಡೋ ಅಂತ ಹೇಳ್ತಾರೆ.
ಲಿಸ್ಟ್ ನಾಳೆ ಆಗುತ್ತೆ. ನಾಳೆ ಆಗಲ್ಲ. ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಅದು ಮಾತ್ರ ತಗೊಳ್ಳಿ. ಮನೇನಾ?
ಸಾರಿ,
ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ?
ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ, ಸೈಟ್ಸ್
ಸೈಟ್ಸ್ ಬರಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ ಡಿಡಿ ಇಲ್ಲೇ ಕೊಟ್ರೆ ತಗೊಂತೀನಿ ಸರ್.
ಡಿಡಿ ಇದ್ರೆ ತಗೊಂತೀರಾ?
ಅಲ್ಲ ಇಲ್ಲೇ ಕೊಟ್ರೆ ಬ್ಯಾಂಕಿಗೆ ಬಂದೇ ಇದೆ ಸರ್ ಅವ್ರು.
ಬ್ಯಾಂಕಿಗೆ ಹೋಗಿ ಕೊಡಿ. I take it day after tomorrow in fresh matters list. Go to the bank and give it.
Please. Your Lordship, passed over matter.
Lord, serial number 146, my lord. If it may be taken up on the 11th, my lord.
Wait, sir. Dictation ಕೊಡ್ಬೇಕಾಯ್ತು. ಏನದು password?
It's not called. Serial number 44.
What is that?
ಎಷ್ಟಿದ್ರೆ ನಮಗೆ
KGP appointment.
ಇಲ್ಲ, I am representing the state in that matter, my lord.
ಕೊಡಿ. Wait.
It's yesterday's matter, my lord.
ಆಯ್ತು ಹೇಳಿ.
ಅಲ್ಲ ಅವರು ಇವತ್ತು ಇಟ್ಕೊಂತಾನಂತೆ.
ನಿಮ್ದು ಆಗೋಗಿದ್ಯಾ?
My lord, I have submitted one judgment, Lordship. And
Yes,
rule 5 is clear.
Vijay Kumar.
Please, my lords, may I draw my lord's kind attention? I may need 10 minutes, my lords permit me.
ಆಯ್ತು ತೊಂದ್ರೆ ಇಲ್ಲ ಹೇಳಿ.
Please. Please, my lords, in this case, the petitioner has challenged the appointment is removed from office in the appointment of respondent number 3, word annexure E, my lords. May I draw my lord's kind attention to the order, my lords? ಅದರಲ್ಲಿ rule 26(2) ಅಂತ ಹೇಳಿದ್ದಾರೆ. That is what the petitioner has founded his case upon. May I draw my lord's kind attention to the rules, my lords? Rules ಅಲ್ಲಿ I'll be able to demonstrate. Rules, the appointment is not under rule 26.
Rule 5, my lords.
Wait, sir. Mostly.
Rule 5, my lords. May I draw my lord's kind attention to rule 5? Now that my learned friend wants me to read it.
Rule 5.
Rule 5, my lords. Appointment of law officers. No person shall be eligible for appointment of law officer. First is the different categories of law officer. Clause 2, may I draw my lord's kind attention. Sub-rule 2 of rule 5.
Pleasure of the government, sir.
Please, my lords. My lord, that rule clearly demonstrates that the power to appoint and the nature of appointment is both.
Sir, I am with you on that, not a problem at all. One day you appoint him, next day you appoint another. That is what this court is not accepting.
Please, my lord, may I draw my lord's kind attention?
ಕಂಟಿನ್ಯೂ.
Please.
ಈಗ ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
Annexure C.
Annexure
My
C.
appointment.
Annexure C.
Yes, Girish, ಹೇಳಿ.
Yes, my lord. I have relied upon, my lord, another
Judgment ಬಿಡಿ
Yes,
ಸರ್,
yes.
ನೀವು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೊಡಿ, ಇವ್ರದ್ದಾಗಿತ್ತಾ?
Annexure C.
Hi, next day, my lord, I am appointed.
He has been appointed by an appointment order.
Yes, yes.
By oversight he was, my lord, by oversight. he was.
Oversight. What do you mean
It's
oversight?
it's not an appointment under Rule 26. That is my case. Made wrong lord's kind attention to Rule 26.
This is an,
Appointment under what?
Please, it is an appointment under Rule 28.
28.
Please. My lord, this is the position to which they have been appointed is additional district government pleaders and assistant government pleaders. That is the provision, my lords.
All right.
By mistake, it has been written as Rule
Where is your
26 clause 2.
appointment?
Annexure C, page number 21,
21.
dated 28/10/2025. So and so ಇವರನ್ನು ಬೆಳಗಾವಿ ಜಿಲ್ಲೆಯ 11ನೇ ಹೆಚ್ಚುವರಿ so and so ಆಗಿ ಪ್ರಭಾರವನ್ನು ವಹಿಸಿಕೊಳ್ಳುವ ದಿನಾಂಕದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ 3 ವರ್ಷದ ಅವಧಿಯವರೆಗೆ ಮುಂದಿನ ಆದೇಶವರೆಗೆ ಇವೆರಡರಲ್ಲಿ ಯಾವುದು ಮೊದಲು ಅಲ್ಲಿಯವರೆಗೆ ನೇಮಿಸಲಾಗಿದೆ.
Rule 26(2) ಅಡಿಯಲ್ಲಿ
Terms of Rule 26(2).
That is what the order reads, my lords. The appointment is not under Rule 26(2).
Yes, it is at page 34, annexure E.
That is also mentioned same rule.
Yeah, because that procedure has not been followed. It is not an appointment under Rule 26 at all, because that Rule 26 pertains to appointment of district government pleaders. This is not a position for district government pleaders. This is a appointment to additional district government pleaders, which is under Rule 28.
ಇಬ್ರದ್ದು ತಪ್ಪು. Both appointments should go there.
Allala, it's mere wrong mention of the statutory provision, my lords, as my lords are aware. Apex courts and my lords have also held that, my
Mere
lord.
mentioning of a wrong provision will not take away the tenor of the
Please,
order.
please.
But
As long as the power to appoint can be traced to any of the provisions in the rules, it is very much there. It is admitted that under Rule 5(2) I have the power. I have made the appointment. As my lords rightly pointed out, only one day appointment. Why was he removed? That's my humble submission, my lords. Under Rule 28, appointments, there is no procedure. There is only anyone can apply. There is no calling for, there is no invitation of applications there. There is no procedure. There is no suitability. There is no merit assessment. Nothing, my lords. The state, my lords, has the liberty to appoint its council. May I read Rule 28, my lords? The difference between
court will never come in the way of your liberty unless
please.
it is arbitrary. Arbitrary ಯಾಕೆಂದ್ರೆ ಒಂದಿನ ಇವ್ರಿಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೊಟ್ಟು ನೆಕ್ಸ್ಟ್ ಡೇ ಅವ್ರಿಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್
ಅಲ್ಲ,
ಕೊಟ್ಟು
by oversight ಆಗಿದೆ ಅದು.
What is the state doing, sir?
I bowed down. I bowed down, my lords. But it is by oversight. He was never meant to be appointed to that position. My lords, what is the difficulty was, my lords? A new court was opened in Athani. An additional position was created. There was an in-charge person who was serving there. What happened, my lord? We needed a full-time law officer to represent the state. Because of that, my lords, we had to immediately make appoint somebody. So in the process, my lords, one of the applications which were pending before us was the petitioner's appointment. So the appointment order was issued. Later we realized that the respondent number 3 is more suitable. So we have appointed him and removed him. My lords, what the rule says, may draw my lords' kind attention to Rule 5 and 5(6) with regard to removal, please. Rule 5(2), as my lord rightly pointed out, it pertains to power of appointment. 5(5), sub-rule 5 and sub-rule 6 pertains to removal, my lords. Sub-rule 5 refers to
removal order ಎಲ್ಲಿದೆ? ರಿಮೂವಲ್ ಮಾಡಿದಾರಾ?
ಅಲ್ಲ, ಸ್ವಾಮಿ, annexure
that's what is challenged.
Annexure A, they have withdrawn my appointment.
Withdrawn his appointment and
subsequently they have appointed.
I have cancelled his appointment.
The entire things have taken place within one day. If my lords have.
What?
Yes.
Wait.
So far as my lord,
With you, wait.
Please.
so far as my appointment is concerned, my lord, as my learned senior submitted, that this is a newly established court. My lord, there was consideration for appointment of ADGP. My lord, I was being considered for the purpose of appointment. In the meanwhile, my lord, he
perhaps my lord, through political influence got appointed, my lord. The next day, my lord.
ಅದಕ್ಕೆ consideration ಅಂದ್ರಲ್ಲ,
Yes.
what was that consideration happened in your?
No, the district judge, my lord, had addressed a letter.
Where is that?
Yes, it is, my lord, produced along with, my lord, the writ petition, page number 19, annexure B.
ಇದಕ್ಕೆ ಯಾರನ್ನ
No, no, he had not recommended anybody. He said that since the court is established, there is a requirement of appointment. Anta. That is the consideration which was going on, and I was being considered as the candidate for appointment for this post.
How do you demonstrate that?
No, that is more not, that cannot be something which is not found in papers, because in between more he.
ಫೋನ್ ಅಲ್ಲಿ ಮಾತಾಡ್ಕೊಂತಾರೆ.
No, these are all more things more that what he, upon coming to know that more I was being considered more, got an appointment. Then more as submitted by my learned senior more, that since that was not the this thing, the more suitable person has been appointed. That's why more my.
Where is the assessment of suitability and by whom?
My lords,
if that were an appointment under 26(2), more those all things would be considered. If it is a 28 appointment, then more that can't be. That's why more my reliance is on the judgment of my lords rendered.
Pleasure.
Yes, not only that, more that the division bench before which the my lord's judgment was taken, it goes to yes, it goes one step further and says that more the scope of judicial review in these matters is extremely low by considering the judgment. My lords have considered.
True, sir. One ದಿವಸದಲ್ಲಿ ಮಾಡಿದ್ರೆ
maybe more that
what maybe
on no
we will be giving the state everything whatever they do.
No, that argument can be more only for the purpose of saying that more it would be stigmatic or whatever for him if
there is no stigma here.
No, of course, that's the reason what I am submitting. More that would not cast anything on him. That contention that it is only one day would not be argued in these cases.
Yes,
Lord.
And my lord, what the petitioner in fact is entitled
He has
to
not
is,
at all made his application. He has not, yes, for consideration of his candidature.
Where is your application?
I have produced annexure A.
Annexure. After that,
upon my application, the sanction has been created, the sanction has been given.
No, this is factually
on my
incorrect,
application. They have not at all made any applications, lordship. Now they have submitted that they have also filed application. Let them, my lord, produce before this honorable court their application.
my lord, regardless, my lord.
And the proceedings, my lord, taken place in the government.
The learned counsel Girish Edward to place on record the application submitted by which respondent are you?
Respondent number 3.
Respondent number 3, and the learned and the state shall place on record the records which led to appointment of the petitioner at the first petitioner on
28/10/2025
and which led to the appointment of the third respondent within 24 hours, i.e. on 29/10/2025. The record shall be placed before the court on the next date, i.e. day after tomorrow. List the matter day after tomorrow in the fresh matters.
Please.
My lords can permission.
Of charge cities, etc., I may permitted to place on record the memo. Subsequent to passing of the impugned order, I have taken charge cities is also handed over. I have appeared in number of cases before the Mono district judge.
appear agidare.
Now
Or one appear agidare. He did not
document.
take charge. He did not take charge. Neither CTC was handed over by the in charge.
Lord, the entire thing is taken place by way of
Now, I have appeared in
influence.
7 cases.
By way of
since then.
influence, my lord, this word, my lord, I cannot.
You have lost all the 7 cases.
No. I have filed memo of appearances. So that may be more taken on record, more my memo along with documents.
Learned counsel files a memo, same is taken on record. Our own copy kodi.
Yes.
We'll take it on Thursday.
Please.
Matters.
With my lords kind permission, may I request my lords that it may be taken up on Monday, my lords.
Monday beda. Thursday or Friday, whichever day you want.
Friday, my lords, please.
All right. Friday fresh matters list.
Please.
It should be over this week.
Please. Much obliged.
Lordships kindly. One matter,
On
serial
submission,
number
if I-
135. My request, 6th or 7th, Lordship.
ಏನು ಎಲ್ಲ ಚೇಂಜ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. 12ಕ್ಕೆ ಹಾಕಿದೆ. 12, 13, 14 3 ದಿನ ಎಲ್ಲ ಹಾಕಿದೆ. ಮತ್ತೆ ಚೇಂಜ್ ಮಾಡಬೇಕು.
102.
7th ಈ ವಾರ ಪೂರ್ತಿ 150 ಮ್ಯಾಟರ್ಸ್ ಎವ್ರಿ ಡೇ. That will become difficult.
102, my lords, please to.
ಹೇಳಿದ್ನಲ್ಲ, ನೀವು ಕೋಆಪರೇಟ್ ಮಾಡಿ ಎಲ್ಲ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ ಕೊಟ್ಬಿಟ್ರದಂದ್ರೆ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತಾ ಹೋಗ್ತೀರಿ. ನಾನೇ ಓದ್ಕೊಂಡ್ಬರ್ಬೇಕು, ನಾನೇ ಮಾಡ್ಬೇಕು ಅಂತಂದ್ರೆ ಕಷ್ಟ.
Your Lordship, may I make a motion?
From all of you, definitely will dispose many cases.
We'll cooperate.
ಎಲ್ಲ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes.
Finish it off.
Please.
Fresh matter. ಇದೆ.
102, my lord, sir, please to post it on 18th. Instead of 18th, may I request on 17th, my lord, sir, I have informed my friend also. Monday.
ಯಾವ್ದು 102?
That GSTR, my lord, input tax credit 3B and
All right.
9.
That's not a
If it could be in fresh matters, my lord, very short point we are urging.
We'll take it on.
It is in preliminary hearing, my lord, same stage. Yes.
Kind leave, my lord.
Your Lordship, CM 162 and 163, Your Lordship. It may be taken on 25th, Your Lordship.
ಅದಲ್ಲದೆ ಬೇರೆ ಯಾವ್ದು ಬೇಕು ಅಂದ್ರೆ ಕೊಟ್ಬಿಡಿ, ಅದಕ್ಕೆ ಮುಂಚೆ ಕೊಡ್ಬೇಡಿ ಯಾವ್ದು.
But serial number 141, yesterday senior advocate has moved it. It is listed today, Vivek Subba Reddy. But online ದಲ್ಲಿ ಇಲ್ಲ. Online ದಲ್ಲಿ ಇದ್ರು ಈಗಿಲ್ಲ.
ಲೈನ್ ಅಲ್ಲಿ ಇದಾರಾ?
ಇಲ್ಲ ಈಗಿಲ್ಲ. May kindly have it tomorrow for these reasons, my lord. Counting of vote is stalled. Administrator is appointed.
ನಾಳೆ ಆಗಲ್ಲ, ನಾಡಿದ್ದ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Please.
ಅದೊಂದು ಎಲೆಕ್ಷನ್ ಮಾತ್ರ.
Please.
My lord, serial number 146, my lord. If it may be, please be taken up on
12-13.
Oblige.
Page wise karpidi.
Madam, quote of sir, madam.
Sir, ಹೇಳಿ.
196 ಅಮ್ಮ.
196.
ಅದು ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಜಸ್ಟ್ ಫಾರ್ ಮ್ಯಾಂಡಮಸ್.
ಡೇಟ್ ಯಾವಾಗ ಹಾಕ್ಬೇಕು ಸರ್?
ಅದು 12th or 13th. 12th or 13th. ಫ್ರೆಶ್ 12th or 13th ಹಾಕೊಡಿ ಅಮ್ಮ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ.
12th ಹಾಕಿರ್ತೀನಿ ಸರ್.
ಪ್ಲೀಸ್ ಅಮ್ಮ.
Madam, CM 162, 163.
162 and 163. ಹೇಳಿ ಸರ್.
25th ಆಗ್ತೀರಾ ಮೇಡಮ್?
Yes sir, 25th.
Okay, thank you.
Madam, ಇದು 146 21st ಆಗ್ಬೋದಾ?
146.
21st ಆಗ್ಬೋದಾ?
21st ಸರ್? ಓಕೆ ಸರ್.
Thank you.